Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-1092. American Whitewater petitioner versus Federal Energy Regulatory Commission. Ms. Nicholson for the petitioner, Mr. Shaner for the respondent.
Good morning, Ms. Nicholson. Let's start when you're ready.
Good morning, and may it please the court. My name is Haley Nicholson, and I represent the petitioner, American Whitewater. American Whitewater followed the requirements in Rule 214 to file for late intervention in FERC's surrender proceedings for the Niangua hydroelectric project in Missouri. At first, there was nothing but green flags in response to American Whitewater's motion. It was an early stage of the proceedings before any final orders had been issued. No party opposed American Whitewater's intervention. And 2 months after American Whitewater's motion, FERC issued the Environmental Assessment, or EA, for the proposed surrender, which listed American Whitewater in a table as an intervener alongside the other parties who had already intervened in the proceedings. American Whitewater then filed timely comments on the EA advocating for surrender with dam removal. It was only then that those initially green flags suddenly became red. Just 2 weeks after these comments were filed, FERC denied American Whitewater's motion.
Is this case moot because this commission issued its order approving the license surrender without taking down the dam in December? And so I'm unclear as to what relief this court could give you at this point, even if you were able to intervene.
This case is not moot, Your Honor, for several reasons. The first is this court's decision in Public Service Commission of State of New York versus Federal Power Commission, where in that case, they were dealing with a denial of intervention from a Federal Power Commission proceedings. And they held that once a petition for review of that denial was properly filed, quote, it cannot be mooted by any action of the Federal Commission.
But you couldn't properly file I know you filed what probably is a protective petition for review, but you have to be a party to the proceeding to file petition for review. Is your theory that if you win here and then we remand just for FERC to apply its test again, we can't dictate that they let you intervene? That's not the type of error you've identified. And if they then were to decide to let you intervene, that would somehow ratify a petition that was filed when you were not a party?
In this case, Your Honor, the Federal Power Act, there's a section in 16 U.S.C. 825 LB that allows for FERC to modify its rehearing request orders. So in this case, even after the petition for review was filed in that related case on the surrender order, FERC still has the ability to modify its findings if it does find that on remand that American Whitewater is properly a party to these proceedings.
And FERC's given no indication that it has any interest in modifying its decision. I mean, instead, we consider your environmental assessment comments, even without intervention, and you haven't, you're saying that they didn't. And so I'm still unclear as to, I mean, it seems rather speculative that they would both have, we'd have to speculate both that they would grant you intervention and that then they would, a year after the fact, decide to modify. But even if they modified it, you would only get to seek review of the modified decision, not the original decision to surrender the license.
That's correct, Your Honor. And in this case, we're dealing with a procedural injury, so redressability looks a little bit different. It's the mere possibility that the order could be changed on remand that matters.
Well, so it's, well, I'm not sure that that works here when, you know, processes are going forward. And I mean, we would have to both remand your intervention decision and direct them to reopen their underlying proceeding, right? Normally those procedural injuries come up at the same time. There's a challenge to the merits in the same case. And so then we can also send the merits back and say, let us know if anything changes. But we don't have a petition here. Nobody has petitioned for review. No party has petitioned for review of the decision to surrender the license.
Beyond American Whitewater, Your Honor.
You're not, I said no party. You're not a party. And even if you become a party later, that'll be way after the time for filing a petition for review from the surrender decision has run. Your theory is that it resets the clock?
No, Your Honor. It's the 16 U.S.C. 825 LB that will allow FERC to modify its decision on American Whitewater's rehearing request, which included merits discussions. It wasn't about intervention. So FERC could modify its discussion even after the petition for review was filed, and this court would still have jurisdiction to hear it. And that case that I cited, the Public Service Commission, they were dealing with a remarkably similar situation in which there was a denial of intervention and then a final order, and the court still held that it could not be mooted by that final order of the Federal Commission. And Public Service Commission has not been overruled by this court and should still be followed.
What's the site?
The site for that case, Your Honor, is 284 F2D 200, and that's DC Circuit 1960.
So I just want to make sure I understood what you just said, because I thought that you had already submitted any substantive comments that you had about the decision. And the only issue is really whether you're an intervener or not, and whether your motion to intervene should have been granted. And the only stakes for that is then you would have the right to appeal this decision. Because in terms of just submitting your thoughts and comments, I think that happened and the commission said it would consider, and I assume that it did because it said it would consider those substantive comments. So I thought the only issue now is this motion to intervene and whether or not you could therefore appeal. Am I correct?
That's the primary issue, Your Honor, and it's important that that's the issue because FERC changed its rationale for the approval of the surrender without dam removal in between the EA and the surrender order. It dropped its rationale for environmental justice, and because that environmental justice rationale wasn't in the EA, no party had the ability to comment on it. And American Whitewater's request for rehearing of the surrender order discusses the merits of that approach for the first time. So it's not just that the consideration of the EA comments removes any possible remedy that American Whitewater could seek in this case.
We had a case called Narragansett Indian Tribe Historical Office versus FERC, where we held that once there's no more proceeding before the agency, there's just no ongoing proceeding in which you could intervene. Intervention, even a wrongful denial of intervention is moot. And given that nobody else has sought review, I don't know what proceeding you're going to intervene in.
That case,
live proceeding.
yes, Your Honor, technically the surrender proceedings are still live because the surrender order is not yet effective. It's only effective once Show Me completes the operations for the decommissioning activities.
But that is some paperwork and inbox checking and reports from so-and-so and so-and-so. And, if they didn't do that, you could challenge their failure to get, the engineer report saying they've decommissioned the plant. But that's not what you want to challenge.
No, Your Honor, but
Is there any ongoing proceeding about the dam surrender, the surrender of the license and the surrender of the license without taking down the dam itself?
If this court were to grant American Whitewater's request, American Whitewater would still be able to have that judicial review of the final surrender order. American Whitewater is not seeking to reopen the proceedings in any way. And this court found that after a denial of intervention petition for review is properly filed in that Public Service Commission case.
And no one else in Public Service Commission had filed a petition for review?
Not that I'm aware of, Your Honor. And in that case, it was still that they sought judicial review after a final order was issued. And this court still.
I'm asking if there was, in that case, was there still a pending proceeding either in this court, on petition for review or before the agency in which you could have intervened. I just don't know what the proceeding is as opposed to forms coming in from dam operators.
In that particular case, Your Honor, the proceeding was still before the DC Circuit because the
That's
petition,
very different.
not necessarily, Your
There's no
Honor.
challenge to the merits before us by a party.
American Whitewater did seek judicial review of the final
I know,
surrender.
but I mean, it's the statute requires a petition for review be by a party. That's just statutory. With jurisdictional, we don't have any choice in that matter. And so in the Public Service Commission case, were there petitions for review pending before this court from people who were already parties?
No, Your Honor. In that case, they were dealing with intervention petitions in a case very similar to this one. And there, like American Whitewater, the petitioners filed a petition for review of the intervention denial, as well as a petition for review of the final order. And this court in that case still found that this court could hear the intervention denial and that the case would not be mooted by any action of the commission. And the court provided reasoning there in saying that a contrary holding of mooting a case after a final order had been issued, quote, would create too ready a means by which the administrative agencies could thwart the power of a reviewing court to pass upon the validity of orders denying intervention. Such applicants for intervention have a right to judicial review of such denials, unquote. But even if this court finds that American Whitewater's petition could be mooted by an action of the federal commission, the capable of repetition yet evading review exception to the mootness doctrine still applies. And that's because the challenged action here was too short to be fully litigated. The surrender order came down the day before American Whitewater's reply brief was due in this case. And given the long-standing inconsistent practice of FERC on Rule 214's application to late intervention, it's reasonably likely that American Whitewater would be subject to the same action again. And if this court finds that the mootness issue is relevant, it has not been briefed by either party, and American Whitewater would welcome the opportunity to brief.
Why didn't you file a 28J letter to inform the court of these developments and to make these arguments?
Are the developments that you're talking about, Your Honor, the surrender order or different developments?
Well, the surrender order, and then you've already filed a petition for review of the surrender order. All that seems very relevant to what we're talking about here today. And you never brought it to our attention. I think some law clerks found this information. It's difficult for us. Now you're saying it's not briefed, but part of that is your fault, is it not?
No, Your Honor. American Whitewater noted that the surrender order had been issued in its reply brief because it had been issued the day before the reply brief was due. And we noted in the reply brief that if this was an issue by this court, that it should be briefed further. But in that particular instance, we noted, it was in a footnote, that there was nothing about the issuance of the surrender order that affects the particular validity of this case before this court. And that's consistent with the Public Service Commission case that I was citing.
I've distracted you from making your actual intervention argument. You want to go ahead for a few minutes?
Thank you, Your Honor. In this case, FERC's decision should be rejected for several reasons. The first is that its interpretation is contrary to the text of the regulation, regulatory history, and binding precedent. The most important issue here is this court's decision in Swanson Mining Corp versus FERC, where this court held that the determination of facts of why a proposed intervener was unable to file a timely petition for intervention, or D1I, quote, is not the sole component of good cause under FERC's rules, end quote. This is directly contrary to FERC's interpretation in this case, and that court's decision should be followed by this court. But even if this court agrees with FERC's interpretation of the regulatory language, this court should still reject FERC's decision as arbitrary and capricious. This court's precedent makes clear that even in cases where agencies have broad authority and discretion to act on requests before them, they still must apply decision-making criteria in a consistent manner. In this court's decision in Airmark Corp versus FAA,
I just want to make sure I've got this right. You were 9 months late to file your motion, and your only excuse was that you only recently became aware of this proceeding and you were unaware that the deadline had passed. And you think it was arbitrary and capricious for the agency to deny your petition to intervene.
That's correct, Your Honor. FERC has not stated any principle that after a set number of months, such as 9 months, means that a denial of a late intervention is warranted. And in this case, FERC is inconsistent.
Well, you don't dispute that that's a relevant factor. How late were you? And I don't see any authority where the lateness was this late, 9 months, where they granted a motion to intervene.
A relevant case, Your Honor, where it has been past this level of time is cited in our reply brief, and that's the Transcontinental Gas Pipeline case. And in that case, FERC granted late intervention to 2 governmental agencies and 1 non-governmental organization over a year past the intervention deadline, even in a case where they didn't find good cause. And
But this is a discretionary call and it's fact-bound, et cetera. And I just think it's difficult for you to say that it's arbitrary and capricious for them to deny when the only good cause that you gave was that you didn't know about it.
The asserted good cause by American Whitewater, Your Honor, is not D1I administrative oversight. American Whitewater's asserted good cause is based on an evaluation of all of Rule 214D's factors. So the fact that there was no evidence of prejudice or disruption, and that American Whitewater's interests would not be adequately represented by parties in the proceeding. And the D1I good cause is not the same thing as B3 good cause. And so this instance, the mere fact that there was administrative oversight does not doom American Whitewater's motion. And as this court held in Airmark Corp versus FAA, discretion to agency expertise is not an excuse for arbitrary and capricious behavior. The court held there that, quote, deference to agency authority or expertise, however, is not a license to treat like cases differently, end quote. And that's precisely what FERC is.
Made length of delay just by itself a factor? Or is it only when it intertwines with prejudice, disruption, those types of things?
To my knowledge, Your Honor, FERC has not stated a specific principle on a certain number of months should be the timeline in which a denial should
Is
occur.
that one of the D factors?
No, Your Honor. And you're correct.
Apart from, obviously, sometimes length of delay can affect prejudice or disruption.
That's correct, Your Honor. And Your Honor is correct that to the extent that timing is considered, it really goes to the prejudice and disruption factors, which there was no evidence of in this particular case. And FERC has on many occasions looked at a lack of prejudice and disruption to find good cause to grant late intervention. And so the fact that FERC has departed from its precedent, finding that an evaluation of the Rule 214D factors is B3 good cause, is arbitrary and capricious in this case. And finally, I just want to note that the danger of arbitrariness in this case is heightened. As this court found in Network IP LLC versus FCC, where regulation standards are, quote, opaque, the danger of arbitrariness or worse is increased. Complainants the agency likes can be excused, while difficult defendants can find themselves drawing the short straw, end quote. Where FERC is so inconsistent in its precedent of applying good cause, administrative oversight, and the Rule 214D factors, there's nothing stopping FERC from applying Rule 214 in a way to keep out flaws from its decision in the record and to prevent interested parties from seeking judicial review of flawed decision. For the foregoing reasons, American Whitewater respect.
Do you have any questions? Please go ahead and sum up and then we'll give some rebuttal time.
For the foregoing reasons, American Whitewater respectfully requests that this court grant its petition to vacate FERC's intervention orders. Thank you.
Counsel.
May it please the court, Houston Shaner for Federal Energy Regulatory Commission. I'd like to begin with the threshold question of mootness that the panel is interested in. I fully agree that at this point, the merits order in this case is a final and non-appealable order that could only be subject to an improper collateral attack. As Judge Millett pointed out, the merits proceedings have largely finished. I would like to add a gloss on that. My friend is correct that there are post-order submissions from the current licensee to a FERC field office, and then the field office will issue approval of the surrender of the license, at which point the commission will lose jurisdiction over the project entirely and jurisdiction will revert to the state. I understand that my friends, in candor, I understand my friends have moved for an administrative stay at the commission level. I'm not aware of a commission action on that right now. So as I understand it, the surrender order is still entirely in effect. And because they were not,
actually, one thing I'm really confused about, Because the surrender order says it will not become effective until you get this Commission of Dam Safety letter saying, until the commission gets this letter from the Division of Dam Safety saying the plant itself.
You have properly, you've complied with the conditions of the ordering paragraph, and at that point,
Project facilities are decommissioned.
and at that point, the license surrender becomes
What does
effective.
effective mean?
The commission loses jurisdiction over the project. The license has been surrendered.
So it
As I
just means
understand
you lose jurisdiction to, so is that sort of the last report? Because it seems like there's a number of reports or things that come in.
There are various submissions, both to the,
This has to be the last one then if you're losing.
the letter from the field office is the last sort of statement that would terminate the commission's jurisdiction over the dam,
And
as I understand
do
things.
you know where we are in that process? Is that the only thing that's the commission is now waiting for? Have all the other paperwork been filed?
My apologies, I don't know that exactly in terms of the submission, but I would understand the letter from the field office as being the critical event here that would terminate jurisdiction entirely.
Let's just assume hypothetically that we found that FERC, this is not only made an improper decision here, but imagine we actually said you improperly denied intervention. So I know
Correct.
I know there's steps there normally, but just for this hypothetical, I'm trying to understand how this all works. If we had decided you were improperly denied intervention, they of course should have been allowed to intervene and remand for action, and consistent with that, what would the commission do with the fact that it had a proceeding go forward without somebody who was supposed to be a party?
To be frank with Your Honor, I'm not sure that we've seen an example of this, in part because the court, as I understand it, has never
Well, she cited
overturned.
the Public Service Commission case.
That is true. I believe.
Because it's not exactly FERC, it's FERC,
Right.
it's another agency,
Right.
but
If I think that was a Federal Power Act case before the commission, and frankly, before a lot of modern standing ripeness and justiciability doctrines generally. So I'm not sure how truly viable it is in this case. I think Narragansett is probably a much better factual analog here, where the facts really have changed. And the key facts here are that the order issued, there were 60 days for a party to the
we have
proceedings.
both cases on the books and I'm not sure what to do. I mean, I haven't found, I think we've cited Public Service Commission relatively recently in the beyond nuclear decision. So I don't think this panel is at liberty to brush it off.
That's true. It is still, as I understand,
So
it, good
assuming
case law,
that's
but
FERC sitting there and it's got this precedent.
I would think also that the statements on sort of what would happen in terms of future commission proceedings are at best dicta, because the procedural rules might have changed, and it doesn't lay out a clear
Have they
path.
changed?
Well, if I
I'm not
believe
sure. I
the
mean, just
commission.
that you have the authority to reopen and that's what was discussed there. So you'll have to reopen.
We do have a reopening rule, but as Your Honor noted, all of the substance that petitioner would raise in the merits proceeding, they've already done that. The commission's already reviewed it, so there's no,
I know, but we
There's no
don't get to
realistic
review
reason.
it. I think they would like,
I think that
they
is,
disagree with that decision that you made and they would like review
think
of that.
that is true, because the court only has the procedural order in front of it right now. There is no relief that it can direct towards the
I mean, there is in
surrender
this
order.
court a pending petition for review on the merits.
Well, there is a file petition for review. Whether or not that's a proper petition for review is certainly up for debate. But they have
Well,
certainly
I mean,
filed
it's
that.
just asking the same question again about how something like this gets remedied.
Well, I think that,
I mean,
I think
in
everyone
theory, an
understands
agency-
the statute requires a proper party to file a petition for review within 60 days.
Mhm.
That didn't happen
Well, my
here.
hypothetical was, assume we say, wow, they should have been a proper party from the beginning.
Well, I think the way that would
But
work
FERC
is
can just defeat that by,
well, the commission under Chenery gets the chance to make the merits, the procedural decision a second time around. The commission may or may not do that. Certainly, you may relax some of the requirements because it's procedural, but here we're looking at the end state and we already know the substantive outcome. So if we're thinking of like the footnote from Lujan, where it might change the EARS, we already consider their substantive arguments in their comments on the environmental assessment.
no, but they
So
also
we know
didn't
it's,
have, I mean, it's the value that's well recognized is that they get a chance. That was the same thing in the Public Service Commission case. And now they got a chance to get judicial.
well, I think
Review.
the opportunity for judicial review of orders is downstream of two facts in this case. One is simply that they waited a very long time to intervene in these proceedings. And if they hadn't done that, they might have been a proper party and then could have brought a proper hearing request and a proper petition for review. So that was something they could have solved on their own. Secondly, they could have sought expedited briefing in this case. They understood where the substance of the proceedings were at the time that they were denied intervention and at the times they filed their initial petition for review. They did not do that. That's a clear path for relief where, the merits order had an issue, but they didn't. And for that reason, the current
Well, I
order
think-
is final and unappealable.
I'm actually just confused about the state of FERC rules on intervention. So in a case called Double E that was in 2020, so post
Pipeline.
Tennessee pipelines, supposedly new strict rule. Although I guess that was only for natural gas strict rule. Commission said it would commonly allow late intervention as long as the person came in before the end of the comment period in environmental impact study cases. Which this would fall exactly within that. But the commission said, well, we won't do it in we will not do that in environmental assessment cases. Is that still the rule? And if so, what on earth is the rationale for saying this very same intervention would have been permitted if you were doing an environmental impact statement?
So
but
as I
not
understand,
environmental assessment.
as I understand it, for Double E Pipeline, along with the other three commission decisions, the two other commission decisions in footnote 36, as well as Broadview Solar. In each of those instances, a party has been 6 to 12 months late. And the commission found under factor D11, because they had such an egregious delay and did not have good cause for the timing of their intervention, that was sufficient to deny intervention.
I'm asking you about, that wasn't the rationale. What was said there. What they said was, there the groups filed their late motion to intervene during the comment period on the environmental assessment. This is paragraph 24. On the environmental assessment. Same as this case. While the commission's regulations provide that any person who files a motion to intervene on the basis of a draft environmental impact statement will be deemed to have filed a timely motion if filed during the comment period. That provision is inapplicable where the staff prepared an environmental assessment instead of an environmental impact statement.
Understood. As I understand
What's
it,
the rationale for
that
that
case
decision?
was unique because when the commission issued notice of its intent to prepare an environmental assessment, it indicated in that notice that parties were welcome to intervene. That did not occur in this case, and as a matter of practice, does not occur in most environmental assessment cases. And as I understand it, that was part of the basis of Commissioner Glick's dissent. In that case, because the commission had made an affirmative representation of a second opportunity to intervene, which is the standard practice.
Commission's regulations provide, was there a so that wasn't a one-off if it's a regulation.
Well, I believe
Do
that,
the regulations still
Well,
provide that?
as I understand, well, the regulations have changed because of the CEQ changes, as I understand it. But my understanding is that
Do the regulations, yeah, go ahead.
the regulations, as I understood them, provided a second opportunity to intervene for environmental impact statements.
As
And
long as you're in during the comment period.
for environmental impact statements,
Yeah,
because they had by rule a separate opportunity to intervene. It's not my understanding that that was true for environmental assessments, but I have to be frank that I don't have the CEQ or FERC rule as it existed the CEQ rule as existed at that time. But my understanding is that environmental assessment was a one-off.
Why wouldn't you have, what is the rationale for treating
Environmental assessments versus environmental
Okay,
impact statements.
yeah. Mhm.
Environmental impact statements are much larger, as this court knows. They're much harder work, and by rule under
Yeah,
CEQ.
last thing you want is more people jumping in at the last minute on those. I
Well,
don't think. I'd
recall
rather-
that in the EIS cases this court has seen, there's often a draft EIS
Mhm.
and then a final EIS with a comment period in between those two. And that comment period in cases like Healthy Gulf or Public Citizen can be decisive in terms of forfeiture. Here, we just had an EA published. The parties were allowed to comment on it and then
You
a
had
merits
it, you had
order.
it published, and parties commented, and so you were taking comments, and they intervened, before that comment period, long before that comment period closed. In fact, they were identified in the assessment itself as having filed a motion to intervene, so before that.
Yeah, on that
And
point,
so I'm trying to understand what the harmless. I mean, I don't understand. It sounds like you just want to argue they were 9 months late, but that has never been a factor that I've, oddly enough, that FERC has trotted out. I mean,
Well,
it's had interventions 2 years
Well,
after the deadline.
I disagree with that, Your Honor. A few points there. I think the length of delay is germane to the D11 factor. And I think we see that in cases like the 3 cases in footnote 36, as well as WE Pipeline, all of which are 6 months to 1 year of delay. And the commission says you failed on their D11 factor. You did not have a good explanation for this delay. And that is sufficient because this rule gives us an ample amount of discretion, as Judge Pan noted earlier.
Yeah, hang on.
And I think it's also important because.
Just to be clear, what you just said has nothing to do with lateness, other than it flagged the time period being analogous to this one.
Well, I can go to the weight of the factor, and I think it's also germane.
Wait, where has the commission said, weight of what factor? Which factor?
D11 factor, but even if that's
The good cause?
D11 factor, correct.
Sorry, you mean the good cause?
D11.
Good cause for the failure to file late.
Correct. The first factor.
Okay, they're already
D1.
late. Okay, where has the agency said, because what you just said to me does not communicate that we independently, apart from prejudice, disruption, we independently look at how late you are as part of the good cause for being late.
The last sentence of paragraph 13 of your hearing order here mentions that
Before this case.
before this case, well, it is citing other cases, and I believe it's.
I know, did any of those cases say that?
Yes, they say that the D11 factor is important for the orderliness of commission proceedings, and the commission also notes it's important to promote efficiency and timeliness. And
But
even if that were the
nothing
case,
here affected.
even if that were the.
Wait.
Oh, sorry.
I'm just trying to be clear
Sure.
here. So it sounds like the answer to my question, have they ever before said that length of time alone is a factor in determining good cause for being late? It sounds like the answer is no, because I haven't heard it from you yet. And then you say, well, we want efficient proceedings, and that makes perfect sense. That's when lateness would go to disruption.
Not necessarily, because disruption might be in the individual
How is it
circumstances.
inefficient, since you were still,
So-
you acknowledged them in the assessment itself as being interveners, I think.
I disagree with that. I don't believe that's a correct characterization of the record. We acknowledged at, I believe it's JA 42, that they filed a motion to
Okay,
intervene.
that's fine.
I'm not sure how
They
anyone
were
could have-
there, right.
Right.
And they didn't even have to file a motion to intervene to comment. I mean, that's a strangeness of your position, because it's open to anyone in the public to comment on your environmental assessment. And every one of those people who comments is coming in, they're coming in at the same time. And you don't say, citizens, we've invited public comment, but now we're going to all say it's too late, it's too disruptive, it's not efficient to have your comments.
No, we didn't reject their comments at all. We rejected party
Exactly.
status.
So there was no efficiency. I don't understand what
Well,
efficiency
you're
looking
asking-
here.
Well, because it's setting an example, you can think of it, perhaps, this might be a little bit too esoteric, but rural utilitarianism versus act utilitarianism, or just the
You're
precedent.
beyond me at
Okay,
this
sure.
point. I'm not an
Sure.
economist, so.
The precedent in this case in terms of timeliness, if we were to excuse first of all, the rule does not require us to make a prejudice finding or a disruption finding, but the commission needs to enforce its rules so parties understand that if they want to be involved in proceedings or future cases, for example, they need to intervene on time. Here, they were put on notice not once, but twice, and still waited a long time before they actually intervened. Now, whether or not they filed comments is irrelevant to that because we consider the substance of those comments.
But
I would also understand.
Sorry, your rationale was we need to have efficiency in doing this, but this environmental assessment is a process where there's nothing remotely inefficient about somebody showing up and commenting. First time you've ever heard of this that's the wrong word, but commenter, is when comments are sent in.
The assumption.
The last day of the open period for comments, and there's nothing inefficient about that because it's a public comment period. So I don't understand. I understand other situations there may be efficiency, but normally if something makes something inefficient, that would.
That's exactly what
fall
Tennessee,
into the-
that's exactly what Tennessee Gas says. We apply these rules more strictly because we have created bad precedent for other parties who are sleeping on their rights. And if we do that here, we're likely to encourage like entities like American Whitewater to come at the last minute, perhaps even after a merits order issued, and say, well, what is the harm
This is
being done?
not, you have a whole different rule for
Sure.
after merits board.
Well, no.
That's not what happened.
I disagree. There is a different application of Rule 214.
That's an extraordinary circumstances test.
But City of Orville says that is a refinement of Rule 214 itself. It is an outgrowth of the rule, is not independent of that rule. And to go back to your,
It's just that is a really difficult standard to meet. And it's obvious because anything
Agreed.
that comes in after decision, I mean, it's going to be hard I can't imagine how they're going to avoid the discussion and prejudice box.
But that-
So they
that
better-
rule-
they better
that
have the
rule-
world's best
that
reason.
rule was based on, say, a presumption of prejudice, and they may not, the commission doesn't necessarily need to make a prejudice finding, but this goes really to the permissiveness of the rule generally. There is no requirement in the rule that the commission make a finding of harm to this proceedings. If you don't meet factor D11, that is sufficient. That is what this court said in
Well,
City of
that's
Orville.
true.
That is what the Ninth Circuit said in California Trout, and there's no requirement for that. And because the rule is such.
You didn't apply that rule in DTE Energy, Athens Utility Board, West Texas. Now, maybe West Texas was so close. I don't know if that
Sure.
was grandfathered in.
Let's get to these. Can I start with Swanson Mining before I get to the reply brief cases? I think there are two, both Swanson Mining and all the cases in the reply brief. The most important issue here is that absolutely none of these cases were mentioned at all in their hearing request to the commission. So if they expected response to specific precedent, it should have been in there. And now they fault us for only raising those cases on appeal. Now, Swanson is distinguishable, and I think actually helps us nonetheless, even if the court considers it. Because the commission, while it did not find that the D11 factor had been satisfied, was a completely different type of situation, factually distinguishable, because they're a state resource agency had alerted the commission to a patently unlawful exemption that it issued under inaction, and that state resource agency had a specific statutory duty. There's nothing like that analogous to this case. They are ordinary run-of-the-mill party.
I guess what we're trying to understand, or I'm trying to understand, is every case can be distinguished.
That is correct. And that is true because
So the question is, what does the commission hope to accomplish with its rule?
to promote the timeliness and efficiency and orderliness of its proceedings.
And what I understand Judge Millett's question's going to is that's all well and good. But there are some indications that that is not how the commission has been applying the rule. And so here, in some of the cases you cite, where the court has sort of made not dispositive comments about timeliness is important, but that wasn't your argument here or not you, but the commission's argument in denying intervention. There wasn't any suggestion that the commission process was prejudiced, that had the American Whitewater notified the commission earlier, that the commission would have changed course or done another study or looked to other issues. That's not this case.
That's correct, Your Honor.
And so the question is, why couldn't they come in? Because everybody else could come in. That's what that's all. And you have a rule. And if you want to say you have to be a filer by 60 days, then it applies to everyone, But that's not the way the commission has used this rule. So I asked my clerk to find any instance in which the commission had denied intervention of a public interest group as opposed to a utility. And the closest we could find was, well, there was the state. All right, but the state is not representing the same interest that the petitioner here is purporting to represent. So I couldn't find any case. Do you have a case?
To make sure I understand the question, Judge Rodgers.
In other words,
Sure.
Industry gets in, anti-industry doesn't get in.
So I think that certainly industry interveners are often denied intervention. It's the commission doesn't determine it by the NGO versus industry status. And I think actually to return to Judge Millett's question a bit, the transcontinental pipeline case that they cite in the reply brief, which is doubly forfeited because it's not in the hearing request or in the opening brief, is a good example there. In the same paragraph they cite, the
I don't think I
commission,
cited that one, but go ahead.
I'm sorry.
That's not one of the ones I listed, but go ahead.
Okay. The commission denied intervention to a group, a non-industry group called 1.5 Degrees LLC because they had no good justification or no good cause in their filing. My friends say that the commission granted intervention to the Watershed Conservancy. I believe Judge Millett was mentioning it roughly 15 months afterwards. But what they left out of that is what the Watershed Conservancy said in their motion. This is page 2 of the motion from the administrative docket, accession number 2022-1118-5224. APWC, the Watershed Conservancy, is a small volunteer-based organization that does not have any lawyers and therefore did not know about the requirements of becoming a party till now. That is in stark contrast to the petitioner here, which is a repeat player before the commission, was put on notice twice, and is able to call on the capable skills of not only in-house counsel, but at least in this proceeding alone, outside counsel from 3 different organizations.
So I understood FERC's point to be, we need to be able to control our docket. All right?
That is
We
certainly a big consideration, yes.
Well, I mean, I'm surprised you didn't focus on that in this case.
Well, we
I mean,
did. That's
if you
what.
have people coming in 9 months later, I think that's where you were going. That's a bad precedent to set, saying it's okay if you come in 9 months later.
Well, Judge Roger, I believe paragraphs 10 and 13 are making exactly the same points that you're making here. The last sentence, paragraph 13, talks about why the D11 factor is critical to the efficiency and timeliness of commission proceedings. The footnote appended.
I'm getting at a slightly different point, I think. Maybe I haven't made myself clear.
Perhaps, or I'm sure I misunderstood.
The commission cites Alcoa, for example. And in Alcoa, the commission makes the point about it's important to know as early as possible so other interested parties will know what the issues are likely to be and come prepared. And I thought, having done a lot of agency work myself, having been a judge, I mean, aren't all these rules designed to enable the agencies to handle their cases efficiently? And they have limited resources. And so they want to know upfront what the issues are going to be. And they're going to plan their research accordingly.
Absolutely.
And if somebody comes in late, then they have to start all over again, or they have to do some additional research. That was not the argument, as I understood it, being made by the commission here. Rather, I thought the commission was saying, look, you're 9 months late. You had notice, you're a repeat player, and you don't give us any explanation for why you were late, other than you overlooked it.
I think
And that's not enough. That's not good cause. End of discussion. And you quote some dictum in various circuits, and one circuit goes much further than even the commission has gone in terms of what it requires under its rule. And so if we get to that issue, it ought to be a simple case.
Well, I think it is certainly a simple case, and that's because the rule says the commission may consider any, all, or really some, none, or all of the factors in paragraph D. Here, we consider the D11 factor, and that is sufficient under the text of the rule and this circuit's precedent under City of Orville, as well as Your Honor noted Cal Trout. Now, it is true that the commission didn't make a specific finding on prejudice to these proceedings, but as Your Honor noted, the commission notes all these factors because they all ultimately get at the same sort of issue fundamentally about the efficiency and integrity of commission processes. So while we might not make a finding of disruption or prejudice and query whether or not those overlap, the fact that we can make a finding on the D11 factor is plainly sufficient under the 214 rule here.
So
The rule is.
I think I come at this from somebody who's been a trial judge. And to me, like, a deadline is important. A deadline is a deadline. And if you miss a deadline, then the burden is on you to explain why this deadline should not apply to you. And I think that it's really hard for me as a former trial judge, perhaps, to say that a 9-month delay is no worse than a 1-day delay. Like, to me, like, this is just a standard thing that you look at when you're looking at good cause. And even beyond the time limit, all they said was, we missed it. I mean, I feel like the process here is the commission is obligated to publish this, and that's how people are put on notice that there's a deadline. And if you miss the deadline, the burden is on you to show good cause. And if all you can say is missed it, didn't see it in the Federal Register, that's not good cause. So to me, if we get to that point, it does seem to be a simpler case. The rule is not anybody who wants to come in can come in if we're not that far along in the proceedings. Like, that's just not the rule. And even if it's been applied that way in some occasions, to me, these are just such fact-bound decisions in each case that I think it's hard to draw a rule and hold the commission to it, that anybody who comes in when there's no prejudice determined by who, I don't even know, then they should be allowed to intervene. Like, I just don't think you can run a process this way.
Yeah, your honor is exactly correct. That's no way to run a railroad. It creates a terrible ex ante incentive if they just mail it in with a 1-sentence non-explanation about why they waited 9 months to file. And the rule doesn't say that the commission has to go beyond that. And here the rule is written.
You're not a district court.
No, we're a commission that
Agency.
we're a commission that runs large multi-party proceedings that
I
take years.
understand what the commission does. I'm fully familiar with that.
Sure.
Now, you have a rule that multiple commissioners themselves have said is inconsistently applied post Tennessee. That didn't fix anything.
Well, obviously, the other commissioners didn't agree with Commissioner Danley.
2 said it was inconsistent and wrong, and 2 said, I mean, you had Danley and Glick, and then a third one who thought our rule's broken and should be fixed anyhow. So you've got them already saying we're not consistent.
And a majority of commissioners believe that we
So I
are.
still haven't, I'm happy I'll let you talk about cases I didn't mention. DTE Energy.
Sure. DT Energy.
It was a late filed motion to intervene. It was granted, no discussion of good cause. Given their interest in the proceeding, the early stage of the proceeding, and the absence of undue prejudice or delay.
Well, I think DT Energy has the same problem as West Texas Pipeline Gas, Athens Utility Board, Duquesne Lighting Company, and Swanson. It's not raised in the hearing request. And other than Swanson.
I'm going to assume the agency, when it announces, oh, we have this rule that unless there's good cause, we don't grant it. They've checked, they've done their homework to make sure they actually have that rule. And when it turns out they don't have that rule, and they didn't have it for these companies, in this case, power companies or gas or oil, whatever it was. But we do have that rule for American Whitewater. That's a problem. And then we have, these are the cases I want you to address. Athens Utility Board. All right.
West Texas Pipeline.
Granting late intervention, granting late intervention because it will not disrupt proceedings or place additional burdens on existing parties. Nothing there about you got to get through the good cause. You could have this rule, and you could also have a rule that says we'll do these factors, but if you're after 3 months, 6 months, 9 months, you pick the time.
Sure.
You're out of business.
If I could make one high level point for all of them before I get into the individual facts, I think Judge Pan's insight here is very important. The rule is written to maximize the commission's discretion. It is reviewed for an abuse of discretion standard. That means the commission is entitled to draw factual distinctions among parties. And in this case, they face a very high burden of showing that an identically situated party was treated differently.
I'm just going to give you some.
Sure.
None of this one. You tell me if this one was setting the rule.
None of the parties.
We do not find PJM's reason, PJM. We don't find their reason for delay persuasive. This was, to be clear, after this decision. But every other rule criterion points in their favor. So guess what? Intervention was granted when they specifically found we don't find good cause. And that was PJM. It wasn't an environmental organization. And then we had Vector Pipeline. And an opposed motion to intervene. While we find that INGAA has not provided good cause, looking at the other factors, we're going to let them in. I mean, we have an obligation when someone brings the issue to us to make sure that the commission when someone says it's not being applied in an even-handed manner, we have an obligation to check the pattern of decisions here. And it's the commission's own mouth here.
So I'm going to skip DTE for now. We're going to go to a group of
No,
cases.
tell me about DT.
Okay, PJM or because the
No,
response is
sorry.
slightly
First,
different.
I threw a lot at you. I'm sorry. So let's start with DTE.
DTE. So DTE, West Texas Pipeline, Athens Utility Board, Duquesne Light.
No.
Okay, sorry.
We're
We'll
gonna
just start with
I'll
DTE.
call them out one at a time. How about
Okay,
that?
sure.
And we'll be clear because you keep referencing ones that I haven't. So
Sure.
DTE,
It's factually distinguishable. The delay there is less than 2 weeks.
where does it say that in the analysis granting the motion?
Paragraph 11.
No, that's not discussion. That's just a description. That's a background description. Where do they
Certainly,
say-
I believe
Where
it's-
do they say in paragraph 21, which is the entire explanation of their decision granting it, that how long makes it? The commission could do it. They could say it's an independent factor, but they haven't. The only time they've mentioned expressly time being too long is when they then tied it to prejudice or disruption. They could have that rule. They don't. And there's paragraph 21. Tell me what in paragraph 21 distinguishes this case.
My apologies, Your Honor. I don't have paragraph
Okay.
21 in front of me.
I'm sorry.
But I can tell you that reading the decision as a whole makes it clear that it's a very factually different case than
Again,
this.
it's only, no. The only fact you've identified is a time thing, which the commission chose not to rely on because it didn't affect the absence of undue prejudice or delay.
So, Your Honor, paragraph 10 clearly mentions the delay. It mentions 7 months between the notice of intervention and the notice of intent to prepare an environmental assessment. It then mentions a 2-month delay after that. It then also mentions sophistication of the parties. But Your Honor also pointed out, even if this is not a D11 factor itself, those facts can still be relevant to the commission's decision because the list of factors in D1 is not exclusive. As this court said in City of Orville, the commission is not
I
required to
agree with that.
communicate with that.
And that's why if I saw a pattern here of the agency being consistent on timeframes, and
But
I mean, one, it could announce a rule, which would really be helpful to everybody. The commission, if it really wants this efficiency and lack of disruption, it could announce the rule and it could, I'm not going to set it. 3 months, 6 months, you tell me what you think would make sense. I don't know. That's not my.
You do see a pattern in footnote 36 of our hearing order, Venture Global CP2, EE Pipeline, Broadview Solar, STS Hydropower. All of those cases are in the 6 to 1 year range. They're nothing like DTE, which is under 2 weeks. And the rest of the cases in the reply brief, which are a month or less in terms of delay.
I know,
Nor does the
that's
commission.
not the rule. I mean, you
Nor-
have to admit that's not the rule they've adopted.
But there isn't necessarily a rule that says that, but it is a clear pattern from these decisional cases and obvious from the decisional law. And it requires an incredibly, I think, somewhat tendentious reading to say that the length of delay did not matter,
I guess I'm a
particularly in this
tendentious- I'm a
case.
tendentious person, at least when it comes to agency, because I expect the agency to say it and not for me to have to knit it together and then somehow figure out why the 18-month or the 2-year delays were different.
Well, what the
I mean, that's
agents,
just not how it
well,
works.
I think it's germane to the D11 factor, good cause under paragraph D in a different sense. And that is because the justification they raised was that they were not aware that the notice of intervention had occurred. But they are charged with a constructive notice under the Federal Register Act, which means that they had been supposedly not aware of this case for 7 months while it's proceeding. And then the agency put them on notice again independently through a second publication. So in some sense, this case is truly unique
What
because
was
they're
the second
the
publication?
notice of intent to prepare an environmental assessment. We put them on notice that this,
They
that
participated in that.
They did, but they did not move to intervene until 2 months after that. They sat on the rights once again.
2 months is too long now as well.
It certainly can be under Rule 214, which is Judge
We don't
Payne
know when
noticed.
2 months will be and when it won't be reliably.
See, and the other thing that's odd about this case, candidly, is that you had comments. So the institutional delay to the agency that could result in prejudice isn't present here. And that was the only explanation I came up for myself as to why the agency hadn't mentioned that aspect of prejudice, because there is no prejudice here. Because the agency knew exactly what American Whitewater was going to say, were it a formal party in the case. And it proceeded.
Well,
So that line of prejudice doesn't work here.
you're correct, Your Honor.
Arguably.
You're correct, Your Honor, that
And
the
so
commission.
all you had was, they're too late, they had notice. Well, all these other cases, there was public notice, and most of these utilities have permanent legal staffs, if not firms on retainer. And so they were on constructive notice as well. But good cause was not enough to keep them from having intervener status before the commission. That's what's so troubling here. Aren't you concerned about that?
If we're talking about this, Your Honor, maybe talking about the PJM case, I would certainly note that it is correct to the commission to not rely on a finding of prejudice in this case, but this is just like what Judge Payne noted, this is no way to run a railroad. You have to set proper ex ante
But-
incentives.
But that's where it's so unconvincing, given that the commission's been all over the waterfront with its rule. All right, and I have even come up with a list of factors based, not factors, but what elements based on your precedent
Considerations.
considerations, thank you, that the commission has used. But the normal ones that you're talking about today and that the commission raised in this case are not present. That's what's so odd about it. And I thought initially when American Whitewater was listed in the EA, I thought, well, it was a typographical error. You know, somebody thought they had actually, their motion had been granted, but in fact it hadn't. Somebody, you know, and their cause and effect argument, I'm not persuaded by. They say we filed negative comments, 2 weeks later, the commission denied. That doesn't persuade me, all right? But it is concerning that the commission doesn't address the fact asserted by American Whitewater that they represent an interest that is relevant to the commission's decision-making that is not otherwise represented. So back to Judge Millett's point about these are agencies, they want to hear from everybody, they want to get the public view, so they make informed decisions. And someone who's late says, look, I have a point of view that's not being represented. And the commission ought to consider this before it makes its decision. So I thought, well, the backside of that is, well, the commission took their comments into account, presumably. But of course, the key point on intervention is you become a party and you have all kinds of rights that you don't have as a member of the public to submit comments. So that's why it's so critical that we have a rule that we can understand.
So one premise of Your Honor's question, I would direct the court to I believe it's the last footnote in the hearing order. I believe that's footnote 43, where in fact, there are several other parties and commenters who raised similar arguments about dam removal in this case.
But the commission never addresses American Whitewater's claim that they represent interests that are not adequately represented by anyone else who is a party before the commission. I didn't see the commission challenge that at all. Now, you have the Department of Recreation in there, you have other people, but the Department of Recreation may have a lot of interest. You know, it's got capital costs as well as operating costs, et cetera. That's not what American Whitewater is talking about. That's not what they say their members are concerned about. And yet the commission doesn't want to give them standing, as it were, in its proceedings.
Well, the commission didn't need to, Your Honor. And the point is well taken about other
They
entities.
didn't need to, but shouldn't it have a rule that makes it clear what's going on?
If the court, perhaps the court might think the rule should read must consider a list of exclusive factors, but that is not the way the rule has been written. It is not the way the rule has been applied. The rule is final and not appealable. It can't be challenged on its own. And this is the rule we have in this case. And that rule is interpreted by this court and the Ninth Circuit says the commission can consider individual factors, but need not consider all of them.
Well,
And here, the
with
commission
all due
decision.
respect to, our sister circuit, it also says the commission has been consistent in applying the rule. All right?
And I think we have, and I think the rehearing order demonstrates that, particularly with footnote 36, adding Broadview Solar. And I think to discuss about inconsistency, it's just critical that I talk about individual cases here. But I've tried to offer the court distinctions to the extent that they get in their decisions raised only on reply and not in rehearing. I don't believe I've addressed Your Honor's point, I think a reference to PJM and Judge Millett's reference to PJM. So I'd like to address that now if that's possible. But as I think the court knows, the fact that the agency might make a separate decision later after the order is under review does not make the orders under review arbitrary and capricious. That is well-established law, and I can give you one citation.
I mean, we are all familiar with the rules of agency.
Certainly.
Record review, but the difficulty here is we've got cases before and after that show a pattern of inconsistency. We don't need to rely on the after ones by themselves, but, at some point, do we have to stick our head in this? I mean, if you had been fully consistent up to and through this decision, and the wheels just came off after this decision, your point would be extremely well taken.
Well, it does address a certain number of cases, but to Your Honor's
No, but
larger
my
points,
point is
certainly.
that when we see, sorry, I do know, I owe you a finishing a sentence, I apologize, but just when we see this stuff before and it's inexplicable and there's commissioners going, what is the rule other than consistently inconsistent, I think Commissioner Danley said. And then we look and it's like, it seems to be getting worse even afterwards. That's what seems troubling to me, but so I'm not relying just on things maybe changed after the fact. I take your point on that. Go ahead.
As the commission noted, I think in paragraph 13, what is being construed as inconsistency here is simply a matter of fact-specific determinations that may involve some of the D factors, but not all of them, maybe none of them. The commission isn't applied to require any of them. So the commission is entitled under its rule.
Inconsistency, to be clear, is that we were told in this decision, we do good cause first. And if you don't get through good cause, you're done.
It's sufficient. And that is true under Venture Global
No,
CP2.
if we don't look at the other factors.
Well,
We aren't going to, if you don't have, that's what happened here. Because they met every other factor. But you didn't meet good cause, we're not going to talk about them. And then we go to other cases and we don't either discuss good cause, the commission doesn't discuss good cause at all. And grants intervention. I mean, I read the decision in this case as not just sufficient, but necessary to have good cause. That's what I read the commission saying here. And then we read ones where they don't even talk about it at all. And then ones where they say, this is not good cause, but the other factors are met, so we'll let you in.
Well, it's not necessarily the other factors. It may be something entirely outside the factors like Swanson mining, which the
I have
commission
not
necessarily-
mentioned Swanson. I know you keep wanting to go to that very old case that long predates even your Tennessee gas, where you're supposedly we're trying to clean this up. Sympathy I have for the commission. It's just, it has to hold a line. And again, you can react and go 7 months is too long, but that's not the commission. You want to run a railroad, right? the train is leaving at this time. If you're not on board, you're not on the train. Okay? You set a hard time limit. If they don't want to do that, then they can say, well, length of time itself will be a factor. It'll be one of our considerations, but they haven't even said that. The only times they've talked about it, apart from this case, is when they did it in a sentence explaining prejudice or disruption. That's the concern here.
Well, the factors aren't necessarily hermetically sealed. I mean, take disruption or prejudice. I'm not sure how the court necessarily distinguishes between those two.
Well,
Obviously, there's lots of overlap, but even if those factors aren't in play,
We have disruption without prejudice. One prejudice often is looked at to other parties.
But in many cases,
Disruption is,
cases, disruption will imply prejudice, right? But the commission might make findings differently in the same way with
they're tasked. I didn't write
the same way with good cause under D11, right? Sometimes it may create prejudice, and sometimes we may be concerned about the ex ante incentives it creates for the whole process in terms of present and future cases later, because we do need to draw a line somewhere, and the commission has done that here, and in the many cases it's cited. And I think ultimately, the other consideration we haven't talked much about is really that the commission in the rehearing order is responding to a limited set of cases that they raised on the rehearing and the rehearing request. And they raised a lot of them, and the commission went through all of those. Now, most of them were just non-responsive because they were ALJ cases but they didn't raise the cases that postdated the orders. But the only two cases they properly raised where they can make this argument were Erie Hydro Boulevard, that's answered in paragraph 12 of the rehearing order, and in note 37 of their hearing order, which is the wood pulp decision. In both those cases, the facts are very different, and the commission explained why the facts were different. Essentially, both equated to a failure of notice. In wood pulp, note 37, the entity seeking late intervention was in Canada, so not deemed to have constructive notice via Federal Register publication, had never participated in commission proceedings, and nonetheless still managed to intervene only 1 month after the deadline. Now, in Erie Hydro Boulevard, the Citizens for Hinkley Lake case in paragraph 12, the commission essentially admitted that its own notices to have two interrelated proceedings created some confusion. Nothing like that is here. That might also be something like in EE pipeline, where the commission mistakenly offered an opportunity to intervene in its environmental assessment, even though it was not an environmental impact statement. But those cases are distinguished, and that is the only universe of cases that they have properly raised on rehearing in this case. And in the opening brief. And so for that reason, I asked the court to affirm. I'm sorry, unless there were more questions, certainly.
I had just a couple things. One is it just seems to me that if you're applying the words of, 214, it says you may consider a bunch of factors, including whether this disrupts the proceeding, whether the interest is adequately represented. So it's a permissive thing. And what I'm hearing from the tenor of this discussion in the colloquies is that if an agency has discretion and has factors it may consider, if it often, or it seems some people think always, treats certain factors a certain way, then they lose their discretion in every case to not consider those factors, even though the rule says they are allowed not to consider those factors. And I guess that leads me to wonder, is it really true that the commission has never denied an intervention motion just because you were late and you didn't have a good reason? That seems to be the tenor of what I'm hearing here. Like, you never do this. You were late, you didn't have a good reason.
No, we've done exactly this case in multiple other situations. Venture Global CP2, they say the NGO whose name is abbreviated by the acronym FISH. You didn't explain the D11 factor. That's sufficient to kick you out. It was sufficient on its own in Broadview Solar, in EE Pipeline, and in STS Hydropower. 3 of those cases are collected again at footnote 36. And in all 4 of those cases, the commission says you mailed it in on D11. We're not going to excuse that. You were on notice because of our cases that this is important. We may consider this factor, and that is sufficient.
Okay.
And it's incumbent on the petitioner here to really show that something like I think international transmission companies cited in the red brief is also a good analog. There, it was a very different sort of proceeding under the Federal Power Act transmission incentives, but the commission had a policy of making fact-specific determinations, just like it does here, under a rule designed to allow it to do exactly that. And when that is the case, the party needs to show that the facts are, there are no materially different facts here. They haven't done that because they fit well into the time range of the 4 cases I mentioned. Plus, they are sort of unique in that they got a second notice from the notice of intent to prepare the EA and sat on their hands for 2 months.
Right.
And it's true the commission did not make
The reason was we didn't know about it, but then they did know about it for 2 months and they still were late.
Well, the reason is essentially that they didn't have actual notice, but by federal statute, they had constructive notice.
Right. But then even then they had actual notice, they waited, I guess is your point.
Apparently,
Yeah. So
certainly.
I guess my other
And many other
question.
entities like PJM moved them
Okay,
much
so
more.
my other question is about mootness. And it just seems to me that if we were to rule against you, you could reopen you could reconsider whether or not the intervention motion should have been granted, using more factors or not, whatever.
I actually think
You could.
that is a great question. I think there is an important factual distinction. Once the letter issues, the commission loses jurisdiction entirely. I don't know how we could reopen after that point.
Okay. I thought you said that had not yet happened.
It had not yet happened.
So what's the
Yeah.
time frame in which this ruling would have to come down for it not to be moot? When will it become moot, I guess?
I don't know. And if I knew, I couldn't tell you.
Well, you do have a pending motion for administrative stay that would also include issuance of that letter for precisely this reason, right? I think the administrative stay.
There is a pending motion for administrative stay from the petitioners. Yes, that was
I
filed.
think it includes issuance of this letter.
I understand that was filed sometime last Friday, I believe. I'm not sure the status of that, and I have no idea whether.
Well, no,
commission
I'm just saying,
agrees or
there's,
not.
I believe that mentions, I mean, council can correct me if I'm wrong, but that includes asking a stay of issuance of that letter for precisely the reason you just mentioned. Once you don't have jurisdiction, I don't know what anybody's going to do.
Right. That is my understanding.
Well, you could always write a letter and ask them to withdraw that letter because of the decision by the court, which makes it mandatory now for you to reconsider whether or not American Whitewater.
Well, I think the court's relief in most in this situation, Your Honor, would be limited to vacatur of the intervention orders.
Sure, no, I understand, but we're not sort of in an impossible world. And if the letter comes tomorrow, the other thing I'm concerned about is when judges ask questions, they don't necessarily and often don't indicate what their views are. And I can see all kinds of reasons why agencies have this kind of rule, where they have a lot of flexibility. And they give you a signal that you ought to file in 90 days. And if you don't, you may not be able to be an intervener. On the other hand, there are going to be circumstances as the agency where we want some flexibility. And in our expert judgment, even though somebody or some entity hasn't shown, quote, good cause as we would normally require, the commission has determined that it's important to its proceeding that this late filed party be in the case.
That's exactly.
So I
Oh,
can
sorry.
understand that. And all I'm getting at is it seems to be clear here, and what's so troubling is that you knew what their views were. You considered them. All right. So the only thing that's at stake here is whether they're going to have the right to appeal.
And the commission, when they file timely motions, the commission has routinely granted American Whitewater itself intervention, as this court saw in a prior case decided in 2025. So the commission has no animus against American Whitewater. I just want to make that crystal clear here.
Oh, and I wasn't suggesting
Your
that, but
Honor,
I was suggesting that the pattern of cases doesn't give us confidence as to what the commission is doing.
Well, I would think it does, Your Honor, because the rule entitles the commission to draw very fine factual distinctions. And when you
True.
take a look at the facts of these cases, they fit very comfortably in the cases in note 36. And they are much different than the other cases.
They fit comfortably in the sense that both the mandatory rule and what petitioner calls the mandatory rule and the discretionary rule both talk about good cause. And I think it's fair to assume the commission isn't defining good cause differently within those two subsections of the same rule. That you may have good cause or you may not. And here the commission says, you gave us no reason. And you had legal notice and you had actual notice. And you just said you forgot.
And they
All right?
mailed it.
And that's not good enough. All right, end of discussion, says the commission. But on the other hand, in these other cases, even the parties who are more involved in the actual decisions that the commission is going to make, because it'll affect their bottom lines, get to come in late. So it's not a question of bias, but it's a question of how you're applying the rule. And that's what's just odd about it.
Well, I think it would go to the weight of the D11 factor in terms of they're trying to explain a degree of delay. And the longer the delay, in terms of the good cause for that delay, the greater explanation you need. And that's an egregious delay here with the minimum of attempted explanation. But I would also note, for your honor, even if it's the case that the length of delay articulated as a grounds for decision in paragraph 10 of the rehearing order is not in fact properly put under paragraph D1 Romanet 1 as good cause, it would still be a sufficient grounds on its own because Rule 214 does not limit the commission to even those factors. And this case is factually unique as far as I understand it because they slept on two different notices or ignored two different notices.
Well, it's factually unique in several respects.
That's true.
Okay, on your favor and on petitioner's favor.
So on the mootness issues, though, what do we do with the fact that it's not moot now as we sit here at oral argument, but could become moot at any moment?
Well,
Depending on when that
on the mootness issue, I'm not sure that it isn't moot really right now because there's no, as I understand, there's no possibility for a viable petition for review of the merits order. Sure, the commission might grant them party status, but I'm not sure what that achieves because the 60-day window has already run. They needed to file a proper hearing request, which the commission rejected. And so they've already missed not only the 825LB 60-day window, they missed the 825LB, A window as well. And so even if the commission were to grant them party status, the court would have to reject, we may have to reject their notice for hearing yet again.
So correct me if I'm wrong. I mean, this is just hypothetical because it's mootness. Like, is there a possibility of relief? Because it seems to me that if this were remanded to you, you could probably, given the broad discretion that the commission has, come with a better rationale or rationale that fits whatever we say.
Absolutely.
Deny them intervention, which is probably what would happen. But is there a possibility that if we were to remand and say that you didn't apply your intervention rule correctly, reapply it, and if you were to hold, okay, they should have been allowed to intervene, that you would go back and look at what they filed, which you rejected because they weren't a party, because now they are, like at the rehearing stage?
My understanding,
because the whole process is moved.
Right. The commission already rejected an earlier attempted rehearing request because they weren't a party. But I'm not sure how the commission, this is, I can't fully speak for the commission. This is my understanding of the statutory clock. It is a hard jurisdictional limit at both 30 days for a hearing request and 6 days for petition for review. Both of those statutory clocks have run. So even if we were to grant them party status, I'm not sure how it happened.
They were just rejected. Did they file in a timely fashion, but they were just rejected because they weren't a party?
I don't know off the top of my head, but I think you could assume so. And if that's true, they could tell you.
So if they were timely, I'm just asking, is it just too late because the rest of the process has moved on? You can't reopen it for one party then at this stage?
Well, I think that.
I mean, you could theoretically look at their rehearing petition and say we wouldn't have granted this anyway. Right.
The commission, like this court, treats the 60-day clock in paragraph B of 825L. The commission treats and I believe this court and virtually every other circuit since Boston Gas in the First Circuit in the late 70s, I believe, has treated the 30-day clock in paragraph A as jurisdictional as well and binding both on the commission and the court and not subject to equitable waiver. So I'm not sure what the commission could do there. So, but again, this problem was avoidable for them in two different ways. One is to read the Federal Register with the 7,000 folks they have able to read it,
No, I understand.
and the 3 outside law firms.
So you're saying
and
even
move
as
faster.
an equitable matter, even if there were equitable.
Right, there would be no
Powers.
equitable reason
There's
to
no
do that
reason.
here. And secondly, I mean, they could have sought expedited briefing, for example. I mean, the commission certainly took its time with the merits order, went through a long section
I'm
106
not at all
process.
sure that had they intervened
Right.
closer in time,
Yeah.
but still a little bit late within your little bit late's okay rule. Then we're talking about 3 or 4 months difference in timing, but this case still isn't coming up here. We'd still have to do the intervention. And I don't see why that would have changed anything on our mootness issue. I don't understand. It was a commission that took forever to rule on its intervention.
I think my point might not have been clear. If they had intervened
On time.
in a timely fashion.
Okay,
Right.
but.
The commission might well have
Oh,
created.
so this
the party
isn't
status.
your, there's some number of lateness that's okay and some number that isn't argument.
Well, it wouldn't be lateness at all.
Right, okay, you're only making a no lateness at all argument. Okay. I mean, it is very strange, to sort of figure out what happens if we're, right, they haven't made, as a matter of law, we had to be granted intervention argument. You're right, they've only said test was applied in an arbitrary way. And they ask to have its only the intervention decision sent back. They don't ask us to say and direct FERC if it grants intervention then to reopen the proceedings. Would FERC at this stage, I assume it still has the authority to reopen? Assuming this magic letter doesn't come in from the Commissioner of Dam Safety or?
There is a rule on reopening. I have to apologize to Your Honor. I'm not sure the exact basis of it and how that would, I am not sure the commission policy on the clock, the statutory clocks vis-a-vis the reopening rule as well.
Right.
But, you know, in a worst case scenario, we might need to brief that. I mean, it's early, but.
Okay. All righty. Any other questions? Great. Thank you very much.
Thank you.
You have a little bit over your time. We appreciate you working with us on this. Okay, counsel, we'll give you 3 minutes for rebuttal. You haven't asked for us to direct them to reopen if they grant intervention. You haven't asked us to rule as a matter of law that they should have granted intervention. So it does feel like a bit of a pickle here on what you would even be intervening in.
I understand that concern, Your Honor, but that concern was addressed by the Public Service Commission case in which they noted.
Really old case, and since then we've got Narragansett, and it's just a little hard to figure out what to do with these 2 cases.
Narragansett is distinguishable, Your Honor. That case was decided on standing grounds, and the court specifically noted that standing had to be evaluated at the time the petition for review was filed. And in that case, all of the relief that the petitioner was seeking was eliminated at the time that the petition for review was filed. And that is simply not the case here. And Public Service Commission is the most on-point case because it dealt with a circumstance that is like American Whitewater's posture
All the
here.
ability for relief may be eliminated since, I mean, normally what happens is someone else has filed a petition for review too. I mean, FERC, alas, makes hard decisions, which it tends to make somebody unhappy on one side and sometimes everybody unhappy on both sides. But this is just an unusual case where everyone else was content with the decision. I'm not saying that you shouldn't have your views, as Judge Rogers has said, you had a different viewpoint. But this thing is over and done, and they are, have done everything except unplug. And so it seems a lot then to think that, and you haven't asked us to direct reopening in your brief. And I'm not, are you aware of any case since Public Service Commission where this court has claimed, and that wasn't a hydroelectric case, I don't think, where this claim has, was it under the same statute though?
I believe so, Your Honor.
Any other case where this court has said go back and if you grant intervention, then you must necessarily reopen. And is that second part, which is what, I take your point, and that's your live interest. We don't assign anything for our authority to direct that. What is our authority to do that?
The best authority I have, Your Honor, is the Public Service Commission case. And in that case, the petitioners.
Is there something in a statute? Are there other cases where, maybe not in an intervention context, but for whatever reason, we had to direct them to reopen an otherwise completely finalized decision that no one else was challenging?
As FERC counsel noted, FERC does have the ability to reopen proceedings, and this court
What is their test when they do that? What is their test?
I don't have the test on the top
I
of
mean,
my
if the
head.
test was prejudice to other parties, then
In this case, Your Honor, any prejudice that might be considered can only be attributed to FERC's actions if this court agrees with American Whitewater. There has been no evidence of prejudice and disruption at the time American Whitewater filed its motion to intervene. And the court and Public Service Commission, the petitioners did not ask for reopener, but the court in that case noted that if it be decided on the merits of the intervention request that the Federal Power Commission had aired, then necessarily the proceedings would have to be reopened.
I know I just don't know what the authority for that is. I mean, we got the case, I guess I could just point to that, but that seems an extraordinary proposition.
If Your Honor finds mootness or any type of these issues to be relevant to this case, FERC counsel or American Whitewater counsel can submit to the court the FERC regulation or the part of the statute that pertains to reopener. But both parties here agree that there is a particular authority that allows for FERC to reopen its proceedings.
But what can it do upon reopening if statutory deadlines have passed?
In this case, Your Honor, the issue of statutory deadlines is solved in part by 16 U.S.C. 825 LB. And in that part of the statute, it states that even after a petition for review is filed, FERC can modify its order. And the statute does not say.
Well, that's not the judge's question, as I understood. Maybe I missed.
So I understood your friend on the other side to be saying that it's too late. There was a 60-day deadline. It's done. You know, we can't go back to that. So I guess there are two barriers. One is once this letter issues, we have no jurisdiction. Even before it issues, a reopening would not enable it to really do anything substantive because the process has moved on. And so at some point, I feel like that probably is the case. I don't know specifically like how the FERC rules work, but why is he wrong?
He's wrong, Your Honor, because of this court's decision in American Whitewater versus FERC in 2025. And while that case was not an intervention case, the case did decide the issue of mootness after a surrender order becomes effective. And at that time that issue was decided, the court found that even if the surrender order was effective upon this court's decision, it still would not render the case moot because this court could vacate that surrender order, which would revert jurisdiction back to FERC.
You haven't asked us to do that.
No, Your Honor. And the issue of whether or not the related proceeding would be moot would have to be resolved in that particular case. But in this case, the best case and the only case that either party has raised on this issue is the Public Service Commission case.
See, I'm thinking of some other cases, not for cases where we have said that the petitioner in this type of situation has to show how it was prejudiced. All right. And so the argument FERC makes is, look, not only did you have formal and legal notice, but you're frequently before FERC. So you know how FERC operates. All right. And you're a sophisticated party. All right. Furthermore, we have your views. We've considered them. So, you know, what's the prejudice to you? The people you represent, their views have been presented to the agency and the agency has considered them. The agency hasn't necessarily agreed with those views, but that's not the test. And so why should we sort of come up with some bad law, arguably, undercutting sort of the agency's procedural process when the party before us, quote unquote, hasn't pointed to any prejudice to it. Because the people it represents or the entities it represents, their views have all been presented to the commission. And there's no suggestion that American Whitewater has anything more to say
That's not
to the commission.
That's not necessarily true, Your Honor.
Well, I didn't see that in your brief. And we get briefs all the time where parties say, look, we're late or we want some special treatment because we've been prejudiced. All right? That's not in your brief.
And that's because the issue of the difference between for considering American Whitewater's comments and now happened after briefing in this case. It was after the surrender order was issued.
Well, you can file 28J letters. You can put us on notice. None of that happened, you know? So literally 24 hours before, we've got this new issue before us, all right? So I'm just trying to think, you know, in this case, why are the equities in your favor? When you haven't pointed us, you haven't asked for things, all right, as Judge Millett's questions have pointed out. Judge Pan has pointed out how there are all kinds of issues that haven't been answered this morning. And, you know, you're not answering them now. You still haven't pointed to any prejudice to the interests you represent.
The specific prejudice is the change in position that FERC took in between the EA and the surrender order.
That was not my question, counsel, and you're too bright. Okay. And you knew what my question was. The interests you say have not been adequately represented by any other party before FERC, but you submitted your comments on behalf of the members that you represent, and you're not denying or you're not challenging FERC's statement that it considered those comments.
In the request for rehearing of the surrender order, American Whitewater does argue that FERC did not sufficiently consider the arguments.
Sufficiently. Okay, they considered them. All right, maybe not sufficiently from your point of view, but you haven't argued any prejudice here. It's not as though FERC overlooked some major issue, you know, that the dam after 5 years is going to explode and kill all the residents within 20 miles. That's not this case.
So
this case is an intellectual case, right?
No.
Are we going to look at a rulemaking by an agency and say, yeah, they're all over the waterfront. You know, their cases are so different. And FERC comes back and says, yes, and that's exactly what our rule entitles us to do. All right? But for a sophisticated litigant who had legal and had constructive and legal notice, you know, what's the excuse for letting you come in so late in the game? There is none. And you haven't said you're prejudiced.
Your Honor, the specific prejudice is the inability to respond to the environmental justice rationale, which switched. So American Whitewater's interest is advocating for surrender with dam removal. And in the EA, unlike in the surrender order, FERC attested that environmental justice weighed against dam removal. And then it changed its mind in a way that no party has been able to comment on in the surrender order.
Well, no other party is before us either, right?
That's correct, Your Honor.
All right, so apparently everybody's happy. Or they've just decided this litigation has to come to an end. It's clear that this dam is going to be decommissioned. All right?
It's unclear, Your Honor. I have no way of knowing why the other parties may or may not have.
We don't either. But all we have is what's before us. All right? And this rule has been on the books forever. You certainly had an opportunity to petition the agency to change its rules. Never did that. And that's not your argument here today. I'm just trying to think about, you know, from our point of view about why do we bend over backward in this type of case? All right? Because you don't like the way the commission has applied the rule over time, and some of the commissioners don't like it either. But the FERC has stuck with it.
Your Honor,
All
FERC,
right, and the court, and it's stuck with it, and the court candidly has gone along with it. All right, so your burden is really high. And you're saying we have some good arguments, but I don't see the prejudice. And I've made some of the arguments for you in questions today.
this court made clear in cases such as City of Orville and Public Service Commission that would-be interveners are aggrieved by a denial of intervention. And in this case, as I just
How are
mentioned,
you aggrieved? What is the prejudice?
the specific prejudice relates to the procedural injuries related to the denial of intervention.
Right. And so you had constructive and actual notice, and that's the risk you took. All right? Why is the problem that the agency has to reopen this whole thing months later? Because, you decided other priorities.
That's because the administrative oversight or the consideration of D1I in Rule 214 is not determinative because it's not the same thing as B3 good cause. But even if this court
Well, I didn't see any legal argument that we have to construe the words good cause differently in B3 and D1. Nobody has suggested that.
Your Honor, American Whitewater did state that in their briefing, and this court did decide that.
I know you
They're
said
textually
it.
different questions.
Yes.
They are textually different good cause questions.
Yes.
Yes, Your Honor. And this court decided that they were different types of questions in the Swanson mining case. And the reason for this case, the heart of this case, relates to the arbitrary and capricious nature of FERC's decision-making.
But I'm getting at, what do the words good and what does the word cause mean? All right? And we have some understanding of what FERC thinks they mean. And we have some understanding of what at least two commissioners think they should mean. But, the majority of the commission hasn't adopted those dissenting views. And so we have the rule as it is.
The commission has not, you're right, Your Honor, the commission has not clearly stated what good cause means, but the two.
So then it seems to me a party coming before us would have to argue why those two words should be understood differently in B3 as opposed to D1. And I didn't see any argument there. I saw an argument as to what factors the agency should have considered. But that's a different issue.
Your Honor, American Whitewater did brief this issue and discussed how B3 good cause and D1I ask different questions. D1I asks what prevented the proposed intervener from filing on time.
Yeah, I thought that was a very sophisticated argument. All right. And you made another very sophisticated argument like that. And that's why it's just amazing to me that American Whitewater waited for 9 months.
Your Honor, American Whitewater doesn't dispute administrative oversight or the length of delay, but the length of delay, as Judge Millett pointed out, is not a factor in the Rule 214 analysis. FERC has not announced in any of the cases that it cites that a set number of months should relate to D1I. And Judge
FERC says, hypothetically, this is the case. You have a sophisticated litigant who's before us all the time. It had constructive notice as a matter of law, and it had actual notice. If there is ever a case where we have proceeded, we should apply the rule here. 9 months under those circumstances just doesn't come within our rule. And there's no explanation as to why you couldn't come in earlier, much less on a timely basis.
The administrative oversight, Your Honor, is not determinative. FERC has on many occasions decided to grant late intervention in cases of administrative oversight, as Judge Millett pointed out. And
I know, But my point is, why can't the commission say, we have this rule, everybody's on notice, there's B3 and there's D. And D says may. Okay, we're going to apply B3.
FERC could do that, Your Honor, but they have not done so in this case. And in the words of recent FERC
Why
Commissioner,
do you think they haven't done so in this case?
Your Honor, it's not clear why FERC decided to decide American Whitewater's motion in the way that it did, but it's.
I read why they said they denied it. They said no explanation, administrative convenience, and we've said that's not enough alone. You're a sophisticated litigant. You had constructive notice. You had actual notice. And a lot of time has passed. And we're going to consider your comments anyway.
I apologize, Your Honor, if I misspoke. I was speaking to the hypothetical where FERC did explain how it's not been inconsistent in its past practice. But you're right, FERC did list those explanations. And as to your Honor's questions about the experienced nature of American Whitewater, FERC has never stated that that's a principle that it's going to apply in the application of Rule 214.
Well,
Haven't
FERC
applied
could
that
look-
rule since.
Excuse me, go
Oh,
ahead.
sorry, no, you go ahead.
No, you.
I mean, if they were adopting a new rule there, then we would expect to see that having been applied since your case, right? And, I mean, have cases since yours denied intervention because a sophisticated party couldn't show good cause?
I'm not aware of a case where there's been
We've done the opposite, right? Right, PJM, we reject your good cause, but we're going to let you in anyhow.
Yes, Your Honor. And in certain instances, like the one.
They weren't adopting a nuclear rule in your case.
No, Your Honor. They have not been clear on why in some cases they allow for administrative oversight decisions to go forward, and in other cases they do not. And as this court held in Airmark Corp versus FAA, where a court is dealing with different decision-making criteria, and in that instance, they had 5 different criteria they were applying to exemptions from noise standards, the court still found that they had to apply those 5 criteria consistently across parties.
Do you have more questions? I just wanted to follow up on Judge Rogers' prejudice question. And your prejudice, normally what we see is an explanation of prejudice as to, what happened before the agency. And I'm not sure that in Public Service Commission that it was a different proceeding and they were kicked out at an early stage and the proceeding went on without them. It wasn't like an environmental assessment here where they said, but go ahead and do your comments and we're going to consider your comments. Is there a case that says the prejudice can be just your ability to seek review in a court as opposed to prejudice before the agency's process itself?
I'm not aware of an analogous case for American Whitewater's posture, Your Honor, but the only cases that either party have cited with respect to standing purposes for a denial of intervention have found that the petitioners have standing in those cases because of the procedural injuries associated with a denial.
Where do those I guess I'm asking you where those procedural injuries usually happen. Usually it's before the agency itself. Collaterally, that limits your ability to come here. But there also is some prejudice before the agency. This is an unusual one because it's an environmental assessment and anyone in the world can comment on it. And so you did. And as Judge Rogers explained, your comments were taken and were considered. And so I'm trying to understand if there's a case where prejudice was exclusively nothing. You weren't prejudiced before the agency by not being allowed to intervene. Your sole argument of prejudice, as I take it, and correct me if I'm wrong, is that but now we can't seek judicial review. Is that am I right in understanding that that is your sole argument as to prejudice?
That's the correct posture right now, Your Honor. And as I mentioned earlier, there's not a specific case that decides this exact issue that I can point Your Honors to, but the only cases, as I mentioned earlier, that have decided this question have found that the petitioners have standing. And while Public Service Commission.
I'm talking about, I mean, we have mootness issues here, but also, if you're not, I'm trying to figure out if it would take some sort of expansion of our laws that require a showing of prejudice to say, or our laws of our case precedent, to say that it's sufficient if your prejudice is, if your denial of intervention did not affect your ability to submit comments, have those comments addressed before the and that's what the agency process was, considered as part of their decision-making process. You're just prejudiced in seeking judicial review. You're not aware of a case like that?
No, Your Honor, the best case I can point you to is the Public Service Commission case where it
Was that an environmental assessment case?
No, Your Honor. And it's not clear that in the standing case law or the mootness case law for EA versus EIS, it's not clear that the courts or FERC draw that particular distinction.
No, but I'm talking about we do sort of have, as Judge Rogers noted, a requirement of a showing of prejudice from procedural error, alleged procedural error by the agency. That's the body of cases I'm asking about.
So the concrete injury that's related to the procedural denial of intervention here is that American Whitewater's members would recreate on this portion of the river if the dams were moved.
That's your Article 3 injury. I'm talking about, maybe I'm just not being clear, the prejudice to you from not being allowed to intervene. That's not a standing question. You were able to communicate those recreational interests to the commission. You made your comments. They were considered by the agency. You don't dispute that. So that was not your prejudice before the agency.
As I see
Were you prejudiced? Tell me how you were prejudiced before the commission by not being allowed to intervene.
Your Honor is correct that the specifics of the prejudice relate to the right to judicial review of a flawed surrender order decision.
Okay.
And in this instance, as I mentioned earlier, the fact that FERC changed its
I
mind.
understand you have a petition for review on that issue. Okay. Do you have more questions? Do you have any more questions?
I do. So I'm just trying to understand. I thought you had said that it wasn't just the right to appeal as an intervener, but there was also a substantive issue on rehearing, which perhaps complicates things somewhat because that's the thing that cannot be addressed in light of where the process is at this point. Because it seems to me that if it were just the right to appeal, public service might support that there's no mootness and the remedy is you get to appeal, because there is language in public service says if you could be deemed to have been an intervener from the time of its application to intervene, and that under such view, it could be deemed to have been a party in the fullest sense throughout the proceeding, and thus it could be deemed to have been a party to the proceeding at the time of the final order. And on that conception, your petition to review the final order would be properly here. I think that chain of reasoning would support a finding potentially. If we rule in your favor, it gets, again, this is hypothetical because you've asked that they have to, the agency would have to apply the rule, and in whatever way we say they're supposed to, they would still have discretion to deny you.
Mhm.
But theoretically, if you were supposed to be in, then I guess that would just mean you could appeal based on this reasoning. And it wouldn't necessarily have to get back into the sticky, getting back before the rehearing and the arguments and et cetera, and the deadlines. Anyway, so it struck me that there is a pathway to it not being moot if the only thing before us was whether or not you can appeal or not.
That's correct, Your Honor. The Public Service Commission case does support the ability for this case to go forward and for the petition for review in the related case.
But you said there's something in addition to just the appellate rights.
What I believe you're referencing, Your Honor, is the statement that I made to Judge Millett about American Whitewater's members being able to recreate on this portion of the river.
Oh, and in response to a question I asked you when you were first before us, I said, is the only thing before us your right to appeal as an intervener? You said no, because there were comments you made on rehearing that weren't considered because you weren't a party.
Adequately considered.
Yeah. Yes, sufficiently considered.
And
Yes.
That issue, Your Honor, is wrapped up in the issue of appeal because whether or not FERC adequately addressed the environmental justice rationale switch up was something that was made in the request for rehearing as part of that appeal process for the surrender order decision.
Okay, I'm just figuring if that's not available. And then my other question was just, and there have been some talks about the equities here, and I am wondering why you didn't move to expedite this appeal, because I think we're in a little bit of a pickle because of the timing. And it seems that if that was your fault and as Judge Rogers said, you're asking us to bend over backwards to figure this all out for your benefit. And I just don't know why we should have to do that when you didn't throughout this case, you've not taken a bunch of procedural steps that you should have. And you're leaving it to us to kind of figure this all out for you.
Your Honor, at the time that we were briefing this issue, we believed that the mootness issue was not going to be relevant because of this court's precedent in American Whitewater versus FERC and the Public Service Commission case. So at the time, we didn't believe that an expedition was necessary because of those particular proceedings.
But you didn't know.
Well, American Whitewater wasn't an intervention case.
Yes, right, no.
That's correct, Your Honor. But in terms of how the related case and the mootness issues there of if American Whitewater can properly seek judicial review in that case relates to American Whitewater versus FERC, that is how that issue is relevant.
But there would be a point at which they can't reopen the order anymore. There must be some timing problem even there.
Your Honor, it's not clear if there is.
Lose jurisdiction.
But this court in American Whitewater versus FERC found in a situation that if FERC happens to lose jurisdiction after a petition for review is filed, that doesn't moot the case because this court can vacate the surrender order and then
Right, because a party had moved.
Mm-hmm.
We're back at the beginning. Are you a party? Not yet.
That's correct, Your Honor. And that's where the Public Service Commission case comes into being.
No, you keep going back to that.
And also you didn't ask for any vacator of anything. I know that there was no order at that point, but it was foreseeable it was going to happen.
Right.
And all you asked for was a remand to reconsider your intervention motion. So again, we're trying to figure out what to do about this and you didn't lay it out.
It's my understanding, Your Honor, that 16 U.S.C. 825 LB would prevent American Whitewater from seeking vacatur of the surrender order in this proceeding because that's not something that was raised on.
But not seeking it, but at least saying that there was a path. I think it was just foreseeable that the surrender order would happen. There would be at least a mootness question to us, even if it wasn't clear to you. And if you have all these ideas about why we shouldn't be concerned about that, it would have been incumbent on you to let us know or somehow put it in your briefs because now we're in a little bit of a bind. And I'm not, we don't love to ask for supplemental briefing. It slows things down, et cetera, complicates things. But I'm not sure what to do about where we are. And it seems a lot of it is your fault, I guess, is for lack of a better way to put it.
Well, Your Honor, the burden to prove that a case is moot or the burden to prove that vacatur is not necessary lies with the defendant or the respondent in this case. And FERC did not at any point in time after the opening brief was filed state that this case should be considered.
You were denied, the final FERC decision denying intervention was 11 months before the surrender decision. Right? January to December, is that right?
I believe so, Your Honor.
Okay. You never at any point asked for a stay of proceedings. Your reply brief notes that the surrender decision has been made. You didn't ask FERC for a stay.
No, Your Honor.
I guess last Friday, probably as preparation for oral argument, you filed your administrative stay request, but you did, that was months after their surrender decision. And so you were filing petitions for review, but never asked for stays, never asked for expedition. Had you moved promptly to ask FERC to stay this decision after it issued the surrender decision in December, then all of this could be, seems potentially at least an easier knot to untie than it now is. And you didn't, in your reply brief, address mootness at all. You didn't cite Public Service Commission there and say they've surrendered it, but it doesn't, you say, well, and we're going to file a petition for review. And you did it on what the next to last possible day. You weren't acting expeditiously.
Well, Your Honor, the mootness issue, as I stated previously in my answer to Judge Pan, it's the defendant's burden to raise these issues and to prove that mootness or that vacatur is unnecessary.
You're the one seeking action from this court, and the only thing your reply brief asks for, knowing that the surrender decision has now been made, again, is a remand of the intervention decision. You don't anywhere argue the impact of the surrender decision on whether there's even a proceeding we could order them to let you intervene in.
Your Honor, not to sound like a broken record, but the Public Service Commission case
I'm
does.
just wondering why you didn't do any of these other things. I mean, it's not uncommon when these things happen to say, hang on, stay that decision. We've got a serious intervention problem here. And rather than have everything go forward, let's put the brakes on this, sort out intervention. And then we can figure out what to do with the surrender order. But instead, time limits ran for everybody to petition. You do a reopening. I don't know what they have to let everybody back in case FERC were to say, yes, you should intervene. Yes, we're reopening. Yes, you're right. Does everyone else have to come back into that reopen proceeding and they thought they were done?
Your Honor, to answer the earlier part of your question first, it was unclear before briefing was issued in this case whether or not when the surrender order would be issued. It's my
Not
understanding.
unclear in your reply brief.
That's correct, Your Honor. And that's because the surrender order was issued the day before the reply brief was due.
Yeah, you can ask for an extension motion to address it. You can ask for supplemental briefing.
I understand, Your Honor, but it was not clear when FERC would issue the surrender order because it's my understanding.
Why didn't you reply brief where it had been issued at that point? And I get it was last minute and lawyers will say, hang on, we need another week on our reply brief. It's not an expedited case because this important event has just happened.
Your Honor, the reason for that is because it's the respondent's burden to raise these issues and to prove that mootness and vacatur are actually.
You want relief. You got to keep the case alive while it's in this court. I don't think you can slough all this off on the commission. The commission's brief was filed before the surrender decision. They had nothing to address in their brief on this issue.
I understand, Your Honor, but the mere fact that American Whitewater didn't move to expedite briefing does not mean.
Or seek stays or address the consequences of the issue surrender order in the reply brief. Or ask for supplemental briefing there so they would have a chance to respond on the implications of the surrender order.
That's correct, Your Honor, in part because, as I stated earlier, this court's precedent in American Whitewater versus FERC and the Public Service Commission made clear that FERC cannot moot the intervention denial petition for review in this case. So American Whitewater was under the impression that this court's precedent was clear, and so that particular issue, unless raised by the defendant, did not need to be further clarified.
Did you send in a 28J letter on Public Service Commission?
No, that opinion is cited in our briefs, Your Honor, for different propositions, including for the standing issue.
Okay. Any other questions?
No.
All right. Thanks to everyone. We kept you up a very long time on the complexities of this case. It is now submitted. We will take a 5-minute recess.
Stand. This honorable court is again in session. Be seated, please. Case number 25-5041. Vanda Pharmaceuticals, Inc., Appellant versus United States Food and Drug Administration, et al. Mr. Hughes for the petitioner, Mr. Peters for the respondent, Mr. Burgess for the intervener appellate.
Good morning, Ms. Hughes. Thanks to all counsel for their patience.
Good morning, Your Honor. May it please the court, Paul Hughes for Vanda Pharmaceuticals. With years of work and millions of dollars of research, Vanda brought Hetlioz to the market. Hetlioz treats non-24, a disorder that primarily affects blind individuals.
And what's the second thing it treats?
SMS, Smith-Magenis syndrome. It's a genetic disorder that affects principally children. So there's both a capsule form and Vanda sought and obtained the first ever FDA approval to have a drug label with Braille on the label. Now, generic drug makers have entered the marketplace. One of the generics, MSN, did put Braille on their label.
How many generics are in the marketplace?
There are 3 generics currently in the market.
What happened to so it's one app, so it's Apotex, MSN, and Teva or Teva?
Teva, Your Honor.
Teva.
Yeah.
MSN, Apotex, and Teva.
Correct.
Apotex doesn't use Braille.
They do not, Your Honor. That's
You
correct.
haven't sued them.
Well, Your Honor, when we filed this lawsuit, they had not yet entered the market at the time. So what the timeline in the case was, this lawsuit was filed initially after Teva had entered the market, and that's when we first found out that they were not putting Braille on their label. Apotex did not enter the market for a significant period of time after which period of time.
A citizen petition there?
Yes, Your Honor, I believe we do have a citizen
And you
petition.
challenged the ANDA in their case too?
We have not yet challenged the end of their case on the basis of the Braille issue. Again,
So I'm just trying to figure out, is the time run or not yet run on this challenge?
No, Your Honor, we have 6 years from the ANDA approval, and there's even more time from the citizen petition denial.
Okay.
Again, recognizing it's a common legal issue, I do think this would govern both Apotex and Teva, but we've not yet sued over the Apotex ANDA.
Oh, we don't know. I mean, you haven't challenged the agency's decision-making on the ANDA, and we don't know what their explanation would be in the Apotex case. I'm just trying to figure out remedially, you argue about injury from competition, but if there's another generic out there doing the exact same thing, presumably these other generics are just going to fill up the demand. Is there really a concrete injury change if you take one player out, but there's 2 more generics already out there, and as of now, you've done nothing to challenge one of those generics, which also is not using Braille?
So several responses to that, Your Honor, to the extent the court's asking about a standing issue. Obviously, standing.
Can we address it?
There's been no challenge to standing. I think that's for good reason. There are many aspects to standing. There's, of course, competitor standing. So having, one competitor not in the marketplace, that would have direct implications, even if other competitors exist in the marketplace, because in pharmaceutical pricing, it's a complex issue about drug pricing, but the more competitors are, that has effects on price. But setting that aside, the real reason Vanda is here is Vanda created the marketplace for tasimelteon for Hetlioz. It's a market that is principally used by blind individuals. And when Vanda did so, it was really important to the company to have Braille on the label for the product. FDA has made the determination that generics don't have to have Braille on the label, and we're here challenging that. If we succeed in this challenge, we would certainly continue to press that claim to Apotex if FDA itself doesn't require that labeling change to Apotex if we prevail on the principal legal question. But again, the nature of this case being against Teva is, I think, an artifact of it's the case that just Apotex didn't go on the market for a substantial period of time after Teva had entered the market, and we didn't know what their label was going to be. And this case was already well launched at that time.
Could you have filed a more timely citizen petition that said, whatever you do, make sure they have to use Braille?
I mean, Your Honor, we filed a citizen petition within a few weeks of their launch of the product, which is when we first learned that they weren't using Braille.
No, you knew they were going through, did you know they were going through the ANDA process?
We knew there were generics going through with ANDAs, yes, Your Honor.
Okay, including, did you know the names of the generic companies? I mean, did you know it was Teva and Apotex?
Yes, there was patent litigation. Yes, Your Honor.
Okay, and so you knew that was all going on, and you didn't tell FDA back then, well, in our view, labels have to have Braille on them.
Well, and MSN's label did have Braille on it. I don't think.
I know, but you didn't, was that just happy coincidence for you, or?
Well, no, we think MSN followed the statute. The statute says we have the same label. I'm sure we'll be talking about that, but I don't think Vanda had to predict that, in our view, FDA was going to violate the statutory same label requirement, and that we had to go remind FDA, here's what the statute says, please apply it in these circumstances.
This is a pretty unprecedented application of the statute. I mean, that's not for the merits one way or the other, but I'm not sure one could have assumed that so comfortably.
Well, and let me be clear, Your Honor, we're not here on an injunctive relief request. We did file a preliminary injunction in this case. That was denied. We did not appeal that. So if the court is asking, what are the equitable factors, to be sure, I don't think any court has said one has to file a citizen's petition in advance of a launch, hypothesizing ways in which a generic could violate the Food, Drug, Cosmetic Act and ask FDA to stop it. I don't think there's any part of diligence that would require that. Here, this was filed in January of 2023, which I believe was about 3 weeks or so after the launch.
Same day as the Apotex citizen petition?
It may have been. I'll go back and check that, Your Honor. But it was launched very quickly. So there was absolute diligence. But I think that inquiry also would only be relevant if we were talking, for example, on the preliminary injunction posture, where those equitable factors would really weigh. We're past that at this point. We're not asking for a preliminary injunction in this case. We're asking for a ruling on the straightforward legal question where the parties have cross moved for summary judgment as to was the ANDA and also by consequence the citizen's petition denial correct as a matter of law in saying that the removing of Braille was appropriate exercise of the different manufacturer exception to the same labeling requirement.
No, the difficult, this is not a standing question at all, but I am I correct that the citizen petition was filed and then lawsuit sort of 6 days later? Is that right?
Yes, Your Honor.
So the agency never had a reasonable chance to act on the citizen petition before the lawsuit.
Well, what happened, Your Honor? Sorry. We filed the lawsuit because we went to the agency. We asked the agency for immediate relief saying, this is really urgent. We want you to have Braille on the product. The agency did not act. Yes, it was within a matter of days. We then filed a preliminary injunction asking the court for immediate action. We were not successful with that. We had parallel actions before FDA and the court. And then the court wound up staying the litigation in the district court pending the resolution of the citizens petition. So I agree, the exigency that we raised and we pressed, we did not prevail on, but that's also just not before the court at this point. And the court did wait for the citizens petition to be resolved and then allowed that to come into the case. And we had cross motions that went to both the ANDA approval as well as the citizens petition decision.
And so how do we think about, so because you have a briefer decision of the ANDA stage about the Braille labeling.
Yeah.
A more thorough one. Had more time, I guess. I don't know. We're more aware of the challenge at the citizen petition stage. Do we consider one of your arguments, to the extent you're arguing that they gave insufficient reasoning at the ANDA stage, but if they gave the more thorough reasoning you want in their answer to the citizen petition, what would be the point of, does that overtake your?
I think our arguments.
Those particular arguments.
Yeah, when we talk about.
It's not your contrary to law, your arbitrary and capricious arguments to the ANDA.
Your Honor, I think we're willing to agree that for our arbitrary and capricious arguments, we will take into account all of FDA's reasoning. I think arbitrary and capricious arguments still withstand all of FDA's reasoning in the citizens petition, but I do want to focus.
Sorry. You didn't make, in your briefing, as I understand it, arbitrary and capricious challenges to the citizen petition decision. It was just contrary to law.
No, Your Honor, I understood our briefing for the arbitrary and capricious was looking at the FDA determination as a whole, both the ANDA decision and the citizens petition. Now, I suppose what is a technical matter, what we're asking the court to set aside is the ANDA decision. And so that is for APA matters, what it is we are technically asking the court to set aside. But I don't think we would object to the notion that material that the FDA decided in the citizens petition would be relevant to the court's consideration. We're not asking the court to close its eyes to the citizens petition decision. But as I said, the focal point of the brief is the contrary to law argument, which I think is common to both the ANDA approval as well as the citizen petition. It is a straightforward question of law. Does the manufacturer exception to the sameness requirement do the work here? And we think the answer to that question is straightforward, just no, it doesn't. To start looking at the textual analysis, I think we have to begin with the principal rule rather than starting with the exception. And the principal rule here is the requirement that the generics label be the same as the branded products label. This is one of the many sameness requirements. It has to be the same active ingredient and has to be the same dose. Other kinds of sameness that Congress required in order to provide generics the abbreviated process through which they can bring their products to market. So that is the principle.
Other sameness requirements, the other ones, and it's the whole lot of sameness required in the ANDA process.
Yeah, it's
identity, or do they require sort of substantive or sameness as the substantive, the material?
Well, so I think it depends on the sameness requirement Your Honor's considering. For example, the active ingredient requirement, it is the identical substance. Similarly for dosage, it has to be the same dose. If it's 20 milligram as the branded product, the generic product has to be 20 milligram. Route of administration, again, that needs to be the same unless there's a petition that's providing a distinction for route of administration. So it is a direct sameness requirement. I think that the district court pointed out in the bioequivalence test standard, there is a sameness of bioequivalence, but just given the nature of clinical testing, there might be some minor variation in test results for bioequivalence the statute takes account of, but it's still, I think.
Well, compositional variations.
There's going to be some right. And there will be compositional variations because there are places in which the generic is able to make decisions about its product that changes from the brand product. So it is not an absolute identical carbon copy, and that can include things like inactive ingredients. So a generic can choose to use different inactive ingredients from the branded product. They can have different shapes of a capsule or a pill. And those are things that a generic has the ability to have some distinction.
It's like material identity, material from the viewpoint of the ANDA process, what we're talking about here, safe and effective drugs.
Yes, sir. I caution, I wouldn't necessarily say these things are immaterial. They can certainly matter. But what Congress said is there are certain things that need to be the same, and there are other things that generics are going to have the ability to choose. Now, even for those things they have the ability to choose, it's not freewheeling. The FDA still approves those things, but it's not to say that the inactive ingredients have to be precisely identical, and nor does the process of manufacture have to be precisely identical. Another area where there does not have to be identicality of product that factors into some of the cases that get discussed is the Romanet 8, which allows an ANDA application or an ANDA applicant, the generic, to apply for only a subset of indications. And the generic may do that, called a skinny label, in order to avoid exclusivities for data exclusivity that the FDA would hold or patent rights. So those are the certain kinds of permissible changes that generics can absolutely make. And so that situates what the
label provision now, which is what this case is about. Obviously, absolute identity is not required or even permissible, right? There have to be changes, but they have to, for obvious reasons, FDA polices them very carefully with a lot of detail to make sure that they aren't variations that bear on safety and efficacy, of the drug.
Oh, I think it goes more than that, Your Honor. What the label, the principal rule, the sameness, says it has to be the same label. And what the Supreme Court in Wyeth and then
Just agreed, same doesn't, I get the statute says same, but we've agreed, I thought we just agreed that same doesn't mean identical. I didn't think you disputed that there was going to be ways in which this thing is not identical.
Well, so I think let me parse two distinct things. I think there is what we call, and this kind of took a life on its own with the district where we disagree with some of the things the court said. We do think for the principal rule of sameness, there is a de minimis principle that would apply, that you would say two things are legally the same, even if they are not precisely identical. So you look at a label and you can see de minimis changes. You wouldn't necessarily.
Permissible de minimis. That seems to me something that might be in the eye of the beholder. But I mean, it seems to me that there are certain things, a lot of things that have to be identical, certainly in content.
Mm-hmm.
You said the dosage thing, that there's 20 milligrams. I mean, that just has to be the same as part of the drug itself being legitimately used. But also for obvious reason, you have to accurately identify that dosage on the label. So that's going to be the same. Same font?
Same font. Well, there'd be some trade dress issues, but I think
Apart from trade dress, assuming, because there are actually a lot of regulations even about what size and what has to be in bold or not, but assume that's all complied with, can they pick a different font?
If it is, again, this goes to where we think you would have a de minimis change. If it's not actually changing the readability, it is effectively the same thing. It's not conveying different information. Right. It's not harder for somebody who might have vision difficulties to read. I think we would say that's a de minimis change, so it qualifies as the same. And you don't get into the exception for the different manufacturer. We would just say that's the same for effective purposes, the same label. Right. And let me be clear, that's not the argument that FDA or Teva has adopted here. They could have suggested an argument that this label is the same, so you don't even have to look to the exception, but they've never advanced that, and that's not what the FDA held. So from Chenery principles, I don't think that would be an argument that would be available. And I'm happy to give the court citations, but I'm sure the court's aware.
But I mean, it's if it's not, something isn't required by sameness, then it would be within a different manufacturer's discretion, font size.
Yeah, and again,
that could be, I mean, you want to put it under de minimis, which the statute doesn't recognize, but I don't know why that wouldn't also be, its changes made because they're a different manufacturer.
Because there's nothing required about it. It misses the required element of that exception. And so that's the key thing I want to talk to you. But to answer the court's question, we think those examples are not being dealt with in the changed required exception. They're being dealt with by the principal rule of what does it mean to be the same. And you can have two labels that have different fonts, but as a legal matter, because the law doesn't deal with trifles, we would say these labels are the same for legal purposes. Now, if FDA had wanted to make the argument that that principle sweeps in Braille and Braille isn't this is lacking Braille is the same, they could have suggested that. They didn't. I think there's a good reason they didn't, and that's because Braille really matters. It matters a lot to the blind community, so it's not a trifling issue.
I mean, that's your argument. I think the FDA had pretty strong arguments that it doesn't make a difference, but
if I
put that aside.
What I'd like to talk about is what
you could say then, if someone instead of Braille made the information super large and super bold to help with those not completely blind, but those with impaired eyesight.
But if I could talk about the change required.
Would that be legally the same?
Probably not legally the same, Your Honor, and it would run afoul of the sameness requirement as what the Supreme Court in Pleva and Wyeth said. And Pleva is, I think, pretty important because Pleva, in that case, the Supreme Court found preemption of state law on the basis that a generic could not go and try to put additional nice to have safety warnings on a label, even if the generic wants to do so. And what the Supreme Court's determination is these things that even might increase safety or make the statement better on efficacy are outside the scope of what's allowed, that it has to be the same label. The only exception to that is if you're in the change required. And so what does change required mean? Our principal submission is for the main rule, the sameness rule, to have any effect, and for the word required to do work. There has to be something external to a generic manufacturer's desire to change the label that requires that change. And there are a whole host of things it could be. So,
I mean, the difficulty here is because it's a generic, there has to be a change, even to what would be in Braille, right? You have your brand name in Braille and then the 20 mg. That's it. Obviously, they're not going to have a brand name in Braille. So is your position that they just have to put 20 mg in Braille?
They do what FDA
Position for that the law requires them to have in Braille.
So I think what FDA did with the MSN is the answer, which is MSN has, instead of Hetlios, like over the box, usually you'd have in Roman script Hetlios, and the generic, instead of having Hetlios, has tazameltine. That is a change that's required.
You have tazameltine right there, almost interwoven right under your name, but you did not put the active ingredient in Braille. So that is not the same. Having an active ingredient in Braille is very different from not having it in Braille.
First, I would say, though, I want to get to that in a minute, but the 20 mg is definitely could be a requirement that's the same in that MSN copied the 20 mg directly. But what MSN also did that FDA approved, and we think is the way you operate.
I understand that they approved them putting the active ingredient in Braille, but you're the one who's saying it's got to be the same. And yet your label does not have the active ingredient in Braille and theirs does. Does it? And your argument is it's safer because now someone using this medication who knows Braille will be able to find out what the active ingredient is in MSN's product, which could be very, very important for a lot of safety and health reasons, which they can't find on your label. Right?
Well, they know it's Hetlios and somebody's.
I know, like, I don't know how many people think the name brand means much of anything.
Well, I think our customers who've been using Hetlios for a decade plus know actually what Hetlios means more than they know what Tazimelteon means. That's more, if anything, indicative. But that's where you have the
So
yes.
there's no point to having the.
No, but this is where
Alex.
why you change the label from Hetlios to Tazimelteon on the label in script. You do the same thing with Braille. That would be a change required. But at the very least, there's
I'm a little worried that having the active ingredient be in Braille on the generic when it is not in Braille, if we take as given your safety arguments for people to understand what they're taking, yours is not in Braille. Theirs is. I mean, there's no, anyway,
well,
that is actually changing the label's assertions of safety or demonstrations of safety as to this drug, because now people can tell what the active ingredient is in Braille, which they couldn't on yours. That's hard to think that that's just a de minimis label difference.
well, it's not a de minimis label difference, Your Honor. I agree with you on that. It's a change that's required by the different manufacturer.
There's nothing required that they take something that you don't have in Braille and that they put it in Braille.
First, this is setting aside the 20 milligrams.
Same about that. It's actually could be materially different.
I mean, I think Your Honor, the best upshot of your argument would be that you would not do the Hetlios to Tazimelteon, which I disagree with. But the 20 milligram,
Sorry.
my apologies, but the 20 milligram, that is, totally adjacent to this. And this point doesn't address the 20 milligram that would be on.
So I'm trying to understand your position, because I think for me at least, now I'm not an expert. You guys are everyone here is more expert than I am at this, but your argument is same means same means same means same, and what's required, and it's certainly not required that they put their active ingredient, that MSM put their active ingredient in Braille.
So
Is
it is required. I think it is
You don't
required.
have it. It doesn't need, they don't need to do it to amend
Because
the label.
what-
You just want a certain amount of Braille on the label?
No, what we want is Braille on the label that conveys the essentially the same information that's on our label.
I'm sorry, the name of a drug and what it actually, its active ingredient is are not the same thing.
But that is how the change required operationalizes,
How
because
do you get to pick that instead of our brand name, you've got to go to the active ingredient? What if instead they had put in Braille, keep away from children?
well, I think that would be a same label requirement. They would need to move to keep away in children to Braille. Sorry.
No.
No, you're saying if that
The
was,
generic.
oh, if the generic, then that would,
20 mg and keep away from children.
well, again, let me just start with
Would that be okay?
the base point. The 20 mg is sort of independent of this. So even if you don't like my argument as to Hetlios to Tazimelteon, which I think you should, I want to describe why, the 20 mg argument withstands that. So that is there regardless. But the reason why the Hetlios to Tazimelteon makes a great deal of sense, and that's what MSN did, is because when you look at the box label, the Roman script, you have Hetlios in large letters because that tells the patient what it is that is in that package. And then they'll have the active ingredient Tazimelteon in a much smaller script. That's allowed because Hetlios is the brand name for that product. When that product is switched to generic, for it to be the same, what generics do is put Tazimelteon into that large script. So that way the patient can understand what is in that package. And this, I want to point the court.
I guess I'm, just to explain what I'm not understanding here. And for now, we're tabling 20 mg. I get that could be identical between the two.
Sure.
Just table that for now. Your argument is all about sameness, and anything that's not required has to be the same. Now, it is required that they take the name Hetlios off their product for obvious reasons. And somewhere in there, they're going to change who their manufacturer. They'll say Tiva instead of Vanda.
Yes.
Okay, those are required.
Yes.
But your argument is that we've got to have it has to be the same. And so you need to have something in Braille that is not in Braille on the name brand manufacturer's label. And that doesn't seem very same to me.
Well,
And what I'm trying to understand is that you just want Braille on there so that someone could identify this as my, particular vision medicine as opposed to my blood pressure or diabetes medicine or something like that. Is that the point?
well,
Or it has to be,
it's
I don't know
both.
how we get from active ingredient and name brand being.
Can I, this will take just a moment if I can. And one just side point is at J 335, we do have active complaints from customers when their products have been switched who've called up the company to say there's no Braille on the product. What's that?
Did you say complaints?
No, it's a complaint.
I thought you said complaints plural.
My apologies, Your Honor.
Single complaint.
We have at least a complaint. I don't know if we have plural, but
If
we
you had
have.
more, you would tell us, I'm sure. So effectively telling us, how many people use these drugs combined, the name brand and the generics?
It is a very small patient population. So one is not an insignificant number against the patient population
Unless I
size.
know the patient population, I can't.
Your Honor, I don't know. I'd have to check with the client.
Are we talking hundreds?
Yes.
Not thousands?
I would have to confirm with the client. It's a small patient population. This is an orphan drug in a rare disease state. So this is we are certainly not talking tens of thousands.
So if I may, this is related to Judge Millett's point. This is the way I've been thinking about it, and tell me if I'm wrong. It has to be the same except for changes required because the new drug and listed drug are produced or distributed by different manufacturers. What is in Braille on Vanda's label is the name of the drug, Hetlios, and the dosage, 20 milligrams. You have to change Hetlios because that is required. It's a different manufacturer. But the Braille-ness of it, you don't have to change the Braille-ness because it's required by a different manufacturer. And this is evidenced by the fact that MSN has a Braille label and it didn't have to change it because it was a different manufacturer. But the content of what's in Braille has to change because it's a different manufacturer. It can't say Hetlios. It has to say whatever Teva is calling the drug. And the Tasmeltian part of it also goes to showing it's a different manufacturer because the patient population knows Hetlios is whatever the active ingredient is that they need, Tasmeltion. They associate it with Hetlios. But the Tasmeltian part of the different manufacturer shows different name. Consumers never heard of this before. It's a new drug. Tasmeltion shows that tells the consumer it's a different manufacturer, but it's the same active ingredient that you were having before. And that's why Tasmeltion can be considered, although I don't know if it's strictly required, but required because it's a different manufacturer. The name would show it's a different manufacturer, but the Tasmeltion also shows it's a different manufacturer with the same active ingredient. So it seems to me like the Braille-ness has to remain because that can't be changed because it's a different manufacturer. And the content of what's in Braille has to identify the drug, the name of it, and in this case, Tasmeltion to show it's not Hetlios, and then 20 milligrams.
I agree completely, Your Honor. And the point is, it is a combination of the sameness requirement being married with a change required in that specific instance. The sameness is you keep the Braille. The change is Hetlios is changed to Tasmeltion. In the same way, you would have the sameness requirement where in Roman script, the major feature of the Vanda package says Hetlios in Roman script. That large script that tells somebody this is what is in the package, that has to remain. What gets changed is instead of it saying Hetlios in Roman script, it is changed to Tasmeltion in Roman script because that is a change required. Just because it's a change required doesn't mean.
Does it just say Tasmeltion or does it also have like some name like Hetlios?
The generic does not say Hetlios. That's a copywritten name, so they don't put.
No, but do they have some different copywritten name?
It does not.
So all it says is Tasmeltion.
Yes, Your Honor. All it says is Tasmeltion.
Okay, so that's what shows that it's a differerent manufacturer.
Correct.
That is Tasmeltion and not Hetlios.
Correct, because that's demonstrating it's the generic.
Different manufacturer is whether it says Vanda or Teva.
It's true that they would see that as well, but
Those
for,
aren't in Braille.
they're not in Braille.
Bottle or generic.
But it's also,
Shows a different manufacturer. That's what's required by being a new manufacturer. Putting the active ingredient in
Well-
Braille is neither same nor required.
well, and the example, the analogy to Judge Pan's hypothetical is if Vanda had put Vanda in Braille on the label, that would be the change. But let me be clear about this. This is not just, free reign that Vanda puts whatever it wants on its label. This is approved by FDA. Vanda had to petition FDA to say, this is a drug that we know is principally going to be used by the blind population. We want to do something that allows these people to identify their medications. So FDA approved this. This was not a.
Just following along though,
Yeah.
on Judge Millett's chain of thought. The original label says Hetlios. It cannot say Hetlios on the generic label for obvious reasons. It's different from Hetlios and they can't use Hetlios. So they have to put something because it's distributed by a different manufacturer. And so they've chosen to put Tazimelteon, but that is a generic name. So I guess what else could they have put there? They could have, I guess, come up with a name for their generic drug, but they're not required to do that.
Well, they can't, under other aspects of the statute and regulations. What Hetlios is, the brand product has a brand name for the active ingredient. The active ingredient is Tazimelteon. When the generics come with their ANDA, they have to put on their bottle
What did MSN put?
Tazimelteon.
Okay, and what did the other one put?
Apotex puts Tazimelteon.
So they all put Tazimelteon.
Because that's the generic name, Your Honor, and that's what FDA required. Teva and Apotex,
It does show that they're different from Vanda, but that doesn't show that they're different from each other.
what somebody realizes is this is a generic product. They're getting the generic version. It does not distinguish which of the three different generics that are in the marketplace. That's right.
So it does show it's a different manufacturer.
It is that
Vanda, but not a different manufacturer.
You are not getting the branded products.
The
You're
other
not
generics.
Yes.
Okay, but that's not showing different manufacturer even.
Well, it's showing that it is a.
It's not, it says you're not getting the name brand product. That's all it shows, because in fact, they don't know. And this could matter if there's inactive ingredients that someone has an allergy to. They don't know whether they're getting the Teva one or the Apotex one or the MSN one, because none of those are in Braille.
Well, Your Honor, let me be clear. Vanda is in favor of more Braille on the labels.
Really? Have you put more Braille on your labels?
Well, Your Honor, we're the first and only company who ever asked to put this.
That, but you said you want more. So are you saying if the generic here had put everything in Braille, that would be same?
Well, Your Honor, I don't know if it would be same under PLEVA, because PLEVA says going safer doesn't make it same.
Exactly. So you said you're in favor of everyone doing it, but they can't do more.
Your Honor, I was just.
Wait, but you can't be more safe.
But
And yet they're going to put an active ingredient in a way that is now accessible to those who read Braille and are blind, that your label does not. And so would FDA have to say, I mean, it feels to me like there's a PLEVA problem with what is now, you now want in Braille. If you said you've got to put Teva or Apotex or MSN in Braille, then at least that would be required because they're a different manufacturer.
Yes. So, Your Honor, just to start from basic points, just because this is important to put on the record, our company is the first one to put Braille on the labels. So the suggestion that we should put more on the label, I don't think we disagree with, but we're the ones who are trying to move directionally to put Braille on the label. And FDA is saying, we don't need to have Braille on the label.
Your name brand on there, but you never put the active ingredient on.
But we're trying to put in the essential information so a blind patient can understand, read their medication.
Name brand is more essential. Name brand. Advertising your name is more important than the active ingredient?
But this is like...
Is the name, your name brand, more important than the active ingredient? I think that's what you just said. Is that correct?
Well, let me be clear. How drugs are advertised in this country is the name brand is what everybody knows the drug as. People generally don't know the generic name.
I'm asking you a question. I mean, look, we're now well into there being generics on the market here. And I thought I heard you just say that having your name brand in Braille is more important to people who will only get information by using Braille than telling them what the active ingredient is they're about to take.
Your Honor, let me
That's
be
more important.
Can I answer this because this is important? I want to be very clear because I don't want to suggest that there's some more importance in marketing or something like that because that's not the case whatsoever. What is the case is that when a brand launches a drug, this isn't Hetlios, this is any drug, what you see on the packaging is generally the big splashy brand name. That is what is in big script. That's the Ozempic. It's whatever the answer is. And that's what the population, the doctor says, I'm going to prescribe you Hetlios. I'm going to prescribe you Ozempic. Whatever it is, that is what the doctor tells the patients generally they are prescribing.
There are generics on the market. That's during your exclusivity period.
And that's why a change required, instead of having the big banner that says Hetlios on the label, it instead has the big banner that says Tazimelty on the label. And the doctor tells the patient, well, now it's generic. And so Hetlios is the generic version is called Tazimelty because that's the active ingredient. But that's, I mean, again, what I'm trying to say is, that is how the drug marketing world works.
I understand that name brands have brands. I understand that. I am trying to ask a much simpler question since you brought it up and you've said it's really important, and I agree it could be here.
Mhm.
And mine seems very different to me to have a name brand in Braille, but not an active ingredient on one label, and in the other one to have the active ingredient in Braille, but not the manufacturer's identity. I mean, the reality is on your brand, there's two ways to find the manufacturer identity: name brand or Vanda, both of which are on the label. There's only one way for them. And you're the one who said it has to be required by being a new manufacturer. And that required changes. It can't say Vanda. It has to say Teva, Apotex, MSN.
I just want to remind,
Argue that those have to be in italics.
even if I'm wrong about all of this, just to be clear again, this doesn't say anything about the 20 milligram issue. And so the key statutory question we put before the court still exists with respect to that. But coming back to this, I think this is, candidly, Judge Pan did a better job articulating my argument than I did. But it's the point that what has to be the same is the Braille-ness, because that's what's there.
Well,
But that gets married to a change required.
Wait, but that got, so the Braille-ness, I'm not even sure what that means. You want some Braille on the label.
Yara, can I
That's
get,
why I thought I'd, but maybe I didn't.
can I
If it
just,
had 20 mg in Braille, what would your position be?
if it was just 20 mg in Braille, our position would be the same position. It needs to be the same. So the patient knows that this is 20 mg, and this will tell the
No, I'm
patient.
sorry, I wasn't clear. So if Teva had come along and said, we read plea, but we can't put an active ingredient in Braille, that would be an increase in safety if you believe that Braille increases safety. So we can't do that. So we're just going to put the 20 mg
Well,
in Braille. And would your position still be that, what would your position be as to whether that satisfies the same label requirement?
well, we would say it does not, but I appreciate from your honor's line of, suggested questioning, that may be a harder question for us, but I would still say it
And
does
the
not.
basis you would say, and you would say it does not because they have to have more Braille on there?
Can I just go back to the example of the main label itself? So our label says in big, large letters, Hetlios. They can't say Hetlios, but they do have to say in big, large letters, change required, Tazimeltian, because that's the generic name of this.
Did you have to say on your label Tazimeltian?
In very small script that's underneath it, not in the large letter font that is prominent to the patients. And
So I'm looking at, let's see, whose brief is this? It's your brief. At 13, picture of the label. And under the brand name is the active ingredient not in Braille?
yes, Your Honor,
It is not.
it is not in Braille. What is in Braille is Hetlios and then 20 milligrams.
That's right. I just wanted to be clear.
Yes. And what
And let me say the reason I'm not clear is because, at least on page 13, the MG, the 2 in 20 is lettered in Braille, but not the 0 MG. But you're saying all that is Braille, and the only thing that's not Braille is what's in what, the Tasmanian and the word capsules?
Yes, Your Honor.
Okay,
Wait, no.
20 mg is in Braille.
Sorry, Hetlios is in Braille and 20 mg is in Braille. I apologize if I
no,
misunderstood.
right, that's what we were just saying. All right, but I'm just telling you, the picture here doesn't give that sense, because some parts of when I looked at this, I thought, well, not all of the dosage is in Braille, but that's wrong. Then what's below all this?
Well, yeah, Your Honor, this might be confusing. Let me explain. This below, what this is depicting is a clear sticker that is overlaid on the label. And the above image shows what it looks like with that sticker attached.
Right.
So the way that this works is you have the bottle, you have one sticker that is the Roman language, and then you have a second clear sticker that has Braille that gets affixed on top of it. And so this bottom,
Just a copy of what's on the top.
yes, Your Honor, it's showing just the Braille standing alone.
Thank you.
So why isn't it the case that your label is your label? It's been approved by the FDA, gone through a rigorous process to get it approved, which is why generics are supposed to have the same label to piggyback off that approval process. Your label doesn't have Tasmanian in Braille, and the word required doesn't go to, what's required at that point. Your label is just your label. It just has Hetlios and 20 milligrams in Braille. And then to apply this statutory provision, it has to be the same except for the changes that are required because the new drug and listed drug are produced or distributed by different manufacturers. The new drug has to say something other than Hetlios. So it says Tasmanian, which is the generic version of Hetlios. And that needs to be in Braille because the fact that the identifying name is in Braille does not need to be changed because it's a different manufacturer. The use of Braille does not need to be changed because it's a different manufacturer. But what is said in Braille needs to be changed because it can't be Hetlios, because it's a different manufacturer. They can't use Hetlios. And it uses the generic brand because it shows that this is the same as Hetlios, but it's the generic version. And it has to have 20 milligrams in Braille. So why doesn't that comply with the statute?
So, Your Honor, if I can compare page 13 that Judge Rogers pointed to page 17, which is Teva's label.
Yes.
What you see is in our label, you have the large script, which says Hetlios. And on page 17, it's no surprise that what you have here is in large script Tasmanian capsules, because that's the generic name of the product. That has to be in large script. So the change required is taking what is the very small script and is telling the active ingredient and turning it into the label of the product. The headline thing that somebody sees when they pick up our product is Hetlios. The change that must be required, because you have to have the headline thing, the label of the product, that's FDA required. It now changes to Tasmanian capsules. That is a change that has been required from one label to another label.
But the change from Braille is not.
Well, and so my point though is they could not have, if you look on the left side where you have where it says usual dosage, they could not legally have Tasmanian capsules in script that looks like that, that's not prominent, that does not tell the user what it is. They have to replace Hetlios with Tasmanian. That is a change that is required.
Is that part of the same label requirement that they have to do that, or is it separately required by FDA?
Well, I think it's both the same label, but also as part of FDA's regulations.
You think it's same label. FDA's maybe not, because they separately require that you have it. Do they require you to reveal the active ingredient on your label too?
I believe, yes, Your Honor.
Do they require your name brand to be a certain size?
I think they do, Your Honor. I can go back and look at this, but there has to be essentially a headline of what this product is, and that has to be of sufficiently prominent font.
But you could have chosen to have Tasmanian, just like these folks do, as the big name, and then your name brand in this very small print that you have the active ingredient.
I actually don't know if we could, Your Honor. I can look into that and give the court 28J if useful, but I don't know standing here if we can do that. Consistent with FDA's labeling requirements. I just genuinely don't know, Your Honor.
But it's Tasmanian is not It is the name of the medication. That's what a generic does. It does the name of the medication, the active ingredient in the medication. And all the generics have that exact same name. So unlike am I saying it? Heliox? Helios, sorry. Which identifies manufacturer, company, brand. Use of this generic active ingredient does not. As I said, it doesn't tell somebody who the manufacturer is, correct? Correct?
Yes, Your Honor.
Okay.
But the point I'm making is this label has to have a headline, and our headline's in Braille, their headline is not in Braille. The way to keep it the same is you keep the headline in Braille because that's what we've done. The change required is just as the Roman text of the headline has to change from Hetlios to Tazimelteon, the label, the Braille text changes from Hetlios to Tazimelteon. Again, though, that says.
FDA says you have to have a headline if you're a name brand that is not the active ingredient.
I believe that's the case, Your Honor, but I can confirm. I do not know if we could have inverted Hetlios and Tazimelteon on this. I don't think that would change the nature of my argument, but
well, then we'd have maybe sameness on what's in Braille. But can I ask, I just have a real quick technical question while we're on page 17. You have on top the approved label, and then on the bottom you have the publicly available label.
Currently uses.
So this really doesn't go to any of the arguments here. I was just very confused. I would have thought the approved label would have to be the publicly used label.
So there's
Which one are we comparing to for purposes of sameness here?
Your Honor, I'm not sure that there is I think we are looking to the approval label.
Mm-hmm.
That is what FDA was considering. But what's changed, for example, is the NDC code has changed. And again, I don't know the precise history of other changes,
It
but
looks like no lot and expiration here. There's no swish, sort of the trade. I assume that's some kind of trademark thing for Teva. But I just don't even know what we're comparing here. It's just sort of baffling to me. So, but it's true that you can change things from what they've approved.
yeah, I think it's a difference between the tentative approval and final approvals. But again,
That's not what you said though, the approved label. When you say approved label, did you mean tentatively approved?
Your Honor, I'd have to go check and see and understand what.
I don't want to distract. It was really confusing.
No, but it's just confusing to figure out what we're doing here.
Well, what we have looked at, Your Honor, is the label
You want us to compare the label on page 13, which is yours, your clients, and the label at the bottom of page 17.
Or top.
Yeah, but I think.
The bottom,
Thank you. Yes. Which one am I comparing it to?
yes.
I'm going to pick top because that's what FDA was looking at when they granted approval. And so I think that is turning on what the legal determination was that label. But again, we were trying to be most complete, but I don't think there's for our purposes.
No, I get it, but just so we know what we're doing. All right.
Yes. Again, first, again, we've talked about this doesn't go to 20 milligram, but if I can just for a brief moment, I know I'm well over my time. The essential point, though, that we make about statutory construction is for both the principal rule and the word required to do work, the change required has to be caused by something external to the label itself. There has to be some permissible change that FDA or that the generic is allowed to make, such as different inactive ingredient, different indication, the subset of indications. It can't simply be.
Please recycle.
Please recycle.
Please recycle. The label.
Probably not. I don't know. And Your Honor.
Well, they can put kosher.
Well, kosher is describing what the manufacturing process is.
Well, but I mean, assume that they're identical manufacturing processes. They just, for whatever reason, want to let people know, or vegan. Contents are the same. We know they have to be the same. And I'm assuming for here, inactive ingredients are the same. And so they want to put vegan or vegan friendly.
If I would think, Your Honor, that the answer would be it needs to be the same. So if the product is truthfully described as not false or misleading, it should copy Yes, I mean, it's a sameness requirement. I don't think there's anything surprising that if the generic drug is
Not
this.
identity, and you said you can trade dress things and de minimis things, they can communicate things. We know that you have different warnings about children. They like, is yours keep out of reach of children? There's keep all medicines out of reach of children. Was that a violation too? Is that difference a violation? Am I right? They say keep all, tell me if I've got it backwards. I think Teva says keep all medicines,
Yeah, right.
all medicines away from children, and your label says keep this medicine away from children.
You're right. That's where I go back to, there might be single word distinctions that are trifles, and that could be, I think the answer the court would say.
I think the problem here is what you're willing to call de minimis or stylistic, right? They've got the swish mark on theirs. Others might say fonts.
Well,
I thought we actually even agreed that font is a style they can change. We don't require that they do that. Their telemetian is not in the same font or size as Heliox is.
But
Right.
so again, this is where I want to go back to. This is not an issue that is dealt with by the exception, the change required. This is an issue, that line of question, which is an important one, goes to, is it a violation of the sameness
And the
requirement?
sameness.
Oh, but-
Okay,
yeah,
please.
go ahead.
Go.
I thought you had agreed, though, and maybe I misunderstood, that the way you're interpreting the statutory text, sameness, is not a requirement that the labels be identical.
It's not a carbon copy requirement. That's right.
That's right.
Yeah.
So from FDA's perspective, just hypothetically, they look at your label, and all I know as a blind person is if I put my hand out and feel the bottle, I feel some braille, right?
Yes, you do
Okay.
feel the
so
braille. That's right.
With the,
And the form factor of the bottle as well, which is unique, but
right, but the form, okay. But what I'm getting at, and I thought this is what Judge Millett's questioning was getting at, is from FDA's perspective, we want the public to be clear that the generic is, quote, the same as the pioneer drug. And yet the same, that's an issue and important for health and safety, is the active ingredient. So if I'm looking at your label, that's in very small type. If I'm looking at the generic label, it's in bold type, larger type. Right? So why, from FDA's perspective of safety, et cetera, you say there is, I mean, the FDA record that you cite on whether they think Braille has anything to do with safety is about as wishy-washy as you can get, all right? And so I just thought, from the point of view of the concern about safety and health, having the active ingredient in larger, and in this case, bold type, provides more safety than knowing that the pioneer's name is Helios.
But I think it's where I want to take us back to the statutory text because.
I am with you on statutory
Okay.
text, but I'm trying to understand, what did Congress mean when it used these words? All right, and it was concerned, as I understood it, that, marketing of new drugs was too costly, it was too time consuming. It took years upon years upon years. All right? So once they had a pioneer that was approved, they wanted to get these generics out faster. All right?
Precisely.
So the generics could piggyback on the pioneer's research, and it could change the label just so the generics told the consuming public what the generic was.
I agree with all of that, Your Honor. And that's why I don't think what Congress set up leaves room for what FDA is ultimately requesting,
But
which is.
FDA is delegated the authority to determine what is necessary for safe consumption, right?
But
Not the manufacturers.
Yes, Your Honor, but that's not part of the ANDA approval process is a principal matter for the labeling, because the way Congress set it up to streamline it, to get to exactly what Your Honor was saying is, we've already done the safety and efficacy approval. We've already done the labeling.
No, but here's my point. The approved label, I understand that, and I thought that was going to be your lead argument, but in any event, suppose.
Well, I'm trying to make it, Your Honor. Hopefully I'm there, but.
Suppose Teva put out a label that was exactly like yours. All right, it says Helios. All right, and then it has the active ingredient.
That they can't, and that's why Congress.
No, they cannot.
That's right.
And so that's why there's that provision in the statute that
Precisely.
says if there's a manufacturing change, et cetera. So they can't put your name on their label.
That's right. It's a change required.
All right.
Totally agree.
All right.
Totally agree.
So I don't see why it's not reasonable if you're delegating authority to an agency with expertise, and they have to make a decision about how can this generic be safely administered and understood, that it could make that decision that, well, it's very nice that the pioneer decided to use some of its label in Braille. And that's probably very convenient for blind people. All right. But on the other hand, what we really want them to be clear about is it's the same active ingredient. So that's why what we want is this bold height.
Your Honor, those points might go to my arbitrary and capriciousness arguments.
No, I'm not there. I'm with your concession that sameness doesn't mean identical.
But it does not mean, though, that they can change things that were specifically negotiated, a really important part of the label where we had to go out and do study requirements to be able to demonstrate the readability of this, where we went and said, this is done in Europe.
I understand that. And maybe we're just behind Europe. I thought that was a very nice point. Okay.
Yeah.
But anyway, that's where we are. All right. And my only point is that if there is some delegated authority here, isn't that precisely the type of delegation decision that was intended?
Well, Your Honor, when you look at the citizens petition, their response, there is no discussion from FDA that describes in some rigorous fashion what change required means. What FDA essentially says is we'll just use our judgment and decide, but that's not the statute Congress wrote. That would mean that the sameness requirement is essentially doesn't actually have the force Congress intended, that anything could change. And PLEVA says that is not right. Even if it would be a great idea for a generic to add more safety information that doesn't conflict with the label, that just adds more information on top, that would be great for the public, the Supreme Court says you can't do that. That is not part of the Hatch-Waxman bargain.
Please go ahead.
Okay.
No, I'm second on your question.
No.
Well, so when they have tasmaltian in bold, thicker print and the 20 mg highlighted by this orange background, those are impermissible too?
No, we've not argued that those are.
You haven't argued those, but those are different. And those would seem to be highlighting, as Judge Rogers said, critically important information.
This again,
I think search around on here for where the active ingredient is, right? And the amount. So
this is where I go back to my underlying point where I agree with Judge Rogers. These are not carbon copy, photocopy requirements.
I'm just trying to clear up something. So I just want to make sure I know. Do you agree that this font change and this bolding change are permissible?
Yes, because I don't think it makes it not the same label for legal purposes.
So font and boldness changes are. Now,
it was an accepted premise of the citizens petition that these aren't the same, that the citizens petition, which we have to accept as Chenery, said we have to get into the exception.
Okay, I'm just, so font, formatting, shading, that's At least is what's done here. I'm sure one can imagine.
One can, but that's the thing is I'm not saying these are subject to categorical rules because one can imagine font or shading not being the same. And there could be tough judgment calls, but that's not here.
Let's imagine there's a medicine for dyslexia.
For sure.
As it turns out,
Yeah, there's some fonts that are easier for dyslexia.
right, there are
Understood.
fonts that are like that.
Yes.
So if a generic comes along and says, and let's assume there's the name brand and it just has regular font. And the generic comes along and says, well, no, we're going to use a font that's easier for those who are dyslexic to read. We'll have the same content. I mean, other than the stuff we have to change, like name brand. We'll have the same content, but we're going to have that different font because it's easier to be read by dyslexic patients. PLEVA permits or doesn't?
Yeah, I think that's a hard question under PLEVA because that is.
What is your view? I wouldn't be asking if I thought it were an easy question.
Yeah.
If the font changes,
I think that probably the best reading of PLEVA is that it prohibits it. I admit that's a tough call. The reason it prohibits it is because the reason you'd be doing the font change is because you're saying it makes a difference. I know that's a counterintuitive result. It's the same way that PLEVA says you can't make the product safer. But I think it would be a pretty good reason for the generic to petition the FDA to say, we've got a better way to do this label and you should compel the branded product to use this label that's more.
That change would not be required because it was a different manufacturer.
Well, they could petition FDA to change the branded manufacturer's label, and then it would come downstream from there that they could use that. But again,
Am I wrong that that's looking at a different part of the statute, whether it's same or not? Whereas we're trying to look at whether it's required because it's a different manufacturer.
that's right.
Changing a font to make it better, or more easily read by dyslexic people would not be a change that's required because you're a manufacturer,
That's right.
different manufacturer.
Well, sorry, Your Honor. I think if the hypothetical is the generic says we have a better way to do the label that is going to be more useful for the patient population who's going to take this product, and we're going to petition FDA to change the brand product's label. FDA says, you're right. That's a better way to do the
So it
label.
would change both labels. It would
Correct.
still be the same.
It would still be the same because it would change the brand label, and then that would flow through from the sameness requirement to the generic. That's right. Let me be clear. It's an interesting
In
hypothetical.
this case, it is conceded that these are different. They're not the same. And we're only looking at whether the change is required because it's a different manufacturer.
Right. And I'll point the court just to two places in the citizen petition response, because I think this pretty well cements FDA's position. It's J 920 and 918. And they at J 20 acknowledge the quote unquote labeling differences between the RLD, that's the reference listed drug, and the ANDAs. And then 918 make clear the sole legal argument they're resting on is, are we within the scope of the changes required exception? Not, are we in a world which we say that these are legally the same labels? And again, FDA didn't do that, so they can't from a Chenery perspective, but I don't think it would be well taken if they said Braille or no Braille is the kind of thing where it's, a small font, Your Honor's font change where there's actually somebody can read it better. That might be a distinct case, but just a slightly bigger, slightly smaller, different color, I don't think is nearly the same as Braille or not Braille. So that's why FDA didn't make that argument in the below when it was before the agency.
There's no role for FDA's expertise in the determination of what is required.
Well, I think that's what the Supreme Court in PLEVA said, is this requirement is pretty strong and we're not going to go back. The plaintiffs in the PLEVA case said, of course, FDA would have allowed if you'd gone back and asked for safer information. And the Supreme Court says we can't engage in that, sort of situation because what is required here is the same label. That's the strict obligation of it being the same label.
You acknowledge the record evidence about how the Braille came into being, correct?
I'm sorry, I'm not sure I follow Your Honor's question. If you could.
Well, maybe it wasn't clear. Vanda said we'd like to add Braille.
Yes, Your Honor.
And FDA said, that's interesting.
Yes.
Do some studies.
Yes.
All right, let's see if that's really going to be helpful or not. All right, so you did some studies. And some people thought it was helpful, some people thought it wasn't. And then within the agency, you had 3 different people and they had slightly different views. But no one thought, as I read it, and maybe I'm wrong, tell me if I'm wrong, that it was essential or necessary for the safe and effective administration of these drugs.
But that isn't the question the statute asks, because, for example, the same thing could be with warnings. You could.
So you say, all I'm trying to understand in this case is, I'm trying to understand what Congress had in mind. That's not.
And can I give this example? Because
could I just finish?
Of course.
Then you can
Sorry.
tell me how I'm wrong.
no, thank you.
First, we're looking at the plain text. All right. That's where you begin and end.
Yes.
All right. I'm saying sometimes words aren't always clear. So what does required mean? And suppose FDA said to your client, yeah, you know, if you want to issue, I don't know, $50 US bonds with every bottle of Helios, go right ahead. It's a great idea. You know, more blind people will use your product and it'll be good for them. Great. And that's what your studies show. So you put out these $50 bonds. Then a generic comes along and says, we don't want to put out those $50 bonds. All right? It's not required. It's great that you do it. Some people think it's really good for the blind community. But, you know, is it medically necessary for safety or the efficacy in the use of the drugs? And FDA says, essentially, no, go ahead. Kevin, with the label that you're proposing.
So let me offer.
Yeah.
Let me offer an example I think plays off this, because this could be a very real world example, and I think it helps at least how we're thinking about this. Take the court's example of the history here. Imagine a scenario where you get all sorts of clinical data that could have warning signs about your drug having some sort of adverse events. Not for Helios, very safe drug, but I'm just saying hypothetically. So for some other drug, and the brand may be very concerned about liability. So they go to FDA and say, here's some evidence that we think we need to put an extra warning on our product because of, cardiovascular activity. And we want to do that because, we don't want to get sued later. So we want to put this in our bottle. And the folks at FDA look at it and say, well, it's not really that big of a risk. There's maybe 1 or 2 people. It's not something that we would require generally to do because it's not so overwhelming. But if the brand wants to do it, sure, why not? It's truthful information. They can put it on the label. That's no problem. Generic comes around and says, we've looked at this evidence. We don't think it needs to go on the label. And you look at a record and it'd be the same record here. And they can say, well, the reviewers internally thought it was inconclusive. And they said, maybe it's nice to have, we'll let the brand do it. The result is they have to copy what the brand product did. And if they don't like what the brand product did, they have to go back and change the brand label through a petition process.
Because you're changing your position. You think sameness means identical.
I'm talking about things that are same because they're actually conveying information that is, has some substantive effect or is material information or something. And again, I'm not saying those are the precise tests. I'm saying it's actually conveying things that FDA's.
To what? Safety and efficacy?
Well, no, I'm not suggesting this is a materiality. I'm saying it's something that matters. Is this the kind of.
Just said materiality. That's what I was picking up on.
Yeah. And that's why I'm not suggesting that this is just a straight materiality test. What I'm saying is sameness is there some reason that this matters?
Because what we're trying to figure out is, even you agree it's not identity. And you agree that there can be different within, there's extensive regulation by FDA on sizes and what's bold and whatnot, but within the rules, there can be difference on fonts, shading, highlighting, all of these things, whatever else falls in your de minimis bucket. All of these things can happen as well. And FDA has put those in the different manufacturer exception. That's where they put fonts.
Well, I don't think they should put the fonts there. Yeah, I'm saying that's not the right way to interpret the statute.
Well, they put them there. That's the label they're putting them under for now. And so when what we're struggling with here is you want you agree not identity, but we're trying to understand what the range is. And, the reality of this record is, and you haven't challenged this, that the FDA decided when you did your study on putting your brand name in Braille, you had to show them that it wasn't making, the label wasn't making administration of this drug less safe, unsafe, not safer. And all they did was decide it's not making it less safe, right? And so it was a choice, a design choice you were allowed to make because it didn't render it less safe.
I think FDA recognized that following the recommendations, what Europe has done
They have a lot more Braille. Do you have the same, would this label pass muster without additional Braille in Europe?
Perhaps not, but again,
No, so don't be giving me the Europe.
well, we're the only one who are doing it, Your Honor. We're the only ones moving towards Braille.
Okay, I mean, you've said your piece on that. All right, the point here is you chose to put your brand name in a particular font style, we'll call it font style Braille. A particular way of packaging your brand name and the 20 mg point. Neither of which, all FDA decided was that won't make it less safe. You're allowed to do it. That's a stylistic choice you get to make. That's what FDA decided. You have not, unless I've misunderstood your brief seriously here, you have not challenged their decision. They were wrong, that having the brand name is, but not the active ingredient, is actually necessary for safety.
Well, Your Honor, setting aside the arbitrary interpretations.
That.
Well, no, Your Honor, because when this was put to the question of the director and the deputy director of then DPP, now Department of Psychiatry, there was questions. They said, this may make it less safe for patients who won't have Braille. Now, I'm not saying that's conclusively. I appreciate FDA is going to say there are differing views about the agency, but what it goes to is this bears on safety. This is not some irrelevant consideration that is completely tangential to safety. FDA recognizes it. They realize that putting it on is only helpful and useful.
I don't know what you mean by relevant to safety. FDA didn't say, did they say it makes it more safe?
They looked at our.
They say it makes it more safe.
They looked at our study results and found our study results showed that more people who are blind would be able to identify the product than who wouldn't be able to identify the product. I think that is a conclusion that it is more safe. They did not use the words it's more safe.
Marketing conclusion. Okay. It doesn't have anything to do with safety.
It has
been. That's why I said I thought that the citations you gave us weren't very helpful to your case.
I think medication makes it.
More people will use your product, and that's good. All right? Because we want this product on the market. It will help people. But is it necessary for effective?
I mean, the U.S. Access Board was created by Congress to provide recommendations for making medications more accessible to visually impaired and blind individuals.
One of the accessible. I mean, your client is the good guy. All right? It's helping blind people. All right? Not only with this new medication, but with the bottle so that blind people can find it easily. All right? That's sort of the argument, isn't it?
Well, it's not just finding, it's not mixing up their medications, because if you have these in just the same pill bottle that has no distinguishing feature, it allows to medication mix-ups. This is a drug that is a specialty sleep medication that is designed to be taken, an hour, a half hour to an hour and a half before your targeted bedtime. And if you take that medication at the wrong time of day, it's going to make you go to sleep potentially. So
Information's not in Braille. When to take it isn't in Braille.
But it is telling you what this drug is. So this is that that you're taking this drug as opposed to a blood pressure medicine or some other medication that you might be taking.
All the Braille is telling us is that you manufacture, your client.
It's telling you what the drug is in the bottle. It's allowing you to identify this medication.
It's like Bayer aspirin.
Well, it's not Bayer. It would be saying it's the product. It's telling you this is, it's not telling you Vanda. It's telling you this is this particular product, Hetlio, so you know this medication that you're taking compared to, as I said, your blood pressure meds or some other kind of medication that may not have the same time sensitivity as to this
It's a great
drug.
idea. And that's what, the record from FDA in your study shows. It's a great idea.
And didn't the FDA say to Vanda, it inquired whether Vanda considered if other important information such as the established name or usual dosage should also appear in Braille on the container label to promote the safe use of the product?
Yes, I think there was a conversation and they decided back and forth
So
with
they viewed it
FDA.
as a safety issue also.
Well, I think it was an agreement between Vanda and FDA for the first ever product that was going to put Braille, that this was the Braille that was going to go on.
Hang
There
on,
was-
they found it does not, you have not established that Braille is necessary for the safe and effective use of the drug product.
Sorry, can you,
FDA found.
are you?
Where is that?
Are you referencing this?
924?
This is the citizens petition. You're referencing the citizen petition response. Yes, this was not the underlying approval of our NDA. We're talking about the citizens petition rejection is what I think Your Honor is quoting from.
Right, but you haven't shown that it is safe and effective for these, that is necessary for the safe and effective use of the drug product.
Yes, that's our arbitrary and capricious claims after the fact ex post when we said it should be on. They rejected our arbitrary and capricious claims. That's different than when we went on with it and we explained that there were safety implications and they agreed that we could put it on our bottle.
They're saying that you can't, they say lots of things that can be put on bottles. It doesn't mean that it's required. I mean, what I'm struggling with here is either the Braille is necessary for safe and effective use, at which point, yes, it has to be on everyone's bottle. Or having Braille on there, the drug itself is safe and effective, and having Braille on there doesn't take that away.
But that's not what the statutory question asks. The statutory,
No,
there's,
but am I right in describe, which of those is the FDA decision? I think it's the latter.
yes, I think that's,
Doesn't reduce safety or effectiveness.
and I'm saying they've gotten the statutory test wrong. That is not the test that is to be asked of does the label change reduce safety or efficacy?
Wait, I'm sorry. I'm just doing this one step at a time.
Sure.
All right. So FDA found back when you guys wanted to put Braille on the label, and they did the studies because they had to know, would it confuse people?
Right.
They have to be concerned about is Braille literacy so low that people might misinterpret the information? I'm sure they had to do all these things to make sure this isn't going to create a safety problem.
Right.
That's what they care about. And you did your studies. They had a lot of criticisms of the studies, but they said at the end of the day, this isn't going to hurt. Is that correct?
I don't think I agree with your characterization. They said it's not going to hurt, but they did allow it and they allowed it after
Say it's necessary for safety.
I don't think they had an explicit finding it was necessary for safety. If that's
They have an implicit finding that was necessary for.
well, that's yes, because why else would you put it on the label? I mean, again,
Well, there's a difference between promoting safety
Right.
and necessary for safety. But I understand your point to be that when you applied for approval, you raised a safety issue that would be addressed by Braille, promoting safety,
Yes.
even if not necessary. They went back and forth with you, seemed to agreed that this was about safety because they said it themselves, and then they approved you. And then later, in a different decision, not relevant to the approval, but relative to the citizen suit, they said this wasn't necessary, but that was not the standard they applied when they approved you. And it is not the standard that's required by the statute.
yes, the standard by the statute is it the same label that was approved? And this goes to my hypothetical of maybe we didn't have to put, or a drug didn't have to put a cardiovascular warning on the label and they did it out of excess caution because they were worried about litigation risk downstream. And maybe the FDA would have approved it anyway. But once that's the label and it has to go forward, even if FDA says we might not have required it. And so it doesn't become optional for the generic. The things that can change from the label are when there is something about the product that differs from the branded product that requires a change. So A different manufacturer, of course, a different address, a different inactive
That's all
ingredient.
the de minimis and font
No, that
styles.
to be clear, in our view, that is not coming in through the different manufacturer exception. It's not a change
No, I'm
required.
saying, but those things are all allowed by generics.
They're allowed because it's not a difference. It's not violating the principal rule. Again, it's important to situate. We have a principal rule that says it's got to be the same. And that we ask, what does the same mean? Does it mean a carbon copy? And I've said, and we've been through, it's not a carbon copy. So there are differences, minute differences that would not make something legally not the same. This is not a question this court has to address what that means, because FDA agrees that these labels are different and did not suggest that these are the same for legal purposes. Maybe they could have made that argument, but they didn't. And that I don't think would be a well-taken argument.
Does that matter? Was Loper Bright? I mean, we have to decide whether these things were contrary to law, contrary to statute. Does the statute allow this difference?
Yeah. Yes, Your Honor.
Don't we have to decide both and any other avenues for whether this is allowed or not, whether it's sameness or a different manufacturer, or whether they wrap it all up together? Don't we have to decide that? Don't we, at the end of the day, just have to decide whether this is same in that, as
Well-
same is used, as we understand same to be using, Congress to be using same in this ANDA provision?
I do think same, Your Honor, would have some factual determinations that would get wrapped up in it. If you're going to say that two different labels that aren't carbon copies qualify as legally the same, which I think we all agree can be done, there would be factual questions that go to that. You know, if something is the sort of minor change.
Touch your argument. If we're going to get into factual questions, it seems to me. What you want to present, as I understood it, and I thought that was what Judge Millett was following, is a plain question of law. You look at the words, here's what Congress meant. All right? The label has to be the same. Period. End of discussion. All right? Unless the changes are necessary or required. And that's where you stop, right?
I mean, I agree with everything you said, but that's the statute, Your Honor. I'm not sure the question where it meant.
Go further. And you not only say there's more than Loper Bright here, but we agree there's some other types of changes that can be made.
No, Your Honor.
Well,
That's not my argument.
De minimis, font changes, okay?
But that's.
You're okay with those. All right. So then my question is, you say Teva has just gone too far.
No, Your Honor, that's not our argument at all.
Well, I'm trying to close it down.
Yeah.
If Teva had put your label on its product, they can't do that. So
Correct.
you agree there have to be changes.
Yes.
And you agree the FDA is supposed to determine whether a label accurately conveys information, right?
Yes.
Okay. So now it's got the active ingredient in large letters, in bold.
Yes.
And so under your analysis, Loper Bright, is that okay?
It's a change required because our original product says Hetlios bold. They cannot do that. So they have to change to Tazameltian bold. That is exactly what the statute obligates them as a change required. Yes, Your Honor, that's okay.
So you're okay with that change?
That is a textbook change required by the statute.
And so the fact that you also give out these bonds, all right? FDA approved that too.
But that's not a label issue, Your Honor. That's not copying the label. That's not the same
QR code on
label.
the label.
Yeah, Your Honor. Yes, in a fanciful example where FDA approves, some lottery giveaway to people who buy the medication, which would be unlawful under a whole host of other laws. But if that were
The hypothetical.
that's the hypothetical. It would be incredibly illegal because it would be a kickback and anti-stark violation.
A legal thing. They
But-
give a bunch of flowers out with each bottle.
Well, again, a QR code that gives you a coupon for flowers. I can't imagine a world in which FDA, the label on the bottle is a really important thing. I think
Yes, it is. And looking at yours, all I know is that's your brand name. It doesn't tell me what the active ingredients is.
That's a criticism of the industry as a whole. That has nothing to do with our
I'm
case.
just trying to understand, what could Congress have meant where a word can have different meanings?
What Congress,
And so normally the Supreme Court instructs us to use the ordinary dictionary meaning unless Congress indicates it means something else.
well,
So we know that same doesn't always mean identical. And you agree. And so here, the change to which you're objecting, in my hypothetical, is a determination by the agency to which Congress delegated this responsibility to determine what is necessary for the safe and efficacious use of a drug.
but it's Congress, so FDA made that determination with the branch.
FDA says, we've looked at these studies about Braille, and we were concerned, as Judge Millett has emphasized, is this going to cause a problem? And they say, no, it's not going to cause a problem. But they never said, unlike your brief, that it's either a condition of approval or that it's necessary for the safe and effective. Well,
Your Honor, if that were what the statutory text were, I agree with you, I would have a very different case. That's just simply not what the statute directs the inquiry the FDA is to undertake right now.
what does the statute say?
The statute says, first, the first requirement, prohibition, it says the label must be the same. So the first question is,
So what
do we,
the same mean?
yes, so this is where I go.
Who decides that?
I
You
think-
decide it, right?
Well,
And even after Loper Bright, the Supreme Court has said an Article III court can look at what the agency has said, the expert agency. Doesn't have to follow it necessarily. But it is going to be interested and presumably influenced by what the agency
and the
says.
agency did not say this was the same. They said this is a different label. They said the opposite of that. They said again, two-step process. One, is it the same? If not, is it justified by an exception?
Depends what you mean by the word same.
Wait, if I may,
That's all I'm trying to get. That there's one way to read that, understand that word. I say you have to wear the same suit tomorrow. We know exactly what that means, right? If I say we want you to wear the same suit by the same designer, I don't know what suit we're necessarily talking about. You could come in tomorrow with a gray suit. Is that the same? Or you could come in with a suit that has short sleeves. Is that the same?
So let me just point to the Teva's summary judgment motion at 344. Let me quote from it. Teva's label quote, the same label as the label approved for the brand name drug, except that Teva's label does not, end of the quote, use Braille. So they agree that their label is not the same in respect to the Braille. So it is established. I can point to J 344,
I think we all can recognize that. I don't think you need to prove that they omitted Braille and you have it.
Well, what I'm saying, what they admit in the lower courts below, what FDA agrees is that the first step of the statute, if we didn't have an exception, if this had to be the same label, would the label be the same? The answer to that question is no, and no party has challenged it, and that's not.
I think Judge Panos had a
if I
question.
may,
Sorry.
on the Loper Bright issue, why isn't it the case? I think it's true that Chenery survives Loper Bright and principles of issue preservation survive Loper Bright. In this case, before the agency, the focus was on interpreting whether the label was subject to this exception for changes required because the drugs are distributed by different manufacturers. That's what would happen before the agency. They did not address a different statutory interpretation question, which is when is a new drug the same? Or when is what the labeling proposed the same as the labeling approved as before? That wasn't before the agency because the FDA conceded that these were not the same. And because it wasn't before the agency, numerous factual things that we would need to know to decide this issue was not before the agency. And the legal arguments also were not made before the agency. Their factual things would include a finding about why these are not the same, if that were the case, and what made them not the same, and an explanation of what the same means. As Judge Rogers was saying, what does that mean in this context? None of that is in this record. And therefore, it should be precluded by Chenery, issue preclusion, et cetera, because regardless if we have the first say on interpreting the same, we don't have a record to determine the same in this case.
Yes, Your Honor, I agree. Sameness is just not an issue in this case, and it can't be because of Chenery. It would be a factual issue. It's not been argued. It's not part of the case. What is the sole issue that was decided by FDA and that comes before the court is the scope of the changes required by a different manufacturer. That scope can't be interpreted to negate the meaning of the word required.
So did you make this argument?
Sorry, Your Honor, I didn't hear you.
The Chenery argument?
Well, did I make a Chenery argument?
Yes.
FDA didn't make a sameness argument, so no, Your Honor. This was,
Right.
the sameness argument
I
was.
just want to be clear what's before us, okay? You didn't make that argument, all right?
Well, because,
Alternative.
Your Honor,
You knew what FDA was going to argue.
but they didn't argue sameness. They haven't argued
Just
sameness
saying,
this
you
court.
knew what their argument was going to be in response to yours. They weren't going to say, let's withdraw the appeal because we agree.
But even before this court, they don't make a sameness argument, Your Honor.
How about, let's see what FDA has to say.
Yeah.
About this. Can I ask you
Yeah.
one quick, I apologize, folks, just one quick fact question. Just a
course, sir.
quick fact question, nothing more. JA 637. When FDA asks why he's putting your proprietary name and strength of safety, blah, blah, blah. And Vanda's response is, Vanda proposes presenting the proprietary name and strength in Braille on the label and providing patients an appropriate medication guide in Braille, black and white, and audio formats.
Yes,
Do you do that?
we do. We have a book. I have a copy of it in my office that has like a
The
little.
audio and everything?
Yeah, it's like.
With every single bottle that goes out? folks?
Yeah, it's a welcome package, a welcome kit that when a patient is enrolled with Helios, they get a welcome kit that has a brochure with Braille that has lots of Braille all around the brochure. It's several pages of Braille. And they also have an audio thing where they click a button and they can listen to all the audio. So
My understanding is, sorry, that a lot of this patient things, is that part of the label? I thought
It's
a
not
lot
part of the
this stuff
label.
that comes with.
that we've not argued and I don't believe
Okay.
it is not
Okay.
part of the label as such. That's more of our, but we do it. And I'll be happy to give the court copies if the court would like to see it.
So just very quickly, a generic doesn't have to include that enclosure, right?
We've not taken the position as part of the label. I think FDA would agree it's not part of the label. It's something that we do to
Okay.
to give.
So something you
blind-
tell people, it's not an insert that comes with the medication, like those big inserts. Okay.
Yeah, it does not, Your Honor, to be clear about this, and I can confirm, I don't believe it comes with every single bottle of the product. What happens is when a patient enrolls, they get a welcome package that says you're a new.
In the mail or something,
You get a package in the mail that says.
not from the pharmacy.
Yes, that here's and it includes a big guide in Braille and it includes an audio guide where you can get all this information read to you.
Okay. Thank you. All right, long last, sorry.
That's it.
Oh, you still haven't. All right. You got 10 minutes to respond to that.
Only 10, Your Honor. Good morning, may it please the court. David Peters on behalf of the United States of America. Congress enacted the Hatch-Waxman amendments to facilitate the introduction to the market of low-cost generic drugs that are as safe and effective as their brand name counterparts. As part of that scheme, generic drugs must copy numerous labeling features of the brand name drug, such as safety warnings or dosage information that are necessary to the drug's safe and effective use. But where a brand name manufacturer includes discretionary labeling information or makes formatting choices that, while permissible, are not necessary to the drug's safe and effective use, the generic manufacturer may elect to omit those features. That narrow exception to the same labeling requirement furthers the statutory scheme by ensuring that the same labeling requirement is not leveraged to deter generic
What's the statutory basis for that? Like, I can understand why that is a sensible way to
What is
proceed.
your quote?
But where's the Where's the connection to the actual statute?
I think it's a different manufacturer exception. I mean, the FDA has long understood that exception to permit certain labeling changes and certain other changes to drugs that generic manufacturers are allowed to make by virtue of the statute. And I don't actually understand Vanda to be really disagreeing with that argument. I mean, Vanda kind of has this, it relies on this textualist argument, but when you hear the kind of formulation of their textualist account, it's, changes that are external to the drug itself, but that's not the statute.
Required though. Like, I don't see how your interpretation fits with required, because the change has to be required because the new drug and listed drug are produced or distributed by different manufacturers.
Yeah, I mean, yes, Your Honor. The FDA has long understood that provision to allow certain changes that are permissible for generic manufacturers to make. And so I think an example that might be
I think
helpful.
required means permissible.
That's not what I'm saying, Your Honor.
Sorry, go ahead.
No, please, go ahead.
No, Your Honor, I'm not saying required is permissible. What I'm saying is required, I think in this statutory text, is meant to mean appropriate or suitable in a given context. And the reason that provision has to have that meaning is because everyone agrees. I mean, look at page 1 of the reply brief. Everyone agrees that generic manufacturers can make changes to their drugs or to their labels that are permissible, right? So the easiest example,
That kind of begs the question.
I mean, I think the easiest example is that for formulations, right? The Zeneca case is a good example, but generic manufacturers can formulate their drugs with inactive ingredients that are different than the inactive ingredients that brand name drugs formulate their drug with.
Disclose that because, that has to be on the label for safety reasons. People have to know what inactive ingredients are because they could have an allergy to it.
Certainly, Your Honor. But the point I think is
required because they're manufacturing differently than the name brand.
But it's required because they're making a change to their product. It's not required because there's a different manufacturer. The generic manufacturer could always formulate their product with the same inactive ingredient. I mean, that's why I think you have to understand that statutory text to be, we agree. This is, that is, a bit opaque, but we think
that they couldn't do it economically, that it's cheaper. It makes it cheaper so that as a generic to use X inactive ingredient rather than Y, it's just an inactive ingredient.
And that's a permissible choice that a generic manufacturer can make. But if you take required to mean strictly obligatory, there's no way it's strictly obligatory for a generic manufacturer to formulate its product in the exact same way. Or for another example, the FDA has long understood this.
Why isn't that required? Because it's a different manufacturer that's using different stuff. So it's required to the label accurate.
Sorry, I agree that the different manufacturer is broad enough to encompass that situation because there is a new manufacturer. The manufacturer has made a choice that's it's permitted to make by virtue of the statute. And then by virtue of that choice, I think it's fair to say that it's then suitable to make the changes to the labeling. That's exactly the same here, right? The labeling features that are at issue here are labeling features that FDA determined were not necessary to the safe and effective use of the drug. And when
that's in the manufacturing, it's required because it's a different manufacturer. The manufacturer has used a different ingredient. But the labeling with Braille doesn't fall within that.
I mean, Your Honor, those labeling features are not required because there's a new manufacturer. The new manufacturer could, if you take required to mean strictly obligatory.
Well, the manufacturer has manufactured a generic drug and it has certain features and the label needs to be accurate.
Certainly, Your Honor.
So it's required because the manufacturing process is different here and we're going to explain that. We're not going to have an inaccurate label.
It is appropriate because it's a new manufacturer. Our view is that it's appropriate here to make labeling changes because it's a new manufacturer.
That doesn't mean the manufacturer can do anything they want on a whim.
Absolutely not, Your Honor. That's not our position. Our position is that, as has been discussed, for some time prior to me coming to the podium, there is extensive regulations of the information that generic manufacturers have to have on their label that are required for the brand name drug to be safe and effective.
What about what Congress required?
Yes, sir.
Same label as approved by FDA.
Sure, and everyone agrees everyone agrees that labels don't have to be identical. My colleague on their side is now trying to kind of make these say, well, there's de minimis harm, but actually maybe whether something is de minimis is fact dependent, who knows? I mean, I think the more straightforward way to read the statute is same means same. They have to be the same, but the different manufacturer exception allows generic manufacturers to make changes. And so just to go back.
Required. So how do you map that on with your position? What's your best argument that this change was required because it was a different manufacturer?
I will. So, Your Honor, there are certain there are extensive regulations of the information that must be included on a brand name label when that brand name label is approved. Braille is not one of them, right? And Braille is one of many design choices that manufacture.
You're making an argument, but I'm asking you to tie this to the text.
Yep.
Give me your best argument as to why what happened in this case was required because the new drug was produced or distributed by.
And if I may, Your Honor, there is any number of discretionary labeling choices that a brand name manufacturer may make about its product. But what the statutory scheme allows is for a generic manufacturer to change those kind of non-required elements of a label. And so when there is a new manufacturer, they are able to make.
Getting that they can change non-required elements of a label. Where'd you get that?
Your Honor, it flows from the fact that the way the statutory scheme works is that there is certain information that has to be included on a brand name's label, but there is information that the generic.
But the statute says the generic has to be the same, except things that are required because the new drug and listed drug are produced. And I'm not getting an answer from you as to why this particular change was required because they're different manufacturers.
Your Honor, I think that the word required does not mean strictly obligatory. It means, is this a type of change that is suitable under the circumstances of the statutory scheme?
Okay, so stop. What's your best argument for why this is suitable under the statutory scheme?
Yes, that for a brand name manufacturer, when it submits its
It's a
label.
whim. This is why they did it. They just didn't want to do it. So any whim is suitable?
No, Your Honor, the key determination here was that FDA determined that the inclusion of this limited amount of information in Braille was not necessary to the drug's safe and effective use.
That's what FDA determined, but I think the question is whether that complied with the statute. And basically, I can see why that would be a logical way to proceed. I just don't see how it's connected to the statute. And I will say, I was surprised to see the communications going on within FDA where nobody's talking about the statute. Everybody's kind of opining, is this safe? I don't know if it's safe. I don't think it matters. Other drugs don't have it. But nobody asked the general counsel of the FDA, does that not happen at the FDA? That would to ask if there are legal requirements as opposed to just what we think?
No, I mean, the FDA the FDA understands that the generic, this is what I was trying to say. FDA has long understood the generic manufacturer, the different manufacturer exception to allow generic manufacturers to make changes, including to labeling features that are not necessary to the drug's approval.
Upheld that interpretation.
You know, there's very few cases, but I think.
Yes, exactly. So Judge Pan's questions are right on point, and you've got to answer them, whether you like it or not. Because obviously the panel is very concerned about that and saying that FDA has already always done this, or it's a reasonable interpretation. That's not good enough.
No, but I mean, even the hypotheticals that were given today, right? Something, if the brand name manufacturer elects to include on its label something that says, vegan or halal or kosher or gluten-free, those are all voluntary choices about the labeling features that the brand name manufacturer has taken. And the generic is not required to copy those kind of, almost design features of the brand name drugs labeling. I mean,
that might go to whether it violates the sameness requirement at all. What does same mean under the statute? Does same mean all the things, the extensive things that are required for safety and efficacy? So you have to have the same safety and efficacy label as them, but that still doesn't mean it's required. I mean, to build on here, what is your best case for required means appropriate? I would have thought Congress would have said.
I would point Zeneca, Your Honor. I mean, look to Zeneca. Zeneca was the statutory language is required because there is a new manufacturer. And if you take Vanda's argument literally, and it means that strictly obligatory because there's a new manufacturer, there's no way Zeneca comes out the way it does. I mean, Zeneca was an elective choice that the generic manufacturer made about the formulation of its drug. I mean, it could always have just formulated its drug using the same inactive ingredient. And Your Honor,
I guess I feel like those cases are a little bit different because if a generic uses a different ingredient, the label has to be accurate. So it is required because this different manufacturers manufactured the drug in a different way to put that on the label. But what I'm not understanding from your argument is what required really means here. Because required could mean obligatory or could mean suitable, appropriate. But you are giving even suitable, appropriate such a broad meaning that just because a generic manufacturer doesn't feel like putting it on, that's suitable and appropriate.
I don't think that's right. I mean, there was extensive discussion today about fonts and formatting and highlighting and all of those things.
Related to same, but now we're
But I think that's the
interpreting
wrong,
required.
I think that's the wrong way to read the statute. I mean, we think the same means same. It has to be the same, except unless there's a different, it falls in the different manufacturer exception.
But
And
in
so,
this case, you conceded that these are different.
yes, and my point would be,
So now the question is, I'm just trying to drill down on what's before us, which is we're interpreting except for changes required because the new drug and listed drug are produced or distributed by different manufacturers. You say required doesn't mean obligatory, even though that's the more natural reading. But even given that, you say it could mean appropriate. So why is it appropriate?
Yeah, but
here? Why is it appropriate here?
it's appropriate because it serves a statutory scheme. I mean, the whole point of the statutory scheme is to make sure that generic drugs are as safe and effective as their brand name counterparts, and they are able to enter the market. And the concern here,
So that doesn't mean it's affirmatively appropriate. That just means it's not unsafe.
No,
But
it
why
means-
is it appropriate? Why isn't it a good thing to do?
because the statutory scheme gives generic manufacturers some amount of leeway about how they craft their label. Our point about the font and all that is, I don't think it's right to say, well, that's all fine because we understand same to allow any number of these like exceptions. Our view is that same means same, and the reason that you can make changes to font or highlighting or any number of those other things is because they fall within the different manufacturer exception, which is why when you have a
But
question,
now I'm confused. How do you think same falls into the,
no.
so there are two parts of this, right?
Yep.
One part, it has to be the same. The second is there's
Has to be.
exception. So how are you
So,
putting
so
those together? Because you just incorporated same into the second part.
no, my friend on the other side says it's totally fine because my friend on the other side says problems with the text as well. But their view is, of course, a drug that has like this one that has a different formatting, layout, font, highlighting, any number of those other features, everyone agrees that's totally fine. And so their view is that that's fine because same doesn't encompass that. And my point is, no, same encompasses things like font, like formatting, but to the extent that the generic manufacturer can change that, it is because that's permissible under the different manufacturer exception. Like otherwise, you have the exact.
Doesn't even get to the permissible manufacturer exception if they're the same. If they're not this, I'm sorry. You
Yeah,
have to do the sameness
yes.
first before you get to the,
Yes, and our
to the
point,
manufacturer.
the reason we didn't make a sameness argument is because we agree these labels are different. We would agree that two labels that had different fonts would be different. We agree that labels that have different highlighting and
Same doesn't mean identical either. I mean, the same dictionaries they're using say essentially same means alike in material content.
but you're not
And
this.
so I mean,
The same problem that you identified, Judge Millett, when you said, well, what about font for something on a drug that's for, primarily treats individuals who are dyslexic? Like that actually might have real problems and real safety and efficacy problems. I think the best way to think about that is not to make some kind of analysis as to whether it's safe or not, is to say, is that a permissible choice that a different manufacturer can make because it doesn't affect the safety and
Permissible
efficacy of the
choice.
drug?
The statute does not say that the exception is not changes that are permissible for a different manufacturer to make, that are appropriate for a different manufacturer to make, that are required because it's a different manufacturer.
Well, you're right.
And so
I just had I think that the best way to understand the word required is because it's appropriate given the circumstances in light of the statutory scheme. And we think that these types of.
What I'm trying to get at is the statutory language, the plain text. And let me just throw in one other aspect. I know we don't look at legislative history anymore, but the whole point of Hatch-Waxman was to get these generic drugs on the market quickly.
Of course,
And they could piggyback on all the research that was done, which FDA had approved for the pioneer drug. So Congress says, let's get these generics out there fast. Use the same label. You're going to have to change the manufacturer's name if there's a different manufacturer. And any other required change. In other words, Congress said, get these generics out. We don't want you coming back to the FDA, then to the district court, then to the Court of Appeals, then to the Supreme Court. And 12 years down the road, this generic is finally out there because we know what same means as to the same label that's been approved. So if FDA went ahead and approved a label that has Braille in it, that's what the generic has to do. And we don't have to have all this litigation about it.
No, Your Honor.
Congress said, unless there's some other problem, like a legal problem, it didn't say in all those exceptions and such other conclusion as the FDA may decide is reasonable and appropriate.
Your Honor,
No, I mean, you got to deal with that scheme for me and answering the question.
I understand.
And either you think these are not required, or no, not you, but FDA thinks these are not required. I think Judge Pan has been trying to get this answer. We need help.
I understand. The statutory scheme was intended to ensure that generic manufacturers can enter the market as fast and effectively. And what the concern here and the reason why the different manufacturer exception has been understood the way it has been understood is because there is a serious concern with a generic manufacturer electing to include all number of things on the label that are entirely unnecessary to the drug's safe and effective use.
That already, it said the same label as approved by the FDA. And if the FDA approved a label that has, what did you say? Flowers going out with each dosage, each 20 milligrams, so be it. That's what the generic is stuck with it.
No, Your Honor. I mean, I don't think that's right.
Because otherwise, you're spending 12 years in litigation.
I mean, brand name.
And the public never gets the generic.
I mean, just think about that example, Your Honor. If the end result of this case is that a brand name manufacturer can put anything it wants on its label and increase the cost that generic manufacturers won't be able to enter the market, that undermines the very purpose of the statutory scheme.
But FDA can deal with that in dealing with the pioneer drug, because FDA can say, well, this might be very nice, but it's not necessary.
No, Your Honor,
that's the effective administration of this.
That misunderstands the FDA's role in approving the brand name drugs label.
That's my point. But that's what Congress said. FDA has a limited role. It's already done everything that requires expertise, namely all these studies that it's approved for the pioneer.
You know, I don't think that's right. I mean,
okay.
The brand name drug has substantial discretion over what it includes on its brand name label. And it may include information that even FDA determines is not necessary to the safe and effective use of the drug. That includes Braille. FDA did not determine that Braille was necessary to the drug's safe and effective use. Why
would Congress want all this debate about what a same label means when it's clear you're not going to put out misinformation? So if there's a different name and you're just putting out the active ingredient, and if there's anything else that Judge Millett and Judge Pan's questions have been focusing on, then those changes have to be made.
I agree.
We're not going back to have more studies about Braille. We've had studies about Braille, and FDA has approved a label with Braille. So why not just go forward with that? And if no generic can get on the market, well, that's another issue. They can come back to FDA and we can start all over again, or go back to Congress and get the statute amended.
I don't think that's right. The point of the generic drug statute is to ensure that generic drugs can enter the market, to ensure that they are as safe, as effective as their brand name counterparts. If there is brand name labeling that is not at all necessary to the safe and effective use of the drug, which is what FDA determined was the case with the Braille, then it makes good sense to think that when a brand name manufacturer elects to make design choices that are entirely elective, but then that gets approved, if a generic manufacturer comes along and there's a different manufacturer and that different manufacturer makes different design choices, those design choices.
Perfect sense.
Let me just make one point. I'm not suggesting that's not true. Okay? But that's not the statute Congress wrote. It said same label as approved by FDA.
I think the different manufacturer exception has to be given practical understanding. And the practical understanding of different manufacturer exception means that when the statutory scheme.
Practicality, it has to, any practicality has to fit within the words Congress used. And I think Judge Pan has asked, and I've asked, and Judge Rogers has asked, if you have any authority at all that says required because it's a new manufacturer, required because means
but that last
safe because, appropriate because, effective because.
that last clause makes a difference, right? If you take the last clause says because there's a new manufacturer. The reason why I think Zeneca is illustrative, right? Or cases like
that was another ingredient case.
But
it was, I get you say they could choose how they manufacture, but it is at least a fair reading to say a manufacturer manufactures the drug differently and has to disclose that falls within the different manufacturer. Right. It's not that we require the manufacturer to do it, but we're required because this manufacturer manufactures the drug differently. That might be a permissible reading. We'd have to decide if that's a better reading, but that might be a permissible reading of the statute. But you want to do with what you want to shove into this exception, how is this manufacturer likes a different font.
I don't think that's right.
No.
Sorry, I was much too quick, and I should have. My apologies. Yes, if a different manufacturer says, I'm going to make a different discretionary design choice about the label, which is effectively what this
that's this case.
Braille is. That is a permissible change under the different manufacturer exception. We think that the different.
Okay, I'm really struggling. If you wanted to say that's a permissible change under the statute. That could make sense depending on how one reads sameness, a material sameness, or sameness as in meets all the thousands of statutory requirements required for labels. But that's not your argument. And your argument is that I prefer this font because what, does that have anything to do with the manufacturing process? No.
No, it's
different to do with the fact there's a different manufacturer. It's required. There anything required about that as opposed to chosen? I don't understand. Do you have any case that is required the way you are?
I think the Hill case that we cite in our brief is also on point. That's another example in which the brand name manufacturer elected to include a certain peanut protein testing mechanism, right? And that labeling was approved.
As part of their manufacturing process.
Yes, Your Honor.
Okay, do you have anything that's not, what you're doing is giving me cases under this exception that have involved manufacturing processes that differ, which then need to be disclosed. What I'm asking you, you can go out of the FDA context, you can go anywhere you want and tell me a case. Sometimes, we have cases that say shall means may and may can mean shall, but is there a required means?
Suitable or appropriate? I think it's suitable or appropriate. I think that's a fair reading of the definition. That's the one the district court adopted.
Sorry. I'm going to ask again. Do you have any case that has read required to mean that other than the district court decision? Because it seems to me like the word required is really almost the opposite of optional.
A few things. I will point to this court's decision in the railway case that we cited. That was another instance when the court said required does not mean strictly obligatory. Mm-hmm. It is often used, required and necessary are often used in senses that are not strictly obligatory.
Necessary. Okay. But I'm good. Okay. So not strictly obligatory, but what the meaning you want to give it here is optional.
The point is not optional, Your Honor. It is appropriate.
It's a manufacturer can make.
It is the choice the manufacturer can make consistent with the statute where safety and efficacy.
Sounds like optional. Optional, consistent with safety and efficacy.
I think appropriate would be the word that we would use. Suitable or appropriate. That is a dictionary definition of
That dictionary definition, the full definition says called for as suitable or appropriate in a particular case, the need for some and or purpose. You've abbreviated the dictionary definition.
Let me just frame it this way. I'm going to back to Zeneca. I'm going to go back to the manufacturing cases. I understand that the court thinks those are different, but just to explain the statutory definition there, right? It was those changes. There were changes that had to be made to the label there, right? Because there was a different manufacturing practice, or there was a different formulation of the drug. Fine, but that requires a reading of the required because there's a different manufacturer to be read quite broadly. And so
why? Because that's a manufacturing process.
But it's not because
that's narrow.
But
it's a different manufacturer who's a different process. So we have to identify this different manufacturing.
A different optional process, right? A different optional process. It's an optional choice that the manufacturer made. That's.
I think we would all agree that any manufacturing changes have to be disclosed on a label.
Sure, Your Honor. I agree, but
there's no same manufacturer requirement in the statute. There's simply a same label requirement.
Sure, but
so we can have different processes, but if you use different ingredients or anything like that, you're going to have to disclose them. So I think that the point here is it is very hard to anchor your argument, which takes the word required, pushes it away, and it says you can do anything you want unless you can have any difference you want unless it contravenes safety and efficacy.
I don't think it's that broad, Your Honor. I think it's much narrower than that, in part because.
Well, I guess appropriate, because optional choices, design choices.
Sure, Your Honor, but everyone agrees that that manufacturers can have optional design choices.
Yeah,
right?
But I don't think everyone agrees where that goes in the statute.
Fine, or that's true, but it does
the sameness.
It does as much damage to the statute to read those kind of exceptions into same as it does to read.
So same is commonly just determined as, we had the same suit hypo here, that it goes to sort of material relevance under the circumstances.
I took the same suit hypo to be the same means it has to be the same suit, not that it has to be the same suit except for maybe some de minimis changes, except, well, who knows, maybe that's an important difference in I think the better way to read the statute.
So you read same in the statute as identical, and any differences have to come within the exception?
That's our understanding, Your Honor. And that is, I think, the best way to read the statutory scheme.
That's how same is in other parts of the Hatch-Waxman process.
I'm not sure that's true, Your Honor. It's the same active ingredient means the same active ingredient, right? I don't think we would say.
I am not a chemist. I don't know that that may just be a binary choice.
I think FDA would be very concerned if they would say,
bioequivalence doesn't have to be. Our Serrano decision said same there doesn't mean exactly the same.
For bioequivalence, Your Honor, but that is because same doesn't appear in that provision, right? There's
sameness requirement.
Not for bioequivalence, Your Honor. They have to be bioequivalent. They don't have to be the same. That was actually
equivalent.
But that's all. But that was
equivalent. What does that mean? What does equivalent mean?
But bioequivalent means that they can have differences in the formulation of the product.
The same?
Sure, but I'm not saying there's not the same in the sense of the effect of the drug has to be the same. They have to be bioequivalent, I guess, to use the exact language. My point was that same is not being used there. Our understanding is that same means same. It has to be the same active ingredient. Identical. It has to be the same. The sameness requirement means identical. And if you have exceptions to that, the way that the exceptions work is they fit into the different manufacturer exception.
Their view that there are some stylistic exceptions to sameness. He's not saying identical. So I'm just trying to, so the difference is they say identical or same doesn't mean identical. It has some breathing room, but it's very small and it's for, I think when he sees de minimis, I think he would say maybe wholly unrelated to safety. I don't mean to put words in his mouth, but wholly unrelated to safety and ethics.
Sure, but then you're just putting the same analysis into this in the sameness requirement.
It's easier to put it in the definition of sameness than it is required because.
Your Honor, if this court is going to say, look, the sameness requirement means it's pretty flexible here, and there is a certain amount of changes to stylistic choices that the generic manufacturer can make, and also the different manufacturer exception also applies.
You're not making that argument. The agency hasn't made that argument. You've flatly rejected that argument. So so all we have to do is interpret what required because you're a different manufacturer means.
The reason that my friend on the other side, I think, is making the arguments about sameness is because even they understand that there are certain kind of stylistic choices that don't have to be replicated like for like on the generic brand label. And so my point, and then as the colloquy illustrated, whether those things are really de minimis inquires any number of factual determinations about whether they affect the safety and efficacy of the drug, including like here.
That goes to the definition of same. So under your interpretation, is it correct that somebody who just changed the font on the label, now the label's not the same under your interpretation, and they do that because they just feel like it, that is required because it's a different manufacturer?
Whether it would be appropriate would be analyzed under the different manufacturer
But that is required because it's a different manufacturer.
I think that the fact that manufacturer.
Let's say they're allowed to do it.
Yes.
And the rationale of the agency would be like, you can do it because this change of font is required because you're a different manufacturer.
I think it would fall under the different manufacturer exception.
So, but that would be the reasoning.
It would be because it would be.
Changing this from bold to italic is required because you're a different manufacturer.
I think it'd be suitable because there's a new manufacturer. I think that's the best way to read that provision.
Okay. But it's not, the text doesn't say suitable, it says required. So isn't that absurd that that's required because you're a new manufacturer? And so it's required that you change a font from bold to italic. Isn't that absurd?
I don't think so, Your Honor. Again, I will.
How is that not absurd?
I'll give another pitch. Maybe it's not working, but let's try it again. I think the way to think about this is that, particularly for labeling change features, right, which is what we're talking about here, there are things that have to be required. So if you look at 201.5, 14 CFR 201.56, 14 CFR 201.57, 14 CFR 101.200, there are any number of things that have to be included on a brand name drugs label for it to be approved. But that is not exclusive. There are also things that manufacturer can make, design choices that manufacturer can make about its label, and FDA can make the determination if this doesn't have any concerns about safety and efficacy, we will approve that brand name label. When a new manufacturer comes, the new manufacturer can make certain choices about those same design features, right? Because the presence of the new manufacturer means that manufacturer can then make certain design choices. They are limited.
But how's that required?
We think it would be, those changes are the ones that would be suitable because they do not affect the safety and efficacy of the drug.
But what's the answer to Judge Penn's?
How's that required?
I think they are suitable because.
You want to read required for safety and efficacy.
I think that to understand why a labeling change, or frankly, any kind of change, would be appropriate underneath the statute when there's a new manufacturer, it will be because any changes that are being made are not changes that affect the safety and efficacy of the drug.
So not required for safety and efficacy.
Sorry,
Then we wouldn't even need a because clause, would we?
No, I mean, I think the changes would be changes that would be appropriate or suitable because there's a new manufacturer. And the reason that they would be appropriate or suitable is because the changes do not affect the safety or efficacy of the drug. Just like a different.
Why would Congress write a statute like that?
I think the reason that Congress would write a statute is has very much concerns about the reason that.
Generics out fast. So it says identical label, but of course you can't not, sorry about this. You have to put the manufacturer's name on there. You have to put the dosage.
I think there's real concerns about, a brand name manufacturer leveraging the same labeling requirement to make labeling determinations.
But that was a decision Congress made. Congress said the same label as FDA has approved. Congress knew all that because the drug industry was before Congress and made its views well known. There were hearings, there were all kinds of objections. And Congress nevertheless chose that language and the president signed the bill.
But FDA, even this court has recognized in the BMS case that the purpose of the statute is to facilitate the introduction of generic drugs as efficiently as possible while ensuring that those drugs are safe and effective.
And so the concern required as determined by FDA for the efficacy and safety of the drug?
I think the
No, a yes or no first, and then you can explain.
I don't think it's quite right now how I would describe it. I think the way to,
How would you
I
describe?
think the way to think about it is when there are labeling changes that are being made by a generic manufacturer, changes that are made because there is a new manufacturer are required or suitable when those changes are
No
permitted by the
suitable in the
statute.
Statute. All right, there's a because, and there's no qualification to the because. I mean, sometimes Congress writes clearly.
We don't think they wrote so clearly here.
Well, there is a way to say it wrote very clearly. And so if you have a different manufacturer, you have to change the name. If there are royalty issues, you have to change the name.
But Your Honor,
Why is your reading so much better as the better reading
yes.
of the language that Congress wrote when it used fairly clear, unencumbered terms?
I think the concern is a situation in which you have a brand name manufacturer who is included, for example, on its drug label that the drug is halal or kosher. And then the generic manufacturer is then required to copy that, even though even when the drug is exactly the same. The idea is that the generic manufacturer shouldn't have to be jumping through these hoops to ensure that its label is exactly the same when the halal or kosher determination was entirely voluntary, which the chain here.
You approved it. One way FDA could
But Your Honor,
prevent that problem is not approving labels
Your Honor,
that have kosher, that have whatever it is.
and this is the same question that Judge Panjas was. I think that misunderstands FDA's role in approving brand name drug labeling. FDA determination is this brand label to suppose safety and efficacy concerns? The answer to that is no. And there's certain information that FDA requires to be on prescription drugs. I just cited several provisions. But when a brand name drug includes voluntarily, which was the case here, no one doubts that there's not a Braille requirement. Vanda just wanted to do this.
Right, but FDA approved it and for a safety related reason.
That's not true, Your Honor.
It's in the record. Safety is what FDA said.
No, the concern was, does adding information to this raise safety concerns? It did a comprehension study because it said, look, you're voluntarily including this new information. We have to make a risk-based assessment to determine whether it would add any safety concerns. And it deemed the resulting after the study was, quote, acceptable.
I know, but FDA knew because the language was there that if you approve the label, and the generic was going to have the same label, except, the manufacturer's name.
I think there's real concern. There'd be real knock-on effects, Your Honor, if the idea was that that FDA had to go around and try to police labeling.
Not go around. They're coming to you. They can't do anything until you approve it. You don't have to go anywhere.
The nature, and my friend on the other side will agree with this, the nature of approval of brand name drug labeling is that brand name drugs have considerable discretion in the things that they include above and beyond the required information.
The point is, Congress passes a statute. We want these generics out fast. And FDA loads up the label for the Pioneer with all this stuff. And of course, that's going to make it more difficult for the generics because it's going to cost them more money
But it's not
to do all this other stuff.
It's exactly
So,
right.
All I'm getting is, this is not in my view, and I may be wrong, but it's not a view where FDA wasn't on full notice of what Congress meant when it said the same label except. All right. And the notion that it meant anything more than identifying who the manufacturer is, it seems to me is a stretch. And I don't see it saying, unless FDA doesn't think this is suitable
I think
or necessary. That's not what it
the
said.
consequence of the decision, the consequence of reading the different manufacturer exception as narrowly as the other side does, would be that a brand name drug can come to FDA and say, let's include all this extraneous information. FDA can say, look, I don't think any of this is important to the safety and efficacy of the drug, but because at the end of the day, the brand name manufacturer is the one who bears the burden of the label, we're going to approve it because we think it's permissible.
Have to, you can say we're not going to approve all that because then every
Can
generic
you?
drug has to have.
There are severe, I think there are legitimate limits on FDA's ability to disapprove a label when there's otherwise true information on the label, but is just not necessary to the drug's safety and efficacy. I mean,
You can't reject, I mean,
You
assuming
cannot reject it?
let me just be clear about what my question is.
Yes.
Because this has been interesting for me. And that is, so when the name brand comes in, your question is, does it have the 45 things we
Exactly.
require and the fonts and bolds that we require?
precisely.
And if it does, then with respect to decorations, extra words, trademarks, these types of things, all you ask is, does the presence of that additional not FDA required information impede safety and efficacy by, obscuring the label, confusing the consumer? Is that,
Yeah, I mean-
and if it doesn't do those things, you have to let it go?
I think the way to think about it is, yes, and with additional things, right? Is this misbranded in some way? Is this
we're not
like
talking
untruthful
about
or
misbranding.
misleading?
Wait, I think I might be, so, or in part, I'm trying to understand
Right.
the baseline process. They have to check the boxes and then they have to not do anything more to the label that would make the label no longer
I don't want to.
accurate, safe, effective in communicating what needs to be, what you require to be communicated.
Yeah, I mean, I don't want to stand at the podium and say this is forever and all time, all the ways in which FDA can do this, but I think there are limits on FDA's ability to tell brand name drugs you can't include with otherwise truthful information that, doesn't have a negative effect on the safety and efficacy, like Braille, right? That's exactly what happened here. Vanda voluntarily came.
What?
So
That
Vanda,
You cannot do that? Is that-
There is
you have no
limits.
authority to do that?
there are limits on FDA's authority.
And you find those limits where?
I think the grounds for disapproving a label are that they are misleading or they do not have, they're not meeting the safety and efficacy requirements
So
for a
if it
drug.
doesn't fall within those statements, those words used in the regulation, you can't do it.
I think there's
Clear.
a limit or concern about FDA's authority to do so. I mean,
Limit or concern, is the concern a legal one?
Yes.
Or a practical one?
no, a legal concern, you're right. I mean, a legal concern about whether saying you cannot include this information would be something that would be challengeable by the brand name manufacturer. I mean, again, this is why.
What does the statute say the tests are for saying you've ticked all of our boxes, you got all the right fonts and all these things that we've required, all of those are done, but you've added this extra thing. Hello.
I don't have the statutory language in front of me for the grounds for
Statutory language is
for-
with that?
I think the concern is there are grounds for disapproving a new drug application.
Mhm.
For example, the drug is misbranded. It is it doesn't meet the requirements for having safety and efficacy. I think the concern is there may not be clear statutory grounds to deny something just because it wanted to include Braille.
If they put, instead of what they did here, they had put in Braille, they had everything Roman print, is that what we call it?
Roman script, I think.
Roman script. And then in Braille, they put these words down below everything, not obscuring anything. And it said, Vanda is the best. Just in Braille. Now,
Or are drugs the best, maybe?
well, ours not going to help because the generic, then the person will think I want them to have to put on all the generic labels that Vanda is the best.
Well, and the only reason I'm resistant to hypo is just because I imagine one of the answers they're going to give would be that they can't use Vanda on the generic drugs, just like they can't. Teva couldn't have Vanda on Teva's drug label. You have to obviously change that.
Okay,
But
generic's bad.
yeah,
They couldn't say just as good as Vanda's.
yeah, generic's bad, maybe.
But they put, would you be able to reject generic's bad?
I'm not sure. I'm not sure definitely for the hypothetical, but I think that that is the type of concern that FDA has, is that you have information that is extraneous or not necessary. And I think the easiest example is something like, you can imagine brand name says we're going to have like an incredibly complex hologram on our label, right? Because we just think that would be, we think that's great. We think that's part of what like would, I don't know, it helps our marketing, whatever it may be, right? And then you're going to force, it doesn't have any safety and efficacy.
It takes you to Vanda's website.
Yeah, again, I'm resistant of any hypotheticals that are going to take you to,
It doesn't say Vanda on there.
oh, then potentially.
The QR code you'll be phone is going to
And-
take you to Vanda's website.
Exactly.
Or Vanda
FDA.
will say Vanda is best. I shouldn't say Vanda. They're not doing this.
I know.
Company X says,
Yes.
Company X is best.
And QR codes are another example, right? Yes, QR codes have been included on brand name drug labels. They are not deemed to be necessary to the safety and efficacy of the drug, but also not raising concerns. And it's another example where FDA has said to a generic manufacturer, you do not have to replicate that information on.
So why isn't a better reading of the statute to say, to address these concerns you have, that all goes to sameness? And if there are de minimis differences between your label and their label, it's still the same for our legal purposes. And then reserving the second part, which is the exception for different manufacturers for things that are necessary for different manufacturers, like you've manufactured this differently. Why isn't that just a better reading? It feels very difficult to get to your reading. And so why don't we just adopt the easier reading?
I understand, Your Honor, and I understand that this is maybe, I understand. This is FDA has long been understood that the changes that may exist between labels are best understood through the different manufacturer exception. I understand the question is, well, maybe that actually there's some kind of sameness is doing some of the work here.
It's a statutory interpretation now.
Totally understand. But I think there are a range of different changes that are made through different manufacturer exception. I keep going back to Zeneca, though that doesn't seem to be getting much purchase, but just that
They're all manufacturing things. So that's a
but just that there are different choices that are made by generic manufacturers. And the way in which FDA has understood them is that when generic manufacturer making choices about their drug or their product manufacturing or their label, then you understand it through the different manufacturer exception.
It's just, there's no limits to that. That's textually based. It's basically anything they want to do that they think is suitable, they can do. And there's no textual restraint on it, but then you import an atextual unless it relates to safety. It's just really hard to reconcile it with the statute.
I don't think that's exactly right. I mean,
Like, tell me where in the statute there are limits to what you just said.
well, so
That anytime a different manufacturer wants to make any change they want that they think is suitable, they can do so, except when?
no, except
That's the limit.
that there is any amount of information. I think the safety and efficacy requirement is a real limit. I mean, again,
Where in the statute is that, though?
so a few things.
Where in this statutory provision?
I agree. It doesn't, I'm not disagreeing that the provision doesn't say safety and efficacy.
Right. So that's why it's so difficult to find any limit to your interpretation.
But my point is that the limit comes from the fact that the information that has to be required on a drug label to ensure that the drug is safe and effective is robust. And for prescription drugs like these, it is set out extensively in FDA regulations.
No, but we're just interpreting this one provision and your interpretation doesn't really work. And I do wonder too, why FDA wants what you're proposing, because it seems to me that the easier way to do this, and apropos to what Judge Rogers was saying, is we want generic approvals to be streamlined, is that it's the same. And the only way it's not allowed to be the same is we look to this one thing, which is easy to determine, and that's it. But what you're suggesting is every time there's a change to the label, the FDA has to do some kind of new assessment about whether it goes to safety and efficacy. And I would think that that is contrary to the whole point of having a more streamlined process for generics.
No, I mean, whenever a generic submits an application and it has any differences in its labeling, it has to identify all those differences. So, I mean, part of the analysis is that.
Correct. But then either the agency just has to say, this is required because they're different manufacturers, or not. And if it's not, you don't get to do it. But under your reading, every single change, the agency has to determine whether it goes to safety and efficacy.
Understand.
That does not seem like what you should want to be doing.
I understand that's superficially appealing, but it doesn't. You just import the same problem into the sameness requirement. I mean, again, to go back to the example.
You have to decide whether every label is permissible under the FDA. And so everyone has to be, it can't interfere with safety and effectiveness.
Sure. And
No label goes out generic or otherwise if
if it's,
the FDA deciding that this does not impair safety and effectiveness.
yeah, and
It has required things and it doesn't.
sure. And my point was just that you import the same problem into the sameness
No, but it's
analysis.
presumed safe because the Pioneer drug label was approved by FDA and it's safe. So if it's the same, it's safe. There's a presumption of safety if it's the same.
My point was though, what I'm fighting right now, Your Honor, is that under the, sure, if you mean same means same, but the other side has said, actually same doesn't mean same. It doesn't mean identical. Same encompasses any number of kind of diminished exceptions that they think are actually fine because they can't really. And so then you say, well,
But
like,
their diminished ones don't go to safety and efficacy.
my point is that then you'd have to make that determination, right? Judge Millett gave the example of a change in font that actually might very well affect the safety and efficacy of the drug because it may be for a drug product that's for individuals who are dyslexic. And so now if you're saying, well, like, is that sufficiently affecting the sameness, affecting the safety and efficacy of the drug to be same anymore? You're just doing the same analysis in a different statutory provision. Right? Like that is frankly the exact same analysis that FDA did here. Is this something that can be changed? Is this something that was required for approval in the first instance? No, it wasn't a condition of approval. It was entirely voluntary on Vanda's
So
part.
why didn't they say this is the same? It's the same. It's just a different label. It's Braille. I mean, I think that there are problems with that, but hypothetically, if they wanted to go that route, why wouldn't they take that route, which is easier as a statutory interpretation
You know,
matter?
if this court wants to affirm on that's how it understands the statute, perhaps, but I'm saying our FDA's understanding is that the analysis is properly done through the different manufacturer exception because determining whether something is as safe and effective on a different whether a change is appropriate because it doesn't affect the safety and efficacy of the drug is properly done under the different manufacturer exception. And my response was just that if you are going to say, well, actually sameness does that work, you import the same problem into the sameness analysis.
Not the same textual problem.
I-
Can I ask you just two things? So you in your brief, I think interveners as well, talk about trade dress and things like that. Are
Mhm.
there any cases that have said trade dress falls within the required exception? Manufacturer required because of manufacturer exception?
I'm not aware of a case.
There's
John.
been no litigation over that.
I'm not aware of any.
The only litigation over this exception has involved, at least the ones that we've seen, are things that involve changes in the manufacturing process itself.
With the caveat that there are also the different manufacturers exception also encompass changes due to intellectual property change, like patent protections. So Novartis and BMS were other decisions like that.
And then on the fact that you now have a generic, what they want is for the generic to put the active ingredient
Mhm.
in Braille, even though the active ingredient on their label is not in Braille.
You're right. Sorry.
Wait, no, it's,
I think
the
it-
problem is that are they asking for different labels rather than the same label?
I mean-
I'm trying to figure out how to think about that because it feels very different to me.
FDA approved MSN because under applying the same reasoning as it approved here, whether to include Braille or not was a discretionary choice that Vanda made. And so the generic manufacturer is allowed to make a decision about whether to include that on its generic label. But I think that the question that you raised points to the fact that if you just think if the carve-outs are going to be in the sameness problem, then you have this exact issue, right? Because those aren't the same, obviously. And so now you have to also define not only are these things identical, but also what is the quality of sameness that we are evaluating? Is it just having Braille? Is it having the exact same information in Braille? I mean, I think the better way to understand the statute is to channel that inquiry into the different manufacturer exceptions.
We're saying is what's required because it's a different manufacturer. It's required that you can't say Hetlios because you're a different manufacturer.
Sure, we agree with that, right? But if those aren't also the same, right? Like the reason why, those also aren't the same, right?
The answer here would be you don't want the same
That's
label.
right.
They don't have to be the same if it's required because they're different
Yeah, but there's nothing that
manufacturers. And why
requires-
isn't this required? Because they can't say Hetlios.
Sure, I think that's right. Sorry, maybe misunderstood the question
You
originally.
can't say Helios, but they don't have to say in Braille an active ingredient. that isn't in Braille even on the original label. They could just have the active ingredient listed up there. That's what generics are, is just the active ingredient. They're generics. They're not name
Sure.
brands. So that's what they have up there, but it's not their name. It's not Teva's name for this drug. It's the generic active ingredient is what it is. And that's how they label it because they're generics, but it's not, the name of how you identify the manufacturer is Teva, Vanda.
Yes, Your Honor, that is, I'm not sure the question.
That's your argument.
No, what I'm trying to
I mean, no, because no one's challenging
that
that.
just feels like an argument that the rationale would be, well, you don't want the same label. You actually want us to take something that is not in Braille on your label and require it to be in Braille on other people's labels. And if you think it's all promoting safety, then you've got a PLEVA problem. If you don't think it promotes safety, then you're just asking for a different label, not the same label. Because I get that you have to take Helios off. I can't keep saying it right.
Helios.
Off.
Yes.
But that doesn't mean, of course, it does not mean for a generic that you have to now have your own generic name up there. You just have to take out the name brand and have everything else that we require you to have. And anything, the 20 M, let's say the 20 mg, maybe whether you have to decide whether that has to be in Braille, but it doesn't seem like they're asking for the same label. And they're asking for a change that isn't, from their point, that is not made on theirs and has nothing, and it's not subbing in an equivalent thing, right? If they wanted Teva in Braille, that might be closer to equivalent, but subbing in, you've got to put in Braille, the active ingredient doesn't feel like a fair substitute at all. It doesn't feel like same or anything.
Well, why isn't it that?
Can I just?
No, I mean, I'm not sure how to answer the question, but here's why. In our view, we agree that the generic manufacturer that does include Braille, so MSN in this case, or any other generic manufacturer, could not include Helios. We think that it was an appropriate labeling feature to include that the generic had some amount of discretion to understand how to make that change, and including the active ingredient was an appropriate way to kind of change from Helios. That was FDA's understanding of the best way to accommodate the fact that Helios could not be included.
Required,
Well,
because it would be misleading.
we don't think you had to include Braille at all.
No. I thought you said we were talking about not including Helios. I didn't think you were talking about Braille yet.
No, I mean,
First saying you put the active ingredient on the label.
I took the question to be about Braille, but maybe I misunderstood it.
All right.
Well, so I was combining the two things. So Helios has to come off,
Always does.
has to come off. Vanda has to come off.
We think that's an appropriate application of the different manufacturers.
Vanda has to come off on the generics.
Yes, I think,
Right.
I agree.
Helios and Vanda have to come off. Those are required to come off. And so those come off. But what their argument is, wow, well, let's have something else in Braille instead. And they want to put that under the same labeling requirement. And I guess.
Vanda, sorry, just make sure.
Sorry,
Vanda says that you have to then include the brand name drug on the active ingredient on the generic
In
drug.
lieu of, since
Yes,
you
sorry.
don't have a name brand, you're a generic.
Yes, sorry.
You have to put this other thing.
Yes.
That we have on our label, but haven't put in Braille. We have to put that in Braille. You have to put that in Braille. You generic have to put it in Braille, even though we did not, because you got to have something in Braille that sort of parallels what we had in Braille, as in the big word
Yeah.
on your label. And
Okay.
that, I don't understand why that's just not even
An option.
sameness. I mean, why that doesn't fail at step one,
That's a threshold.
sameness. You're not asking for the same thing.
I
Lose on that.
So
And then this case would be about 20 mg being in Braille.
they very may well lose on that, I guess.
So
I
why
mean, does that, you seem to want to shove that into your different manufacturer thing. And that one seems like you can take any definition you want of same, and those are not equivalent substitutions.
The way I would understand it, and just like, for example, the way I think FDA understood when it was approving MSN's label was that Braille is not required at all, obviously. And that if you're going to include Braille, then there's some amount of leeway that the generic manufacturer has as to how to reflect the Braille on its label.
Put everything under the manufacturer exception. And what we're trying to get you to focus on is something else.
I understand.
Right? Because you keep using the word appropriate. And we want to know, is it the same or is it required? And so that's why we keep pestering you with questions.
I'm aware.
So why isn't it the case that I'm just trying to apply the language of the statute. These are different, okay? Because the Pioneer label has Braille, it says Hetlios 20 milligrams in Braille, and the generic has no Braille. Now, applying the statute, it has to be the same except for changes that are required. You have to take off Hetlios. That's required. It's a different manufacturer. But you don't have to take off the Braille because MSN shows that you can have your identifying information in Braille. But you do have to take off Hetlios. And what you put in its place, they happen to choose Tazimelteon, whatever it is, it's whatever identifies the drug. But it has to be in Braille because as a manufacturer, that doesn't require you to remove the Braille.
I just think, I think the problem with that is it raises the move. I understand the statutory move is to move everything to sameness. And the problem is
Everything, just not my interpretation. What I said to you.
I think so.
Should I say it again?
No, maybe just let me try to answer it, which is that the argument is that the sameness is as to Braille, right? That like that's what has to be the same.
Yes.
Under the view, even though everyone agrees that Hetlios and talisman are not the actual active ingredient are not the same, right? And so our view would be that raises hard questions about whether those are actually the same or not. And the better way to
Whether Braille is the same raises a hard question.
whether the
Having
relevant
Braille in each label.
yeah whether the relevant
Make it the same.
whether the relevant inquiry is the Braille-ness, sameness, right? Or just the information itself. I mean, as the district will point out, this is just repeating information that's already on the thing.
Says Congress.
But it's modified by required because you're a different manufacturer and the Braille-ness doesn't depend on which manufacturer it is.
Right.
But Hetlios does, like using the word Hetlios does. So that you have to change Hetlios, but you don't change the Braille-ness, the fact that it's in Braille.
You have to
Because as
change
a
it.
new manufacturer, it has to be the same. There has to be.
I mean, we earlier, we were just saying that Braille is effectively just a stylistic choice like a font. And everyone agrees that you could change the stylistic font, right? And that would still be the same.
If Braille were just a stylistic choice like a font, why was there a back and forth between the agency and Vanda when they wanted to include Braille with discussion about safety?
To make sure that it didn't pose a risk. It was a risk assessment to make sure there wasn't.
It enhanced safety. And I read the quote before, but I'll try to find it again. FDA inquired, have you considered other important information such as the established name or usual dosage should also appear in Braille on the container to promote the safe use of the product? It was an affirmative safety thing.
No, that was
That
the
wasn't a
question.
finding, that
It
was a
wasn't the
question.
answer.
It was a question, but I'm just saying that safety was an issue.
But they no finding.
FDA was absolutely clear, and I'll point to 922 of the JA in its denial of the citizen's petition, that it never thought that Braille was in any way necessary to the drug
Not
safety and effective
necessary,
use.
but it promoted it.
I don't think that's right, Your
They
Honor. I
were
mean,
considering whether it would promote safety.
and for good reason. I mean, more than 90% of people who are visually impaired do not read Braille, right? And Braille is never required on any drug, right?
But when they did their study, it helped people identify the drug because other drugs don't have Braille. So they can tell, even the ones who don't read Braille could tell that this was.
The purpose of that assessment was to determine is this a risk, a safety risk, and to determine there is not a safety risk, which is, I think, brought to the broader point. The way in which FDA does its brand name drug approval is to say, there is certain information that has to be on there because it's required for a drug to be safe and effective. Dosage form, safety warnings, strength, so on and so forth. Those are all set out in extensive regulations, including the format of that information. But then when you elect to include voluntary information.
But to get back to this particular voluntary information, there was an approval process. You approved it and there was a safety discussion, even if it wasn't like a finding that it was necessary for safety. And so this is not like changing the font. This is a substantive thing.
Not in FDA's view, Your Honor. It's not viewed as a substantive thing.
Do you think it is just like
style
changing a
thing.
font?
I think Your Honor, it is a.
About Congress's view.
I I think that
Why did it
Hang on,
use
let him
the
just,
word?
how about he just finishes his answer?
Yes.
And it's my fault mostly. I'm letting him. answer this question.
FDA's view is this was not necessary in any way to the safe and effective use of the drug. As the district court recognized, it's just a volunteer way of including some information that on its own is not at all necessary, is not alone sufficient to ensure the drug is used safely and effectively. And so I think this is very much like a highlight of information. It's very much like certain font choices that you might make to present information. And I mean, and that has been, I think the principal point is that all of that analysis we think is best done in the different manufacturer exception. But to the extent that you think, well, those changes are permissible because they are not the same, I think you import the same problems into the sameness analysis because you have to make a determination, is this like
I think you
font?
could ask a 5-year-old whether a label, you hold up a piece of paper and it says Helios in big font letters. Then you have another one that says, Teramental.
I also mispronounce it all the time.
Active ingredient.
Yeah, active ingredient. That's why I use active
Every
ingredient.
letter and say, are these the same? I gotta think 100 out of 100 are gonna say no.
I guess the point, Your Honor, is if the court is going to say that you can make changes, that the generic manufacturer can always make changes to its kind of elective stylistic choices that the brand name manufacturer has made, then I think this is very much like that. I think that's
Not even there. I'm just.
I know.
I'm just saying, it's one thing to say you have to take Helios off. That's required because you're a new manufacturer. It's an entirely different thing to say, this thing that we have little print on our label, now you have to make it big, or you have to make it Braille, or you have to make it italics. Suddenly makes it the same as that one that had the big Heliox label. They're just not. They're different words. They're different words that perform entirely different functions under the statutory scheme, communicate entirely different information. That doesn't seem to me a difficult question. You want to change this to font. I'm just saying they want a completely different word. One's an active ingredient, one's a name brand, totally different things for health reasons. They want that. That seems to me not a difficult, that's not the same answer. And you don't have to go running around looking for an exception. They're talking about required because they're a manufacturer, right? Then you can grapple with the 20 mg issue. But it just, I mean,
I agree those aren't.
Besides safety and efficacy, fonts and other things, it's not even the same word.
Your Honor,
It's I assume a copyrighted word.
I'm not trying to resist this. I agree that those are not the same word. I agree that they're not the same word. I agree that they're
Not
not.
a name they can lawfully use, not just for FDA reasons, but for intellectual property reasons.
Yes, I agree. I'm not fighting that at all, even despite my.
I know, but I want to say it'll be so hard to do it under shame. Some things may be, but I mean,
I think that's my point, is actually just, and I apologize for not answering the question really. Yes, those are not the same. I think the next point I was trying to make was that I think the sameness requirement, we understand, the FDA understands same to mean same, identical, and it understands that there are permissible changes. Everyone agrees there are permissible changes. I think the question is, how do you understand those permissible changes to fit within the statutory scheme? And my point was just simply that there might be very hard questions if the analysis is that all those fit into the sameness element. That was my point.
Thank you.
more questions?
If there's nothing else.
Sorry, we are well into lunchtime. I'm sure you're all getting hangry with us, but we have to give Teva a chance here. We should provide snacks.
Thank you, Your Honor. Good afternoon. I was wishing I had a bigger breakfast. I know we've been here for a while, so I'll try not
I'm sorry. It's just really hard. It's a really hard case.
No, absolutely. So I'll try not to be repetitive, but it is an important case to Teva and the generics industry. So there are some points I wanted to hit. First, on the statutory question and required, Judge Millett, and I believe Judge Pan asked a few times for a case. I have one. It's one we didn't cite in the briefs, but I do think it endorses our understanding of required because to be consistent with appropriate. It's a Supreme Court case, National Railroad Passenger Corp. versus Boston and Marine Corp. 503 US 407, 1992. In candor, it's
Is there a pin site?
I don't have a pin site,
Okay.
but I think it's the holding of the case as to whether
503 US 407.
whether the International Commerce Commission reasonably interpreted the provision that had required to mean appropriate. In candor, it was a Chevron case, from an earlier time, but I think the same analysis that we're, but from that time, no, absolutely. But it's the same analysis that we are engaging in the FDA is that there are a range of potential meanings for required because maybe you think the more natural one is necessitated by is more of a strict logical requirement, but in certain contexts, it can be consistent with appropriate for the circumstances. The court.
And appropriate for the circumstances here would be safe and effective?
I think the way I.
Effective or not impairing?
No, I think the way I look at it here in terms of like what a limiting principle is, or I don't know that it needs to resolve every case for all time, but as Judge Chutkan noted, in our opinion, this is a very narrow issue because we're dealing with a formatting distinction rather than a content one.
But it isn't a narrow issue. We wouldn't be spending that much time.
It's an interesting statutory puzzle. I agree with that, but my point is that the distinction between format and content, I think, does a fair amount of work, and that the court, as a general matter, can understand that it is appropriate for manufacturers to have discretion about marketing decisions about formatting. That those kinds of decisions and deviations are in no way conflict with the general structure of Hatch-Waxman and what Congress intended, which was that, as Judge Rogers was noting, ANDA's piggyback on the previous brand approval.
It's going to take us 12 years to get an answer.
Well,
and Teva is on the market.
That's right.
All right. So you don't care. All right. But for the normal case that we see, the generic is not on the market. All right. So they're very interested in time and getting their application through and their drug out there. All right. So when Congress says same, why don't we just say same? All right. And move on. All right. As opposed to spending all this time trying to figure out, either we figure out, or as Judge Pan says, she did say it, which is in her question, we send it back and let the agency figure this out and give us some more findings of fact, and then it can come back up here. We can go back and forth for generations. So Hatch-Waxman was trying to cut through all this. So same means same. But obviously, you're not going to put misrepresentations on the generics label. So you're going to take those changes out. All right.
Sure.
And, what's the limit? And now we hear from Vanda that, well, it's a pretty wishy-washy term. All right. Because you can do de minimis and there's some other things. And once we go down that road, I don't know where we stop. And I think that's what our questions have been trying to elucidate for us.
Sure.
From lawyers who are, I'll just say for myself, more familiar with this field, not only in terms of appellate law, but at the agency, during, with the agency proceedings as well.
Sure. A couple responses to that. I mean, streamlining the process is very important to Teva as well. It's the biggest generic manufacturer in the world. I don't think if you took the idea that it means identical sameness, which I think I understand your Honor's question to be postulating.
Except where it would be obviously misleading.
Right. Except where it would be obviously misleading. I don't think that's workable. And I think Vanda agrees it's not workable. At a minimum, you have the trade dress
problem. Or there's a trademark.
Well, that's a big but, because I don't understand how the FDA is in a position to differentiate when a change is required because of trade dress protection versus it's an optional formatting decision. When you say
trade dress, what do you mean?
I mean something that would be protectable as intellectual property.
I was using it in the same way, but I wanted to be sure.
Yeah, no, that's right. And I understood, Mr. Hughes.
That's more difficult. I totally agree. But in our case, it's simple.
I don't think that's right because again,
you're not, you don't have the same brand name, your drug, you haven't given the same brand name. And the active ingredient is what you have to make clear to the public that, this is just as good as Vanda's Helios because it has the same active ingredient.
It has the same active ingredient and it has our label has all the same content. It has all the
That's
same
right.
efficacy. But
So what we're down to is putting Braille on your label is going to cost your client more money.
yes, that's right.
And so it'll cut into the generics profits.
It will cut into the
And
generic
so
profits.
instead of having an 80% profit, it'll have a 78% profit.
Generic profits do not look anything like that.
I'm just-
But I think it's a relevant difference because brands do have a different interest in developing marketing features and
Right.
trying to grow the market. Vanda, before there was generic entry, was charging $25,000 a month for a 30 pill. The point of generics and the point of Hatch-Waxman is to accelerate generic entry and for generics to do it as cheaply as they can. So Vanda, if it wants an optional feature that it thinks is going to be helpful, or as the medical officer in this case indicated, it might have some reputational benefit for Vanda. We don't think they're precluded from doing that. But the question is whether generics have to adopt those optional formatting features under a duty of sameness.
So can I ask you,
Yes.
does the
They're
position
not,
depend
can I
on it
just be
being?
clear though on your question? You're
Yeah.
focusing on required, right? Not required.
We don't, I'm sorry, I'm not sure I understand your question.
I just wanted to be clear before Judge Pan.
Sure.
Question, but maybe you want to go ahead.
Well, I guess all I was saying is that by hypothesis, when we're dealing with the statutory question as opposed to the arbitrary capricious issue, we have a labeling feature that the agency has determined is not necessary for safety. And so the question is, and it's about format rather than the actual content that is being conveyed. So
That was my question.
okay.
Does your argument depend on it being a formatting issue? Because I see that even if it's not necessary for safety, it can also be substantive. And I think I see it as
Yeah.
not just a binary thing. Either it's necessary for safety or it's like font. That there could be something in the middle, something substantive that they've included. And I feel like this is more substantive because they went through a whole approval process, et cetera. Does your position depend on it being just a formatting thing?
I think the fact that it's formatting is an important distinction, and it's one the district court relied on heavily. I don't agree with the premise that because it went through an approval process and the agency engaged in it, that means it's more substantive. Or the agency does that with all sorts of formatting features of a label, makes a determination that the label as a whole, whether it's the form, whether it's the font, whether it's the color, whether it's the layout, is not going to be misleading. So I don't think that distinguishes Braille. And just a small factual point, but Your Honor was noting the commentary and the back and forth with Vanda, regarding whether this had safety benefits. The agency was exploring that. I believe those statements to Vanda were made before the labeling study that it conducted. So I don't think it's correct to read the record as a whole as suggesting that the agency concluded there is an affirmative safety benefit from the inclusion of Braille. And I think the study itself is revealing both the fact that Vanda missed its lower bound. I'd invite the court to look at 1034 through 1036 of the joint appendix to see some of the commentary from actual participants in the study, many of whom, both Braille readers and non-Braille readers, found Vanda's label confusing, including the non-Braille readers. I wouldn't know what to do with this. Braille readers thought it wasn't very clear or effective. So I just don't think that is the predicate that the agency was relying on, that it made any type of finding in that regard. But I do think, so if we're bracketing the safety issue, which is dealt with through an arbitrary capricious challenge, we think obviously the agency gets more deference there and that it was well supported its decision in the citizen petition. We're dealing with something that is purely voluntary, that is not necessary to safety, the agency determined, is not going to the content of the label. It's not.
Is there any finding that it promotes safety?
No, that's the point. I don't think there is any such finding. And Mr. Hughes was using the Pleva Bensing example. I think that's just fundamentally different because the issue there is that if you're adding warnings about the way this drug works, it creates the impression that these are not therapeutically equivalent, which completely.
Oh, Pleva, but Pleva's about, and this is why I was confused about how these cases are applying here, because Pleva's essentially that generic, you don't get to change the label in ways that are going to make it more safe than essentially the name brand.
That's right. But again, it was about the
Right. But it seems to me there's an argument that requiring the active ingredient to be in a particular, presented a particular way that's different from the way it's in a more accessible
Mhm.
or easily viewed or understandable way than it is on the name brand,
Mhm.
would be a PLEVA problem. Whatever.
I think it might be under Vanda's view of safety. If they actually think that the Braille is essential to safety and that it's adding something, I can see the issue with the MSN label and how that problem arises. But given the agency's determination that it is not essential for safety, that is, I think, effectively neutral, then I don't think it fits into the PLEVA v. Mensing issue. And again, I think the problem in PLEVA and the reason that the FDA and the court.
If it were promoting safety, it would be a PLEVA problem. If it's not promoting safety, it's a style problem. It's just a style choice.
Think it's a style choice. Whether it would necessarily be a PLEVA problem, but I do think it's a different issue. Here, the agency concluded is essentially neutral. It's like a style choice. It's the kind of thing that
But
manufacturers.
it's not a choice that's required because you're a different manufacturer.
If you disagree with me, Judge Pan, about the right meaning of required by in this context, then I do think we're reading required by to be appropriate to, consistent with, rather than being logical necessity. As government counsel, I think, was trying to illustrate, Vanda doesn't actually take its logically necessary reading consistently either. There was talk about the Zeneca case. I understand the court thinks that
But you agreed it's not required because you're a different manufacturer, because MSN was able to do it even though they're a different manufacturer.
I do not agree with that, but it's because I think I have a different understanding of what required means than the one
Required
Your Honor
means
is using.
necessary. Do you agree that it's not required?
It is not logically, it's not unavoidable.
Required
It's not,
because you're a different
it's not unavoidable if that's what the right meaning of required is. We just think that's not the right meaning.
No, I understand that.
of
But if
required.
required means necessary, then you agree
If-
that this is not required because you're a different manufacturer.
If required means inevitable, yes, I agree with that, but I don't think that that is a correct one. But I think there are structural reasons. We talked about the formulation issue. I didn't hear any discussion before of the Bristol-Myers case in which generic manufacturers make different decisions about whether to seek approval for a particular indication because they need to avoid a patent or an exclusivity. That's not something that has to do with how the drug is made. It's an optional decision. There are different ways in which the generic could just decide to get on the market rather than pursuing the carve out. So I think if you were going to follow, is it, truly non-optional? That's contrary to Bristol-Myers. And so I don't think that can be a way to read the statute, and required because needs to mean the same thing in all these different examples, and to try to create ad hoc exceptions, I don't think works. I wanted to, I guess, a few other points. On the question about, we were talking before about the importance of it being streamlined and the risk of, if these voluntary formatting features became mandatory for the generic and not the brand, that could raise costs and deter generic entry. And I think the suggestion was, well, maybe a way that the agency could deal with that is by not approving those features in the first place. I agree with what I understood to be government counsel's representation, that that's not an option that's open to the FDA. The relevant statutory provisions are shall approve unless certain conditions are not satisfied. So
What is your understanding of that regulation?
Of that
It says the label shall include 1, 2, 3, 4, 5.
Mm-hmm.
Unless, yeah.
Right, they have to include certain things. There's a general backdrop that labels can't be misbranded, so they can't be misleading, they can't compromise safety. But if you have a feature that the agency has concluded it's not necessary for safety, we're not even sure if it enhances safety, but it's something that the brand wants to do to build its brand. I mean, that's why it has the product name as the brand in the first place. It's
What's the
engaged.
statutory provision that says that?
It's engaged. 355D is the relevant provision for brand approval, and then it uses a similar shall approve language in the context of ANDAs. I think it's J4. So I don't, and there's been discussion about Because I think Vanda's position, they want to preserve most of what the agency has already been doing, but move it into a different bucket because they recognize that it would be problematic to suggest that you can't have deviations in trade dress or font or other things. We think it fits best in the different manufacturer exception rather than similar, but we do think it is very important that these voluntary formatting features not be considered something that generic manufacturers are obliged to adopt. So whichever, it's not all, we think that the agency is right. We obviously care very much about this case, but I think that's the important takeaway, that would be really detrimental to the generics industry.
I'm clear in my own mind why the agency is relying so heavily on that, but do you think that's what Congress had in mind?
I do. I think what Congress had in mind and what the structure is that ANDAs are about therapeutic equivalence and being able to piggyback on the brand, as Your Honor referenced before.
That's what we, Congress, want the agency to focus on.
That's what we want the agency
End of discussion.
Well,
and so when we write a statute, when we enact a statute that says identical, same, we don't really mean it. We mean within the discretion of the agency.
No, I mean, I think the concept of what is same is whether that's like literal identity or whether there's some room around the edges, but I don't think it was necessarily a broad.
I think our questioning has indicated some agreement, I think, about the fact that same is not identical. I mean, you have to change the brand name,
right,
et cetera. But how much further you go is the required by.
Well, sure. But I mean, I think the fact that the language is required because a different manufacturer is what's used to change the manufacturer name suggests that maybe, same does do some real work. And it's at least to me, a little bit unnatural to put in all the different trade dress protections, for example, into the sameness bucket with labels that obviously look quite different, but to say that they are the same. But nonetheless, I think, again, my point is that what is important for the generics industry and for the proper functioning of this statute is that voluntary formatting features adopted by brands that are not supported by safety considerations, not be something that a generic necessarily has to follow and adopt. I did want...
Under that interpretation, would it require the agency then to have a formal finding in the record that, for example, Braille is not necessary?
Well, I think that's present here, that they made that determination that Braille...
I didn't find it in that succinct way.
Well, I mean, it's certainly found in a succinct way in the citizen petition. If you're talking about the contemporaries.
I found it in terms of how Braille came to be. But as Judge Pan's questions have highlighted, the agency was considering safety in terms of Braille. My reading of the agency's answers is that it didn't answer that question. It turned it around, turned it inside out. It said, well, it doesn't hurt anything. Okay.
Well, I think that's right. And I think that's because that's all Vanda's study was designed to establish. Vanda was asked by the agency.
So if it doesn't hurt anything, why shouldn't the generic be required to do it?
Because it has not been demonstrated to have any safety benefit and because it's costly.
That's why I say, doesn't the agency have to make a finding? So it's clear when these things are challenged that the agency has found this is not necessary for safety and the effectiveness of the drug, that this is pure marketing, nothing more. It doesn't hurt anything, but it has nothing to do with the safety and efficacy of the drug. I mean, it would certainly make our life easier, and presumably it would speed these matters through faster for the generics.
I guess I read the records for the agency here to have made such a finding, and to the extent there's ambiguity in the original approval, they certainly made that finding in the citizen petition. And I understood my friend, Mr. Hughes, to say they were recognizing.
But is the FDA allowed to disapprove a label just because it promotes the name brand? As long as...
No, I mean, I think that's our point. Right. There would be no basis for it to do so.
I don't understand that quite, unless the answer is illegal, that it has no authority.
Well, I think
to
that,
consider that.
no, I think that's right, because the way that the statutory
Right, they have no
framework
authority,
works.
just to be clear here.
Yes, right. They have no authority to decide these are superfluous. They don't harm safety and efficacy, but we don't want the generic to have to go ahead and do the expense of doing this unnecessary things, whether it's Braille, whether it's a hologram, because the way the statute is structured is generics, as Your Honor was noting, Judge Rogers, it's supposed to be streamlined approval to get lower cost generics on the market faster. And so brands have an interest potentially in having broader marketing features. If you go to any sporting event in Washington, D.C., you'll see Vanda posters all over the place. That's not how the generic market
I noticed
operates.
that for the first time this season, and maybe it's because
That's right.
the case was
Well,
before us.
I pointed it out to my son at Capitals games a few times. But there's nothing wrong with that. Brands have they operate differently. But the notion is that generics should not be required to copy those formatting features, those things that are done from a marketing perspective. I wanted to address what I think were Judge Millett's questions about what strike me as the inconsistency in Vanda's position, that it says we're relying on sameness to force you to make a change, that you should change the active ingredient to have that in Braille. I think that underscores why their understanding is not a proper reading of the statute. And I think there's also a reason why they're not really relying on the 20 milligrams, because it would make no sense at all. This is a product that's approved in a single strength. So the notion of having Braille for the strength that is the only strength, that doesn't make a lot of sense. So they have to bend over backwards to suggest, well, you need to sort of transpose and now have the active ingredient be in Braille rather than the brand name for the product. Maybe that's a sensible policy result, and we don't disagree with the approval of MSN's label necessarily, but I don't see how that comes from a duty of sameness. And one good indication that it doesn't, and that goes to the sort of piggybacking streamline point before, is that when MSN did that, they had to go get their own certificate of translation because it's not the same word, Hetliaus and Tazimelteon. They had to make sure that the Braille looks different. They had to make sure that this Braille was going to be effective. And so it's not something that is the same.
A certificate for the 20 mg part of the.
I don't believe so. I apologize if I'm misstating, but I don't believe so. The agency did very clearly require a certificate of translation as to the active ingredient because it hadn't previously been in Braille. Active ingredient appears on both labels. It's required to be on the brand label. It's required to be on a generic label. Generics, by the way, can adopt their own brand name. It's not common, but it's something that drugs approved through the ANDA pathway are permitted to do. And so again, it's not, if the test is logical necessity that Vanda seems to presuppose, it clearly is not logically necessary that Teva or any of these other generic products have converted Tazimelteon into Braille. I wanted to make just one last comment about remedy, and then if the court has any questions. As we noted in our brief, we and the government argued below that to the extent there was a concern about the agency's decision, they thought it wasn't well supported, that we didn't think there should be vacature given the significant disruption to the market. It's been 2 years since then. The disruption would be even greater. So obviously we think the court should affirm, but to the extent the court disagrees with the agency's interpretation, including because it thinks maybe it belongs in a different textual bucket than the agency relied upon, we think that's all the stronger indication that the question of remedy should be reserved to the district court, which can decide whether the proper remedy is vacature or not. We raised that in our brief. Vanda didn't address that in its reply, so I think it's really forfeited. But in any event, we think to the extent the court identifies any issue, it should make clear that the remedy question is open to the district court on remand.
Just thinking about the vacature issue. It's the normal remedy is vacature.
It's the default remedy, but it's also something that's subject to the district court's discretion and reviewed by this court for abuse of discretion only.
It would have to be if we interpreted the statute to mean has to be required and Braille is not required because you're a different removing the Braille doesn't fit within that. then why wouldn't we vacate? Because I don't see that additional explanation.
Well, I mean, as we,
Change that.
this was briefed by us in the government in lower court, and we asked for supplemental briefing there to the extent it would become relevant. It's an easy process to make a label change. Like, there are ways to do it. We think we ought not to be required to do it. It would impose
Oh, you
costs.
mean not vacate your whole approval?
Right, that's exactly right. I mean, because again, let's be real about what was happening here. Vanda was seeking to kick us off the market. What, you know, they say it's a safety issue, but that's not, from our perspective, what this was about.
I
So
understand.
yes, so that is our submission.
Okay, thank you.
If the court has no further questions,
All right. Thank you very much, Johnson. Okay, Mr. Hughes, you can take us home now. We'll give you 5 minutes.
Thank you, Your Honor.
Agree that there'd be no purpose, this identifying thing, would there'd be no purpose to having just the 20 mg in Braille?
There'd absolutely be a purpose of having the 20 mgs because it tells you both the dose, but it also tells you this is the
Well,
product.
only one dose for this product.
But it tells you that this is the only bottle in your medicine cabinet that is going to have Braille on it. So it tells you you would have this tactile sensation. And that's why the FDA approved this, even though, as noted, not all blind people read Braille.
Oh, I mean, is that? I'm betting there's other tactile ways that those who are blind are able to differentiate objects.
This is one, and Vanda's study showed that
It's one way of tactilely distinguishing a different shaped bottle, different place, keep it on the shelf.
Yeah, the FDA said this is one way to do it. And that's why we had a study that included people who don't even read Braille. They could still be able to distinguish as a tactile feature. But I think the critical thing here is my friends can't get away from the fact that they don't want the word required to mean required. They want the word required to mean optional. It's a real statutory problem for them that they can't deal with what the word required means. There has to be something.
They deal with it. They offer a different interpretation than you do.
That would,
you don't want same, you agree same doesn't mean same.
Well, Your Honor, they deal with it by giving the antonym of required by saying it should just be read to say optional. So it should basically, the problem with that is it strips the principal rule, the sameness requirement, of any meaning. Our point is the way you understand all of this is, yeah, there are all sorts of different choices that generics can make. They can make choices about inactive products, about which indications to apply for, and those permissible choices that Congress has allowed will require labeling changes, as the court pointed out.
The case that was mentioned, Vanda, Supreme Court said, maybe they're doing things backwards. We think that as a matter of definition, interpretation in the context of this statute, it is plausible, if not preferable. So this is not just a Chevron. If not preferable, to say that Amtrak can find that an acquisition is required when it is a useful and appropriate way to accomplish its goals.
You're right, this case wasn't in their brief, so I've not read the case. I can't really reasonably respond without having read the case that they pointed us to.
That's a fair point.
And is
I just wanted to say, when you sort of say it's the opposite, which I sort of did too, and then here I have the Supreme Court saying that this is actually unaccepted in a different case.
You're right, we'd be happy to look at it, but it sounds like this was under not a Loper Bright framework.
That's why if not preferable. They didn't just say it's plausible. They said if not preferable under the statutory context. So I think that's what we have to think.
But my friends, though, they need required to mean optional, because our point is, yes, there are all sorts of changes outside. So the principal thing is the label has to be the same. And we know Congress, though, left generics to make different choices about their products. When they make one of those permissible changes, there will be times where they are required then to change their label for their label to be accurate. That's what the exception does. It does not, that exception would swallow the rule if they can simply make any change they want, so long as FDA otherwise approves it and doesn't find that change to be misleading. The exception would quite literally swallow the rule at that point. They have to be able to point to some change that they are making external to the principal rule that the label needs to be the same for the word required to do any work and not mean its antonym of optional. On the sameness point, I just want to say, if I'm wrong about the sameness point, I don't think I am. I think, as we've discussed, sameness doesn't necessarily mean photographic copy. If I'm wrong about that, though, it points the opposite direction. It just means FDA has been too flexible in allowing some of the small changes. We haven't disagreed with that. That is how FDA has approached this. But that's where I think it resides as a textual matter in the statutory text for sameness. But again, if my colleagues are correct that I'm wrong, or if I'm wrong about what same means, the result is not that you stuff it into the exception where it doesn't work textually. It means that labels should look more alike for the reasons that Judge Rogers has been suggesting, because this is what Congress wanted. Congress wanted an abbreviated process where not much has changed. FDA is not making new decisions.
But they also wanted one where the name brand couldn't adopt elements and components of the label that would make it more expensive than is required at all for safety and efficacy just to produce a label.
Well, in terms of the expense,
Or
I mean,
a special bottle shape or whatever.
I mean, it's my friend's last comment. There is kind of a what are we doing here question in terms of what we're talking about is a sticker that they could put on the bottle, and why Teva has resisted putting a sticker that another generic has, I think is.
That's going to, is it going to cost more money? Does it cost more money?
I mean, a cent a bottle, if that, to have a sticker on it.
It costs more money.
It'll be a minuscule cost, and they have not drastically reduced the price of the product at all. So I think the margin is pretty significant, but we're not talking a significant cost factor here in any way
Right,
for a
it's
clear sticker.
Cost factor, and then you could do another thing over here that, so you got to repeat this style mark we did over here. You got to have this QR code, you have this hologram, and all that stuff that makes it more expensive for them.
Well, Your Honor, what their obligation is for it to be the same, and this takes me to the next point, which is FDA absolutely polices the label. This notion that the pioneer can just stuff all these things onto the label and FDA is powerless to stop it, it is just flatly wrong.
They didn't say that at all.
Well, they've said
What they said is once you've met all the statutory criteria, and then you show us something, here it was Braille, it could be something else somewhere else. And through studies and stuff, we've determined that that addition does not detract from, doesn't violate any statute or regulation, doesn't detract from safety and efficacy. What doesn't misbrand it? What basis do they have to say, but you can't do it anyhow?
That's exactly what FDA says, and this is.
What basis? What section says they can, we just don't like flowers on labels?
So, let me give an example from this drug that we've handled, which is that the company has studies that demonstrate the efficacy of next day driving for patients who have taken this product and want to publish just.
I'm asking you a very different question. You said they have statutory authority to, if you wanted some flowers on there, and it didn't obscure anything, it didn't suggest any change in meaning, you met every label requirement that there is, and you added flowers. And they said, we think flowers are ugly and inappropriate on medicine labels. Do they have any, and let's just say that's their view, do they have any statutory authority? And if so, tell me what statutory citation.
Your Honor, this is what
to say no.
They do. They do this all the time in controlling the label. They will say.
Under what statutory provision?
I don't have the 355. I can submit a 28J letter, but they will say.
They can say keep your trademark off.
Well, and Your Honor, if you want, I promise you we will do this. We can hold this case in abeyance and we will petition the FDA to add what flowers to our label, a QR code to our label, and let's see if they approve it, because I'm sure you they won't.
In abeyance, I don't.
Well, I'm just telling you, they
forever for them to do that.
Well, they don't do it, and the proof is in the pudding here. Because what I'm saying is, with this drug, we went to them and said, we have these study results that are interesting that doctors may want to know about that show what the effects are on next day driving of patients who've taken this particular sleep drug. We want to put them on the label, and FDA said, no, you're not allowed to put them on the label. That is them very.
That's a much more complicated question where they might have questions about your studies, just as they did here. That's totally different. If you just have a design change, your design, I'm talking about initial approval, and we want to use this font, and it doesn't complicate anything, doesn't obscure anything.
But again,
they say, no, we prefer blue rather than red, and not for any ability of consumers to read the information. And your position is they get to dictate everything?
Well, the example your honor had asked is if we wanted to put on the label, generics are bad. They will tell us
No, I
we
know
can't put
they're gonna-
generics are bad.
They are. They're going to say that.
Well, I'm sure
If they
FDA is not.
wanted to say, if they, again, it sounds like you don't have the statutory side at this point. So I'm just, it seems to me that they have to approve unless the statute says you shall approve, sort of, I'm paraphrasing here, you shall approve unless.
You're right. This is how, I've done this now with this company in labeling negotiations. The agency says, we don't like all of these things. We are redlining your label.
We don't like them. I'm betting, and we just got to end this here, but I'm betting they don't say we don't like it because we don't like flowers. They say it, we don't like it because we think it's distracting. We think it covers up X, Y, or Z. We think it confuses somebody, right?
That may well be, but that goes to
That's
show.
very different. That goes to the statutory criteria. My question about flowers did not.
Your Honor, I do not think that FDA is going to allow us to put flowers on the label. But if we put flowers on the label, Congress gave an answer which says the label needs to be the same to preclude FDA from having to do downstream work to figure out if there was something about the flowers that were a good idea or not a good idea. Again, I think that's not a real hypothetical because I don't think FDA will allow it. I don't think a manufacturer is going to put it on the label. But if they did, what the statute says is we're streamlining this. We're making it real easy for generics because all they have to do is copy what the brand name did.
Right.
And again, I just don't think my friends can say what required means other than saying it's optional.
I think, do my colleagues have any more questions? All right, thank you. Everyone here a long time. We're really grateful for helping us with this challenging case, which is now submitted.
This board does have to adjourn until Monday, March 8th, by 9:30 a.m.